Very good morning and welcome to one and all. Symbiosis Law School Pune, a constituent of Symbiosis International Deemed University, is hosting a regional consultation on review of criminal law, improvement in status of women in collaboration with the National Commission for Women on their special invitation in the Western region. A very warm welcome to all the dignitaries present. This event will be the third edition in a series of 5 regional consultations on review of criminal law, improvement in the status of women, which was held previously on the 18th of January 2022 and 22nd of January 2022. The regional consultations are conducted with the object of reviewing and analyzing the position of law, which will eventually culminate into a concluding consultation on the topic of criminal law and improving the status of women. I welcome all the dignitaries who are present here today. I would like to welcome Dr. Shashikala Gurpur, Ma'am, Director, Symbiosis Law School, Pune, and Dean, Symbiosis International Deemed University. I welcome Justice Ambadas Joshi, Sir, Lokayukt, Goa. Professor Dr. KVS Sharma, Vice Chancellor, MNLU, Aurangabad. Dr. Purvi Pokhriyal, Ma'am, Dean, National Forensic Science University, Gujarat. The NCW Nodal Officer, Mr. Praveen Singh. Professor Dr. K.I. Vibhuti, Director, Amity Law School, Mumbai. Dr. Rashmi Oja, Principal, Chembur, Karnataka College of Law. Advocate Puneet Bhasin, Cyber Law and Cybercrime Experts. Mr. Pratap Sawant, Secretary of the District Legal Services Authority. We have representation from the top management by Dr. Bhama. We also have online participation of our colleagues from NLIU Bhopal, Mr. Professor Tapan Mohanty. We have representation of NGOs as well with Ms. Anuradha Sahasrabudhe from Childline. And we also have the students and other participants who are joining us, faculty members who are joining us online, as well as physically in the offline mode. A very warm welcome to one and all. We would like to begin today's regional consultation with the lighting of the lamp. So for this, I would like to request all the dignitaries to kindly proceed to the center of the room in order to light the lamp.
या कुन्देन्दु तुषारहार धवला या शुभ्रवस्त्रावृता या वीणावरदण्डमण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतशङ्करप्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा शुक्लां ब्रह्मविचारसारपरमा आद्यां जगद्व्यापिनीं वीणा पुस्तकधारिणीम् अभयदां जाड्यान्धकारापहा
because that hot water is gone.
Thank you to all the dignitaries for the lighting of the lamp. It is now my privilege to introduce Dr. Shashikala Gurpur ma'am for the welcome address and introduction to the theme of our regional consultation. Dr. Shashikala Gurpur is a director of Symbiosis Law School, Pune, Dean, Symbiosis International Deemed University, Jean Monnet Chair Professor in EU Climate Justice Law, Governance, Management and Policy, and Project Manager for the SIU in 21st Teach Skill Project, along with several other EU projects. Dr. Shashikala Gurpur is a distinguished academician and orator with more than 200 invited lectures, workshops, and seminars in prestigious universities across the globe. She has more than 26 years of teaching experience and has over 80 articles and research papers, 2 co-authored books, and 12 book chapters to her credit. She's a member of the MCCIA Corporate Legislation Committee for the years 2020 to 22. She's a member of the International Advisory Board of the Center for Common Law in Europe, UCD Sutherland School, Ireland. She's the honorary member of Association of Young International Criminal Lawyers. She is the recipient of several distinct honors, awards, and recognitions for her contribution in legal education, for gender sensitization, and community outreach programs. It is my honor, ma'am, to welcome you to address the gathering this morning.
Respected Chief Guest Justice Ambadas Joshi sir, our own Honorable Vice Chancellor of Aurangabad National Law School, Dr. Sharma sir, our dear colleagues from the field of law, veterans, in fact, like Professor Vibhute, Professor Rashmi Oza, Professor Rajeshri, among others, distinguished member and representative as the special officer, nodal officer from National Commission for Women, Mr. Praveenji, and all the distinguished scholars and leaders here, like Dr. Purvi Pokhriyal, who is in the capacity of double stakeholder, representing the parents as well as the internationally renowned National Forensic University's deanship of the law school. Our District Legal Aid Services Authority Secretary, Judge Sawant, sir, very, very valuable representation here from the community in the form of Sister Lucy, Anuradha ma'am, and all of you, my distinguished colleagues, other invitees, on and offline. I have here from the top management side, Dr. Bhama Venkatramani, who is the Dean of Academics and Administration, my distinguished fellow directors from other Symbiosis Law Schools, to mention Dr. Chandrasekhar Ravandale from Symbiosis Law School, Noida, Dr. Anuradha from Symbiosis Law School, Hyderabad, and Dr. Sukhwinder Singh from Symbiosis Law School, Nagpur, as well as Professor Lassi already mentioned, representation from Goa in the form of Dr. Shabir from Salgaonkar Law School, representation from Rajasthan in the form of Professor Ranjit, representation from Madhya Pradesh in the form of National Law School, Bhopal's Professor Mohanty, to mention a few, and many more who have joined online to participate in this deliberation. We also have some of our distinguished speakers adorning the panel here, who will be responding to the queries as well as giving their precious views on these proposals, which have been put forth by the government initiative through National Women's Commission through its earlier consultations. I'm very happy to welcome all of you on 3 or 4 counts. First of all, as the director of Symbiosis Law School, Pune, which is the oldest law school in the Faculty of Law, which is today home to 3 more law schools, which are equally growing and distinguished. I'm very happy to share with you that there are 4 hallmarks of excellence that Symbiosis International University and the grand vision of Dr. Mazumdar sir, who founded Symbiosis, represent. First of all, it's about high quality academics in terms of research and teaching, where we have been the pioneers in the BBA LLB program way back in the mid-80s. One of the first law schools in the country among 4 or 5 to start the 5-year program. And secondly, we have been one of the very few to start 1-year LLM within 3 months of the rolling out of UGC's rule. We have been one of the first to ever start in this country, European Legal Studies Certificate Program, among other things. There could be many more innovative aspects that I could bring before you, but I would like to tell you about 3 of them. One is networking, which is represented today within the drop of a hat. Within few minutes, we were able to gather this distinguished panel because of not only the brand that Symbiosis family represents, but also because of the network that we maintain by contributing to nation development in the form of great careers that we have created in the field of law through our alumni and students, but also in the form of contribution we have made to law reform in this country. I'm very humbled to state with you that ever since this law school took its shape way back in 1977, we have been very lucky to have the mentorship of then Law Minister, late Advocate Ram Jethmalani, later on Mr. Veerappa Moily, Mr. Salman Khurshid. All of them relied on this law school as a kind of repertoire, crucible of ideas, as a crucible of research, thought process. And we are very, very honored to share with you that we have been collaborating with the District Legal Aid Services Authority in reaching the law and remedy of the law to the vulnerable sections in Pune, of which the echo is in the form of representation today with Mr. Sawant. So such is our ethos in Symbiosis of collaboration and symbiotic relationship with community, with government, with you can say other stakeholders such as alumni, judiciary, lawyers, etc. Now, one of the most important collaborations that we have had is with the non-governmental organizations. And we have very distinguished organizations here being represented in the form of Mahir and Childline, to mention a few. We have 3 more joining us later on, which shows that a venture of this kind, which is going to happen in next 3 or 4 hours, requires all stakeholders to deliberate on the future of law as a kind of vehicle of bringing those into justice who otherwise remain either voiceless or invisible. So our collaboration also extends to other universities. We participate, they participate. So you see here our relationship with the national law schools in Maharashtra. All the 3 national law schools, we have a very strong relationship. We have a relationship with National Forensic University, which is a university of excellence. And we have with the Amity University, Dr. Vibhute earlier was in IIT Kharagpur. So our friendship continues from there. Or much before that, some of the students he nurtured are our faculty members while he was in the Pune University as a senior professor. And we have Mumbai University being represented here, which is home to number of law schools. And Dr. Rajashri and Dr. Rashmi Oja stand here as the testimony to our deeper friendship with the university. Aside from that, Symbiosis hallmark also has been in terms of creating standard research. You would see that today the university itself is ranking among the top 25, top 50 in various surveys, whereas the law school has been consistently ranked among the top 5 or top 10 because of such hallmarks of excellence. Now, in the grand vision of Dr. S.B. Muzumdar sir, the law school got shaped in terms of being a public service organization with the commitment to justice. So large number of our output has been in terms of contributing good lawyers and judges. You would see that today in the country, if you look at good law firms in the leadership roles, we have our alumni. We have our alumni as judges in Mumbai High Court in the form of Revati Mohite Deri, to mention one. We also have Justice Sadhna Zadav and 2 more in Aurangabad bench. So this shows that the public service commitment of any law school, which is more pronounced in Symbiosis Law School and the family of Symbiosis Law Schools, is visible. So I welcome you with that tone setting kind of assurance to you that this is no accident that we are a forum to this deliberation, which is involving 6 states. It's a regional deliberation. It is a kind of a consequence of the good work that this law school has been engaged in and this law school has been looked up to. So I hope that we keep that promise with the wisdom and experience of all the panelists coming in here and the grand agenda that we have drawn with the National Commission for Women. First of all, as I welcome all of you, I also have my deep gratitude for the National Commission for Women, particularly the chairmanship, as well as the member who has been supportive to us in identifying our law school as the venue. Other than us, I think in rest of India, national law schools have been identified. Maybe the short notice and the quickness of the agenda that needs to be reached has made us to be chosen. So I welcome such gesture on behalf of the National Commission for Women for the funding, as well as for all the addresses, initiatives, and support, and the quick way of responding. Nobody could imagine a government to collaborate with the speed that Symbiosis has and the kind of excellence that Symbiosis has in a matter of 3 days to bring this whole event into fruition. I welcome the faculty members and our students, our researchers who are assisting here as organizers, rapporteurs for the entire day's proceeding. I must also speak quickly about our chief guest, Justice Ambadas Joshi. Sir has been a kind of icon of academics, despite being in judiciary. In addition to being in judiciary, we always speak about such collaboration between judiciary and academia. Welcome, sir, for your kindness of traveling all the way here. Sharma sir, thank you for traveling all the way here, because the commission had insisted on offline meeting of certain minimum numbers. All of you have honored us, supported the great cause. Now let me come to the theme of today's. The theme of today's is about improvement in status of women by reviewing criminal law. A very interesting and very needed, very much needed, very timely agenda that we have. National Commission for Women has already circulated this agenda all over the country. It held its one online deliberation in the month of January. Then there were certain regional deliberations which were lined up. Along with us yesterday, 3 were going on, and today also some are going on. Now, here, 4 areas have been taken up. One is cyber crime as an issue. Second is classification of offenses. Third is certain amendments suggested in the procedural law, approaches suggested for Indian Evidence Act related adducing of evidences, laws relating to violence against women or offenses against women. So for convenience, we divided them into 2 panels. One is the general, particularly public space oriented kind of laws, which have issues related to both the working of the executive and the judiciary together, aside from legal interpretation and law provision reform, in the form of cyber offenses and in the form of, let us say, classification of offenses. In the afternoon, we are looking at exclusively at the family-based violence. Now, why the need for looking at criminal law in terms of status of women? If you look at the word status and women, women are taking their identity in terms of being the target of discrimination or target of exclusion or denial before their shaping of their birth in this world. In the PCPNDT Act, this issue was addressed long ago, and now we are seeing that in this consultation, we have excluded that part of law which is to do with the children, which is POCSO and other legislations. Yet, I must tell you here that there are certain areas where the 2 overlap. So I'm happy here Childline representation is here. So that could also be looked into in terms of procedural aspects and how we could send such suggestions in terms of how to make courts more friendly. We are missing Justice Joshi here today because of unavoidable reasons, but in her book, she has clearly told what kind of reforms are required, because girl-child is also a very strong gendered issue here. Aside from that, we have the latest evolution in transgender law and identification and honoring of transgender rights. That needs reflection here. So our expert panel is going to reflect on that. Now, why criminal law in terms of status? Status is not just about being a citizen, not just political status. It involves cultural status, social status, economic status. And if one thinks that criminal law is only about the negative behavior, we must also look at the economic impact of crime, social impact of crime, cultural impact of crime. As far as women are concerned, there are not only cultural impacts, there are also cultural norms and behaviors which are in turn feeding the crime. So subtly, these recommendations which are proposed or which are asked for are reflecting on that. For example, misogynistic seditious statements. Very important. This is a subtle way of addressing the cultural feeding of crimes against women, which are affecting status and honor and dignity of women. Another example I can give is the long-term study which was done by Galway University in collaboration with Tata Institute of Social Sciences, where in Rajasthan they found out how thousands of crores could have been saved to the sector if there was no domestic violence. Because the minute there is domestic violence, the kind of physical impact, the kind of psychological impact it has, and it excludes the half of the humanity, means women, from the workforce, it results in certain economic loss to the private sphere as well as the public sphere. So reflecting on the criminal law is not just for the idea of security in terms of state being a respectable state, in terms of higher rank in equality index only internationally, or respecting human rights of women in the form of CEDAW only. It is also about the development of this country. It's about economic enhancement of this country. It's about equality clauses in the constitution being realized. So crime is not just having an implication in terms of sanitization of the society, in my opinion. It is having a larger impact in terms of pushing the country forward in development. Therefore, this deliberation, as I set the stage, I would like to emphasize what is not told by Women's Commission, but what is carried in the aspiration of Women's Commission, is that the time has come for us to be more inclusive in terms of getting the potential and capability of women into the mainstay by eliminating or warding off the blocks to such realization in the form of criminality in society. We have seen that with the onset of online mechanism as the lifeline of human interaction, more exacerbated by the COVID necessities, we have also seen crimes assuming new forms, vulnerability assuming new form. So this is something that is going to be addressed in the morning as a very key issue, and we have expert like Advocate Puneet, who is going to join us and talk to us about it. Besides the literature that we have circulated to all of you, which is comprising of studies which have been done in the Mumbai area, comprising of Rajya Sabha recommendation in this area. So let us see how far we can incorporate those things. They may be emerging in other regional consultations, but they need to get into the body of law as soon as possible, as one of the scholars, Soumya, who is currently with Jindal Law School, urges. Earlier she was in Maharashtra National Law School, Mumbai. So we have a number of scholars inputs also coming in here. Yale Law School carries a kind of scholarship enterprise which was captured by Professor Ranjit from Jodhpur National Law School. It talks about how exactly the police force, the prison and others need to be guided by a policy which is gender friendly in terms of transgenders, LGBT community. So some of these scholarly inputs also we are bringing into the deliberation, and our rapporteurs are going to cross verify what deliberation comes here to give a shape in terms of our recommendation from this regional consultation to the National Commission for Women. I welcome one and all once again, and I once again posit my deepest gratitude to each and every one of you from this dais. And I did not look forward to such a whopping support with such a short notice. Once again, welcome.
Thank you, ma'am. Thank you for that warm welcome address, and also for setting the stage for all the valuable discussions and deliberations that are to take place today. In order to honor the dignitaries who have made such an effort and have graced us with their presence this morning, we would like to felicitate all the dignitaries. And for this, I would like to request Dr. Shashikala Gurpur ma'am to felicitate firstly the chief guest today, Justice Ambadas Joshi, Lokayukt, Goa. I would request ma'am to now felicitate Professor Dr. KVS Sharma, Vice Chancellor, MNLU, Aurangabad. I request ma'am to now felicitate Dr. Purvi Pokhriyal, Dean, National Forensic Science University, Gujarat. I would also like to request ma'am to felicitate the NCW nodal officer that we have with us today, Mr. Praveen Singh. I would now like to call upon Dr. Aparajita Mohanty, Deputy Director, Academics, to felicitate Judge Pratap Sawant, Secretary, District Legal Services Authority. I request ma'am to felicitate Advocate Puneet Bhasin, cyber law and cyber crime experts. I'd like to request ma'am to felicitate Ms. Anuradha Sahasrabuddhe, Director, Childline. I would also like ma'am to request ma'am to felicitate Sister Lucy from Maher. I would now like to call upon Dr. Dhanaji Jadhav, Deputy Director, Administration, to kindly felicitate Professor Dr. K.I. Vibhute, Director, Amity Law School, Mumbai. To felicitate Dr. Rashmi Oja, Principal, Chembur, Karnataka College of Law. And Dr. Rajashri Varadi, Professor and former Head, Department of Law, University of Mumbai. Thank you once again to all the dignitaries. It is now my privilege to welcome and introduce the chief guest for today's inaugural ceremony, Justice Ambadas Joshi. Justice Ambadas Joshi practiced as advocate at Beed, Aurangabad, and then in High Court bench at Aurangabad since 1982. He was appointed as a special counsel for the state of Maharashtra in many cases, service matters, writ petitions, appeals arising out of land acquisitions, civil supplies, labor laws, etc. He was elevated to the bench of Mumbai High Court on 16th March of 2014. He worked as a single judge in criminal labor and services, criminal company, civil criminal company law assignments. He participated as junior judge in division bench for hearing writ petitions, labor and service and laws, including service matters. He presided over as a senior judge over the bench, hearing writ petitions, including service matters, letters, patent appeals, etc. He presided as the senior judge on division bench, also hearing criminal appeals and writ petitions for 2.5 years. He retired in 2013 while sitting at Aurangabad and has been appointed as the chairman of Maharashtra Administrative Tribunal in 2014 and retired as the chairman of Maharashtra Administrative Tribunal on the 15th of July, 2019. I invite you, sir, to deliver the chief guest address. Over to you.
As a member of the group discussion panel, I may present some thoughts on the topic, but as a speaker in the first session, I take liberty to speak something which the Women's Commission may have in contemplation, but today does not have in mind. I shall try to abide by my time limit and mention the points. If I have to argue on that, I'll keep it for second session, question and answer session. I'll simply mention those points. I begin with the concept of backward integration. This word I am using for the commission to note, researchers and rapporteurs to note. I'm more than sure that everybody knows what is the concept of backward integration, but at the cost and risk of repetition, I shall tell. Whenever any commercial or industrial activities commenced or to be commenced, tremendous research and backward work is done. In absence of that, we find numerous sugar factories and industries failing. Let us examine this point of view while considering prevention of the offenses relating to women on which we are focusing today. Point number one. Secondly, vaccine is better than antibiotic. what preventive action which we or Women's Commission proposes to initiate for securing prevention of such offences. I shall mention only one incident. One collector in Punjab conducted a SAS Bahu Sammelan. It was in his back of mind that my district will not have a 498 case. And I am more than sure, counseling prior to marriage, even I go to the extent of counseling prior to the age of marriage, counseling before marriage and counseling post marriage, bears outstanding and unbelievable fruits. As a lawyer, I have done tremendous consultation in family matters. On the basis of that experience, I am sharing this aspect. Our community, including those in governance, are hounded and have got a many of rights. At some point of life in the history of nation, we need to think of emphasizing on duty-based jurisprudence. Let us stop talking about it. We have right mania. I had an occasion to address a women's gathering at Chalisgaon. It was sponsored by UGC out of college education. If you, instead of, I am not saying that don't amend the law, amend it, train the bahus, no issue. But if you train the SAS, mother-in-law, as to how to tackle and treat the next generation, probably this cruelty and all this is likely to subside. Tremendous backward integration is required. It ought never be forgotten. Next point is, I know a couple of NGOs people representing here and helplines there. Can we manage? Women's Commission must strive for that. We have a parallel online trigger. No sooner an FIR is registered relating to an offense against women, there should be a call bell to one or two NGOs who are going to give moral support. That lady is in trauma. She needs immediate consolation. A glass of water, a cup of tea, an inquiry whether she had food. How many hours have gone to her taking food? Somebody to pat her back, sit with her. Is it necessary or not? If this is not done, law has its limitations. I believe many of academicians know. One of the former Director General of Police Maharashtra wrote a book, Cops, Criminals and the Law, Dr. Ramakant Kulkarni. It must be available in archives now. Nobody has put hand on that. He has raised a question in his doctoral research. What is that degree of justice we are going to confer on the victim? Now, as of today, it is 30 years old. I gave an order at Nagpur in a custodial death case, observing that let there be an insurance of a police officer, the way the doctors have liability of insurance. Why can't police officers have liability of insurance? Because government took a stand that the police officer did a wrong in his private capacity. We don't pay him compensation. I had discussed a thought before some NGOs before more than 25 years, and my thought was dismissed there and then, which I am now repeating. I want rapporteurs and commission to note it. We spend lakhs and millions on marriage and dowry. Why can't we have a small check on a contributory provident fund as a social security device? सांप ने काट लिया तो इंश्योरेंस है, मोटरसाइकिल एक्सीडेंट हो तो कॉम्पेंसेशन है, 100 रुपए के पॉलिसी में 10 लाख रुपए. Why should the lady wait for her morsel of to eat next day morning? Husband doesn't pay for 10 years. He has money to spend up to Supreme Court. Why can't there be a contributory? I am not on government to spend on it. I want a contributory fund to arise. And I know few black sheep are going to be there. झूठा केस करके पैसे मांगेंगे लोग. Let 5-10% wrong payments be made, but let 90% victims have a consolation, some solace, some support. I know I am transgressing the subject, but without prevention, without vaccine, there can't be prevention. For that reason, I am mentioning one or two more points because I would definitely love to restrict myself within the time. How do we We all learn in law colleges, and those who are here, teachers, teach in law colleges. End of law, object of law. Is the object of this law relating to offenses against women to punish the people and send them to jail? It is one of the inevitable consequences. Is it the object of law? All these laws are remedial. We need to look at this from the point of view of prevention. And as is always said, a Democrat would always continue to argue to preserve right of his opponent as well, to open of mouth. So I'm going to continue to argue this point so long I have energy. And I want you people to think on it. Somebody someday will have to think on this. Great and bad point to end. I'll illustrate so that my point is done well. A minor girl abducted. By the time the Honorable High Court judge heard the habeas corpus petition, she had a pregnancy of 7 months. What is the degree of sensitization of me and my community? And from where it comes? Somebody doesn't become a judge overnight. Lawyers, law students, what is the sensibility? हाँ हो जाएगा. अरे habeas corpus petition में notice निकालेंगे 10 दिन का. As a judge, I could not tolerate. At the cost of self-praise, I'll tell you, I had fortune of deciding habeas corpus on the day on which it was on the board. In honor killing, if the girl is killed, where is the justice? How do we do it? I know I saw a matter on board, serial number 20 on my board. And in the morning when I went to the court, I told the Shirasidar to contact both lawyers, telling that I will take the matter out of turn. It was taken at 10:30. The girl was produced at 3 p.m. and matter ended on the same day. When it is possible, you have that feel of heartburn. This sensation doesn't come automatically. You and me will have to work on that. I think this, for this session, this is sufficient. If something more is to be argued, I mean argued. Question answer session, if time permits, I'll do it. I think I have avoided by time. I gratefully acknowledge being invited here, and I am happy that I have exploited that opportunity. Thank you all, and I wish you fruitful discussion. Thank you.
Thank you, sir. Thank you very much for that compelling address to emphasize on the gravity and the urgency of the topic that we are dealing with this morning. It is now my privilege to introduce the guest of honor for today's inaugural ceremony, Professor Dr. KVS Sharma, Vice Chancellor, MNLU Aurangabad. Professor Dr. Sharma is the Vice Chancellor and he is the Chair of Consumer Laws he was the Chair of Consumer Laws at Nalsar University of Law, Hyderabad. He received the Best Teachers Award from the State Government of Telangana on Head Center for Consumer and Competition Law, Nalsar University. He was the presiding arbitrator in a dispute between NTPC and Singaneri Collieries Limited. He was enrolled as an advocate in 1983 in the Bar Council of Andhra Pradesh, Hyderabad, and he practiced as an advocate in Visakhapatnam from 1983 to 1986. He has several professional affiliations and associations and is currently joining us as the Vice Chancellor of Maharashtra National Law University, Aurangabad. Over to you, sir.
Good morning all of you. Respected Professor Dr. Shashikala Gurpur, Fulbright Scholar, Director, Symbiosis Law School, Pune, Dean Faculty of Law, SIU. I'm very thankful to you, Madam, for inviting me as guest of honor. And yesterday, Chief Justice of Bombay High Court, he visited our university at 6 o'clock. And immediately after he leaves the university, I started and came here. And Lordship, Honorable Lordship, Sri Justice Ambadas, Honorable Lordship, Sri Justice Ambadas Joshi, Lokayukta, Goa, and former High Court Judge, Bombay, and respected dignitaries, participants, representatives from National Commission for Women. why there is a need for reform in criminal justice system. And our Honorable Minister, Home Minister, he wrote letters to all vice chancellors and professors to send suggestions on criminal justice reforms. And he constituted Professor Ranbir Singh Committee also in National University, Delhi, and they are working on it, and still they are supposed to submit the reforms. Whatever suggestions we are giving here, if we send it to that particular committee, they will incorporate in the what we call in the criminal justice reforms also. Just I got this report 2019, Justice Report 2019, India Justice Report 2019, first time initiative of Tata Trust. It leads way to bare-bone common knowledge of India's what we call failing criminal justice system. They mentioned some important points I will read here. So many they gave, just 5 to 10 points I will read. This prisons, if you see, prevalence of HIV, sexuality transmitted infections, hepatitis B and C, and TB in prison population is 2 to 10 times higher than the general population. This is one. In 2016, 67.7% of India's prison population were under trial prisoners. This is one area in this women are also there where universities can do something. How many under trials are there? Just I will read, after that I will give my observation. The prison occupancy in Delhi is as high as 180%. Then in Uttar Pradesh, 95,366 inmates are handled by 2016, Uttar Pradesh with over 68,000 under trials inmates, 68,000 under trials. Last 5 years, 10 years, without trial, they were struggling in jail. And in one interview, one boy, he said, he went to second show movie and he was going, police arrested. In last 5 years, he was in jail. Police personnel, they were not producing. So many. And taking bath is also a luxury in this. So many ladies are also there. Women are also there. That National Commission for Women and the universities, we can pay some attention on that. Then nationally, 19 states and UTs spend between 20,000 to 35,000 per inmate annually. This is less than 100 rupees per day on each prisoner. Then in judiciary, if you take, there are 28 million cases pending in India's subordinate courts, out of which 24% have been pending for more than 5 years. In this, divorce matters you can, maintenance cases you can, how many are there? Decades they are taking. If you file a case for maintenance in junior civil judge court or senior civil judge court, it will take 5 to 10 years. Then the husband may prefer an appeal. In High Court, we don't know, 10 years or 20 years. Once the matter goes to Supreme Court, both parties will die. That maintenance or anything, their children may get or may not get, that's a different issue. On average, no state or UT, apart from Delhi, spent even 1% of its budget on judiciary. At the subordinate court level, in 21 states and UTs, a case remains pending for 5 years on average or more. This is minimum, they said. Then, with reference to women, 2019 report, there are 7% women in the entire police work. And they are supposed to deal with what you call accused when they are women. And sufficient women force is not there. 7% women force. And at officer level, we have only 6% women. Only 18% of panel lawyers with legal services institutions that provide legal aid are women. Then women accounts for 28% in the lower judiciary and 12% at the high court level. And almost all family courts must be headed by women judges. And sufficient number of women judges are not there, and how they are tackling this family court matters, I don't know. There are just 9.6% women across all levels of prison administration. Women prisoners, if you take, they are in thousands or lakhs, 9.6% women, 90% are male, and these persons are dealing with women prisoners also. And with reference to police, if you take, there are 151 police personnel per 1 lakh people. This is one. And with reference to prisons, if you take, prisons are understaffed by at least 33%, with the highest rate found at the officer and correctional staff levels. Similarly, if you take, in 27 states and UTs, including Haryana, Maharashtra, and Kerala, There is just one subordinate court judge for over 50,000 people. For 50,000 people, only one subordinate court judge. And they are supposed to deal with all cases relating to what you call domestic violence and maintenance and family disputes, everything. So, with reference to what you call domestic violence cases and reference to some what you call disputes between husband and wife, sometimes they fall under criminal matters also. To Nalsa, Justice, the then Chief Justice of AP High Court, erstwhile AP High Court, he came and said, even in criminal matters, we can apply mediation, arbitration. In CRPC offenses, we can classify into compoundable, non-compoundable. So this compoundable offenses, we can refer to arbitration or mediation. And in this aspect, my request, wherever I go, even last time also, Madam also, Shishkala Gopru, Madam also, jointly we will do this program. She said it later on, because of COVID, we did not initiate the program. Almost all universities now, and almost all universities, departments of law in universities, we can establish arbitration mediation centers. This is one thing we have to do. National Commission for Women can enter into MOUs with all departments and national universities. We can establish mediation centers. In case NCW, it will be there for that. Independent people may not be having that much confidence. So we can establish mediation centers, and almost all domestic violence matters or family dispute matters can be sorted out through mediation. In Western countries, they are encouraging mediation, not arbitration. When I was professor in Nalsar, we used to start one diploma course, diploma in arbitration, and we conducted for 20 years. Several employees, executives, they got training and they became professional arbitrators also. There was a dispute between NTPC and Singareni. NTPC nominated former executive director Dave, and Singareni nominated former chief general manager Sesh Kumar Reddy. I don't know who suggested my name. That is a dispute between contractual dispute between two companies, 38 crores. And both the officers nominated me as presiding arbitrator. Then I went to my vice chancellor, Professor Faisal Mustafa. Sir, they nominated me. Can I accept? He saw me like this and said, normal, no vice chancellor will accept. No head of the department will accept. The same thing when I discussed with so many vice chancellors in consortium, why don't we start arbitration centers? Nearly 5 to 10 vice chancellors, they oppose. No, teachers will go into arbitration. They neglect this. I think Saturdays, Sundays we do. We are the best persons to sort out this mediation and arbitration. Then he saw me like this and approved. After that, there is one water limited MNC, US company. It used to enter into MOUs with all panchayats and installing water treatment plants. And there was an arbitration tribunal clause. There was dispute between panchayats and this 100 disputes were there. And this company nominated me as arbitrator. Again, I went to my vice chancellor. Sir, more than 100 districts are there. They nominated me, accept. What is this? You are going to do this job or that job? Then I said, Saturday, Sunday, sir, we do. Then he accepted that. After coming here, I lost that opportunity. But this is another advantage. I'm telling you how teachers can resolve disputes, women problems, all these. National Commodity Derivative Corporation and MCX. These two nominated me as a panel arbitrator. Online I'm doing. So almost 7 awards I gave. What I'm telling, let us establish mediation centers. I'm going to enter into MOU with Maharashtra State Chamber of Commerce. And already we discussed with Marathwada Chamber. I'm going to establish arbitration center and mediation center in my university. Like that, I am requesting all heads of departments, vice chancellors, establish mediation centers, arbitration centers. I request NCW to give some what you call support, so that almost all women disputes, whatever problems, this maintenance, all these other domestic violence cases, through mediation we can resolve. So this is the only suggestion I want to give to all university heads and vice chancellors here. In case you want, we can collaboratively also, we can do this. Thank you one and all.
Thank you very much, sir. Thank you for that address and also for emphasizing the need for prison reforms and alternative dispute resolution methods for improving the status of women. I would now like to invite Dr. Aparajita Mohanty ma'am, Deputy Director, Academics, Symbiosis Law School, Pune, to deliver the vote of thanks for the inaugural ceremony.
On behalf of management of Symbiosis, Dean Faculty of Law SIU, Dr. Sashikala Gurpur, faculty and staff of Symbiosis Law School, I extend a warm vote of thanks to our esteemed chief guest, Honorable Justice Shri Ambadas Joshi sir, our Lokayukta, Goa, for gracing the event, regional consultation on review of criminal law, improvement in status of women, organized in collaboration with National Commission for Women. Thank you, sir, for gracing the event and addressing the august audience. I extend a warm note of gratitude to Professor KVS Sarma, sir, VC, MNLU, Aurangabad, for consenting to be the guest of honor and delivering the address. Thank you, sir. I thank the esteemed academics, senior advocates, representatives from NGOs, the directors of 3 sister law schools, representatives from the NLIUs of Western region who have attended the inaugural function as the resource persons. As the event unfolds, we will be partaking their wisdom with regard to suggested reforms in criminal law status of women. It is the privilege of Symbiosis Law School, Pune, to be collaborating with National Commission for Women for arranging this event for the Western region. I put on record a sincere note of thanks to NCW. I thank Mr. Praveenji, nodal officer, for being here with us from yesterday and providing us with his able guidance. I thank Dr. Sashikala Gurpur, Dean, Faculty of Law, SIU, and Director of Symbiosis Law School, Pune, for meticulously planning the event and guiding us at every step. Thank you, madam. I thank the organizing committee headed by Dr. Bindu, Dr. Shelke, the Professor Lasya, who have planned and organized the event with great deal of zeal and passion. Thank you, madam. Thank you, Dr. Shelke. I thank the faculty for their wholehearted cooperation in executing it. I thank the IT team for providing the technical support. I thank volunteers of Student Advisory Board, the entire Student Advisory Board, which is present over here online, and the students for attending the inaugural function. Thank you, one, and thank you all.
Thank you, ma'am. With this, we come to the end of the inaugural ceremony. We will now take a break of 5 minutes and we will commence with the first plenary session on cybercrime and IPC sexual offenses, which will commence at 11:10 a.m.
SK Jain will be arriving. We welcome on behalf of Symbiosis Law School.
His seat is there.
Okay. Welcome back to one and all. We will begin with the plenary session 1 in 5 minutes. We are just waiting for Advocate SK Jain to join us.
No change, ma'am. Just that after every speaker, there will be polling. So otherwise, it will take too much time at the end.
So we have the question related.
Yes,
to that.
yes.
Very
Into that list after that for polling.
Welcome back to the plenary session 1, review of criminal law improvement in the status of women, cybercrime and IPC sexual offenses. For introducing the resource persons of today's first plenary session, I would like to invite Professor Dr. Bindu Ronald, co-head Khalsa Symbiosis Law School, Pune.
Good morning and a very warm welcome to all our guests, faculty and students who are there online with us today. To the first plenary session that we have on the regional consultation on review of criminal law, improvement in the status of women. And this session will relate to cybercrime and IPC sexual offenses. The first plenary session has been divided into two. A, which will discuss the sexual offenses, and B, which will have discussion on cyber dimension of sexual offenses. Our first plenary session definitely looks very interesting with very eminent resource persons who are there with us and who will be sharing their views on the various topics relating to sexual offenses and cyber dimensions of sexual offenses. Let me briefly introduce all the resource persons who we have in the first session. Our moderator for the plenary session is Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, and Dean, Faculty of Law, Symbiosis International University. An eminent scholar, she's the holder of the Giammone Chair on Climate Change, and we have already been introduced to her, and the two plenary session will surely showcase a very enthusiastic justice crusader who will be there with us. We also have other panelists. We have Professor Dr. KVS Sarma, Vice Chancellor, MNLU Aurangabad. Sir is an academician. So in the first panel, we have Professor KVS Sarma, Vice Chancellor, MNLU Aurangabad. Sir is an eminent academician. He held the Consumer Laws Chair at Nalsar University of Law, Hyderabad. He is the recipient of the Best Teachers Award from the State Government of Telangana on the Head Center for Consumer and Competition Laws. Sir has been the presiding arbitrator in a dispute between NTPC and Shingareni Collieries Limited. We also have in the second panel, Professor Dr. Rashmi Oja. Dr. Rashmi Oja is the principal of Chembur, Karnataka College of Law. a recipient of gold medal for securing first class first in Master of Laws degree from Mumbai University. She pursued her postgraduate diploma in human rights from University of Mumbai. She was conferred doctorate degree on the topic of human rights and gender inequalities in India by Mumbai University. She has to her credit numerous publications, she was the only participant selected from India to participate in the Advanced International Training Program at Sweden, where she presented a paper on violence against women in India before the committee members of United Nations. She was awarded the International Diploma in Human Rights with distinction by Royal Wallenberg Institute of Human Rights and Humanitarian Laws, Sweden. We have with us Professor Dr. K.I. Vibhute. Dr. Vibhute is the Professor of Law and Director, Amity Law School, Amity University, Mumbai, and Honorary Professor Emeritus, National Law University, Jodhpur. A recipient of distinction at the graduate and postgraduate studies in law and of fellowships from Hague Academy of International Law, the International Institution of Human Rights, the UN Human Rights Center, the Max Planck for Comparative Public and International Law, Germany. Sir, it's a privilege to have you here with us. And sir was also listed on Who's Who in the World, the Great Minds of the 21st Century, 1,000 Great Asians, Outstanding Scholars of the 21st Century, and Leading Educators of the World and Who's Who in Asia. He has been a professor of law at various universities of repute in India and abroad, and sir has numerous publications to his credit and has been on the editorial board of some of the leading national and international law journals, including the Journal of Indian Law Institute, Asian Yearbook of International Law, International Journal of Criminal Justice, to name a few. He's also the vice president of the Indian Society of Victimology. We have with us Advocate Punit Basin. Advocate Punit Basin is a pioneer in cyber laws in India and was awarded the Best Cyber Lawyer in India. She's an advisor to the Rajya Sabha committees on internet laws and recipient of 5 national awards for contribution in cyber laws, one of them being the Best Cyber Lawyer in India from late Shri Ram Jethmalani. She has presented as expert in cyber laws before in amendment to the Information Technology Act and drafting of new legislations, Rajya Sabha Committee on Online Pornography Regulation in India, recommendations for formulation of Indian data protection law, recommendations of cryptocurrency regulation and online gambling laws, and recommendation to the National Commission for Women on cybercrime against women. Ms. Punit is a very well-known author in cyber laws, and her articles are published routinely in newspapers and on online portals, wherein she shares her views on issues and latest updates in digital crimes and privacy space. She's also routinely featured on the leading news channels like BBC, CNBC, etc. Ms. Punit launched Cybergear Academy in 2018 to develop industry skills sets in EU GDPR compliance, cyber laws, cybercrime investigation, and data protection compliances. We also have in this session Dr. Atmaram Shelke, who's our very own person, an associate professor at Symbiosis Law School. He's an academician who is an expert in cyber laws, constitutional law, and criminal law, a gold medalist in LLM, and also a PhD from Symbiosis International University. He has a number of publications to his credit and admired by the students for his scholarship. Along with Dr. Atmaram, we also have with us another faculty from Symbiosis Law School, Pune, Dr. Girish Abhyankar, who is an expert in criminal law and author. He has authored a book, Witness Protection in Criminal Trial in India, and also has other publications. In this session, we will also have Dr. Anuradha Sahasrabuddhe, Director, Childline. She did her post-graduation in nutrition laws and dietetics, and MPhil and PhD in education with research in women's adult education. Besides, she has diploma in German, Sanskrit, etc. She has worked with several organizations on women's empowerment and health issues and is a trainer for diverse groups children, adolescents, teachers, parents, police, government officials, etc., in the field of gender, rights, child sexual abuse, etc. A very warm welcome to you, ma'am. We also have with us Advocate S.K. Jain, a very eminent lawyer with 48 years of practice. He's the president of Niramay Trust, Pune, that works for upliftment of slum-dwelling children, especially girls. Sir is the director of Century Enka Limited, Century Textiles Limited, and he is the chairman of Constitution Committees of Jain International Trade Organization. Sir is a patron member of the Science and Technology Park, Savitribai Phule Pune University, and president Adhivakta Parishad, chairman of the advisory committee of Apang Kalyankari Sanstha, and has represented various government bodies and local authorities. We look forward to hearing all our resource persons in this session. A very warm welcome to one and all.
Thank you very much, ma'am. I would now like to invite Dr. Shashikala Gurpur ma'am to begin with the moderation of this session, with the first speaker being Professor Dr. KVS Sharma, Vice Chancellor, MNLU, Aurangabad.
Good morning, one and all. Welcome to this first panel, plenary session 1, which is on the theme of improvement in the status of women in terms of cybercrime and sexual offenses listed in Indian Penal Code, as selected and handed over for recommendation process by the National Women's Commission. So I welcome the eminent panel with the academics, with the scholars, with practitioners like Advocate Puneet, with also people who have been in the non-governmental organizations forefront, like Ms. Anuradha Sahasrabudhe, and the topmost criminal lawyer of Pune, Advocate S.K. Jain, with us. It's a great honor to welcome all of you to this panel. And first of all, we will be taking a kind of input from the expert within 5 to 10 minutes. So I request all of you to manage as much as possible that time limit, because then again we have, after each speaker, there is a theme that is going on polling, where the proposed recommendation or the area for which recommendation is asked is put in the question form and options. So we have an audience which is not less than 800, which is offline, because our young students and people from other states, because this consultation is of 6 states altogether as a regional consultation. So many people from other states could not make it to travel. Therefore, they will be on the online mode. So it will be put for polling after each speaker speaks. So that takes at least 2 to 3 minutes. So we have accommodated that way in terms of time. So we request you to adhere to the timeline. Now, the first point we are going to take up is the area of sexual offenses. If you look at the literature that has been circulated to all the viewers as well as speakers, we have connected the two. Is the PPT running there? We have connected the two in terms of questions asked and in terms of provisions which are there. So the first point is going to be taken up by Dr. KVS Sharma, Vice Chancellor, MNLU, Aurangabad, where Sir is going to talk about classification. Is there a need for separate type of classification, whether it should be offenses related to women as such a class, or other classes of offense inclusive of this, or should it be gender related offenses? So these options the Commission has given. So I would request the wisdom of Dr. KV Sharma to come through from his research background, and then we put it for polling.
Honorable Sri Justice Joshi sir, Honorable Director Shashikala Gurpur madam, Honorable learned gathering here, dignitaries, and I think so many students, just now madam said 800 participants. I thought maximum only Symbiosis law students are attending, but now I came to know that 800 participants are attending. So all the learned participants, my dear students, the topic today is sexual offenses, criminal justice reforms. In that, sexual offenses, need for reform in classification, modification. If you take this, whole IPC is based on one Latin maxim, actus non facit trium nisi mensit tria. Means the act alone does not constitute a crime unless it must be accompanied with a guilty mind. So the essentials of crime are actus reus plus guilty mind is equal to crime. Actus committing an act which is prohibited by law, or omitting to do an act which he is bound to do by law with guilty mind is a crime. If you take Lord Macaulay's IPC, Indian Penal Code, it consists of 511 sections. Out of 511 sections, 3 chapters are very, very important in this. That is offense against property, offense against body, and general exceptions. Out of these 3, this present topic falls under offense against body. In offense against body, so many crimes are there. That is rape, hurt, grievous hurt, all this. But strangely, here, sexual offenses, with reference to sexual offenses, any classification, further classification is needed or not. Some experts say this IPC 1860 is not enough to deal with the crimes, particularly in the modern era they are committing. It is not having provisions to deal. Some time back, all of you saw some advertisements, some newspaper item, some youngsters, they kept in website that is a selling of a particular, selling of respected ladies belonging to minority community. These things were done by youngsters, educated students, all these. Why they did, we don't know. Who spoiled their mind, we don't know. Under which law it comes under which section the police have to. And one more thing, 2 Delhi High Court cases I saw, I read about rape. But yesterday when madam asked, I was going through some material, I came through one Delhi High Court cases to digital rape. What is this digital rape? 52-year-old man, he digitally raped a girl, 13-year-old girl. And another case law, 2 case laws are there. I mentioned those case names also. And under which section you have to? Can we book them under rape 375? Or with minor punishment, modesty, outraging the modesty of a woman. But he committed rape, that is digital rape. But if you prosecute under section 375, 7 years, 8 years. Under other section, 1 year, 6 months, like that he will go through. So these are the areas we have to. But strangely, the Britishers who gave us this Contract Act, codified law for contracts, codified law for crimes, they don't have codified law for crimes and contracts. Majority laws are based on what you call, particularly criminal law is also based on common law. But strangely, they codified piecemeal some areas in contracts and crimes also. With reference to crimes, they codified what you call, they passed one act called UK Sexual Offences Act 2003, and it divided the sexual offences into 4 broad categories. The offense, and before discussing these 4 broad categories, we discuss the present classification in IPC. The offense of rape under IPC is only limited to instances of penile penetration under section 375, while non-penetrative sexual offences are strewn across 354, 377, and 509 of IPC. Next slide. Section 354, it is dealing with assault or criminal force to women with intent to outrage her modesty. Then section 509, word, gesture, or act intended to insult the modesty of a woman. Then section 377, unnatural offenses. These 3 categories we have in IPC. And grave sexual offenses where penile penetration is absent would be meted with a much lesser degree of punishment than the one prescribed under section 376. These 2 cases, digital rape, Delhi High Court was unable to do maximum. He can be punished under section 354. And in Pankaj Chaudhary case also, the same offense was reported. Even in SPS Rathore Limited was CBI, also same offense was reported. And distinction between attempt to rape under section 376 and molestation under section 354. attempt to commit rape under section 376 and outrages the modesty of a woman under section 354. These two, attempt and committing, these two classifications they made under the present code. According to section 156 report of the Law Commission of India, sexual offenses against a child below 12 years of age may be committed in various forms such as sexual intercourse, that is 375, carnal intercourse, section 377, and sexual assault, section 354. That is, first one comes under rape, second one comes under outraging the modesty, or third one comes under unnatural offenses. 172nd Law Commission report stated that the physical and psychological impact of the sexual offense on the child should be the basis for making, can you go back? Making out an offense under the IPC rather than scrutinizing the type of penetration. Whether penetration is there or not, that the courts, everyone, sections, they are dealing with. Almost he outrages the modesty, worse than rape he did. Then penetration is not there. Then he cannot be prosecuted. He cannot be punished with severe punishment. So this penetration, non-penetration, I don't understand why they are making so serious. They have to give same punishment for both. Recently, Bombay High Court judgment, skin to skin judgment also we saw. That is also not happy judgment. Protection of Children from Sexual Offences Act 2012. This is according to UK. According to UK Sexual Offences Act 2003, penetrative sexual assault, sexual contract without penetration, non-contractual sexual offenses, that is sexual harassment, it comes under D, attempt to commit sexual offense. Then next, abetting a sexual offense. This particular act classified sexual offense into 5 categories. Even Justice Verma Committee report also submitted in 2013, it classified rape, sexual assault, verbal sexual assault, sexual harassment, acid attack, offense against women in conflict areas, that is armed forces, trafficking, child sexual abuse. This they incorporated in 2013 and 2000 Act also, IPCV. But in Kenya, they also passed one act, Sexual Offense Act 2006. What are they discussed nearly 20-25 classifications they made. Rape, attempted rape, sexual assault, compelled or induced indecent acts, acts which cause penetration or indecent acts committed within the view of child or person with mental disabilities. With mental disabilities, they separated. Then defilement, attempted defilement, gang rape, indecent act with child or adult, promotion of sexual offense with a child, child trafficking, child sex tourism, child prostitution, child pornography, exploitation of prostitution, trafficking for sexual exploitation, prostitution of persons with mental disabilities, incest by male and female persons, then sexual harassment, sexual offenses relating to position of authority and persons in position of trust. Then sexual relationship with predate position of authority, that is workplace, employer-employee. Then deliberate transmission of HIV or any other life-threatening sexually transmitted disease, administering a substance with intent. Then distribution of substance by juristic persons, that is corporate offenses. This is not there in our IPC. Then cultural and religious sexual offenses. Then with reference to this, they passed regulations also. So this is the classification in UK, and in India, Justice Verma's committee, that is 2013. At that time, the cyber law was not much developed. So we have to make some changes, whether we have to follow UK or whether like Kenya, we have to follow Kenyan classification or something more than that. Now learned participants, honorable faculty members, process, they explain now. Thank you very much.
Sir, thank you for that wonderful deliberation, quick and very, very focused. One of the things that is brought in and which we were also noticing, now experts like Puneet will speak on cyber offenses, but what we see here is, do we bring in the cyber dimensions of these classifications in here itself, or should it be a separate legislation on cyber offenses against women, because that will be spreading too thin, and it will not have the punch which IPC has, because then we will have to have a separate type of investigation mechanism, separate type of courts That's again complicating the process and outsourcing of justice. It should be separate, you think? Yes. Okay, so for women, there should be a separate legislation, not women. Do we call it as offenses against human body or subset of gender discrimination offenses or an independent category of offenses? Sorry, sir. Cyber crimes against women should be separate legislation, not in conjunction with these. It can be repetitive there. This can be repeated there. So this is a technicality that needs to be coming in. Small legislation they can pass. Or a separate cyber crime legislation. Within that, there can be a part of this being dealt with. So that is the first thing. Second is, within IPC, should there be change?
Should be a separate chapter in IT.
Okay. Yeah, separate chapter.
Making a separate law, it will be a very overlapping, and that will give one chance more ki whether it should be prosecuted under IPC or cybercrime, that act or that act, and that will take the matter up to Supreme Court for another 10 years.
Great. So you are, all of you are watching the legislative side, the litigation side, and the impact on other corresponding legislations like Indian Evidence Act and process. Okay. So it's not under IT Act, but under Indian Penal Code we should have. That's what even I feel.
That also would, instead of
This is fair enough. Ultimately, where to locate is absolutely independent issue. It should be composed, brought together, put it under this law or that law. Its location is not significant.
Intersectionality is very important, interface of the two. And very important thing, as of now, dealing with cyber crimes has been very diluted because it is like a ping pong ball swinging between executive authorities. Yeah.
My doubt, in UK and Kenya, in some countries, we are seeing sexual offense itself, they are passing separate special acts. Sexual
That's
offenses.
a very interesting observation you brought. What do you all think? Should there be
sexual
Kenyan
offenses
and
separate
UK
act.
approach, or should it be Indian Penal Code being?
I have one or two suggestions to make. One is that suggesting for a separate law, cyber crimes against women, would lead to multiplicity of legislations, which goes against the convention that there should be multiplicity of laws. The other thing is that if you keep separate legislation, that will create problems, as Advocate S.K. Jain was rightly saying. That will lead to kind of separate provisions under CRPC evidence. That will create complications more than solving the problem. Therefore, I have one suggestion to make. That suggestion is that instead of having even separate provisions, why can't you deliberate on amending 375 in such a way to incorporate this kind of cyber crimes against women, so that will get more kind of recognition under criminal law, and that will attract the more punishment. Of course, punishment is not the ultimate goal of criminal law, but at the most we can do justice to the victims of crimes.
Very good. So incorporating victim point of view by bringing it into the IPC. Yeah.
One point I would like to take, like more from a practical perspective. Today, when we are talking about cyber crimes itself, if you go to a police station, the officer just knows a few sections of the information technology which he doesn't understand. They introducing a new act will mean he understands rape under IPC as of now. So many years, the same thing last 1 to 3 years. Trying to explain a new act with new sections, you are going to again start. It's been 10, 15 years and still police has not fully wrapped their head around these offenses. So if there is some context to them, an amendment, then they will understand. Otherwise, when a complaint will go, what needs to happen? Should we go under this or should we go under that? And there itself, a lot of FIRs will just not have the right sections. So, there is a ground level problem that will come up. We see it happening on a routine level with cyber crime cases itself.
Yeah, can I, see, I feel that I completely in agreement with what Puneet said. It should be the part of IPC, but one very important thing probably we are missing it out, probably is there in the other document, is about the gender neutrality and inclusiveness. Because, I mean, according to me, sex can never be a foundation for deciding a legal wrongs. And the all kind of debates that we are getting into, that whether we are being able to operate the sustained transformative changes pertaining to the status of women and trying to march towards the gender neutrality in terms of all the kinds of offenses. So basically, we may have an amendment in each sections of the IPC, and we are trying to make it more inclusive and not only talking about sexual offenses against women. But I still remember the 172 second Law Commission report, when for the first time they said rape is to be replaced with the terminology sexual assault, and then so that we can make it more inclusive. Unfortunately, it was also being carried out in the criminal law amendment in 2012, but then it was not being finally taken up. You will find these gender neutrality aspects only in the UGC document. When UGC has tried to devise these sexual harassment of women employees and all students of all sexes, in that the UGC guideline of the sexual harassment, wherein we are looking at the inclusive aspects of sexual harassment. So probably when we are talking about where to locate this provision, we also need to talk about the inclusive aspects of taking care of, and the whole debate that is been going on before the Delhi High Court with reference to even 375, and the debate with reference to gender neutrality. Can male be raped or not? Definitely we have recently come across a survey wherein the survey says that in India, recently BPRD has conducted a survey. In India, 18.2% of the male, they did experience the instances of sexual assault. And then from this thing, almost 80% were being committed by female. Because we are, marching towards a different era. So probably, whether the IPC is being able to tackle the new era issues or not. So probably we also need to look at not only where to locate, but whether we are looking at inclusivity in terms of incorporating all these amendments.
Okay, thank you. Now, not being from the legal fraternity, I may make some stupid comments, but with a lot of experience with women and children and dealing with police stations and laws. This may sound a little utopian idea, but it's for our legal experts to deal with. The ground reality, as she said, at the police stations is they still don't know what law to apply. They apply wrong sections. They also don't apply all sections. And if they apply all sections, having been on the Juvenile Justice Board for several years, I find that is misused to victimize the victim. Both at the police station level, at the judgment level, or even when the arguments are going on. Eventually, in the case of women and children, they tend to go hostile and the case is just gone and there is no justice. So can we think of something where at the time of registering the case, it is made so watertight, it's just one maybe section that has all this. And as you said, I really second your inclusivity factor. Then we get a lot of cases where women are the abusers and also including the abused transgenders. So, these things need to be considered. And I'm talking of a law where all these loopholes are plugged. Can we think of that?
Agreed, ma'am. Yeah. That is what Dr. Sharma also suggested, that scattered all around in IPC should be brought in one place, and with the Verma Committee, that is the criminal amendment law, and with the cyber offences being taken into force. So the first deliberations, 10 minutes are over, we have crossed. So now we will come to the second deliberation on rape, dealing with the idea of consent, standard consent, initiation of consent, marital rape exception in 2 of 375 under consideration, and gender neutrality. Over to you.
Esteemed dignitaries and participants, a very good morning to one and all. I will. A very good morning to one and all. I'll be expressing my opinion on the exception to the offense of rape vis-a-vis gender neutrality, and my focus would be from a human rights perspective. What strikes me is God created the universe, man and woman, and the whole world started with ecstasies, pleasures, and pains. And to rationalize between pleasure and pain emerged the rule of law, which is the foundation of civilization and soul of democracy. After 75 years of Indian independence, and it's been more than 7 decades since the Constitution of India has been put in its place, more than 7 decades since the UN General Assembly adopted the Universal Declaration of Human Rights 1948. Where does India stand when we have to gauge India in the context of its civilization? A quality of nation civilization can be measured by the respect a nation state gives to its citizens towards protection and promotion of their rights, and the mechanism it uses for enforcement of these rights as such. So India being a party to majority of international human rights instruments, and we having celebrated 75 years and more than 7 decades of the Constitution, I think it's high time for us now to focus on this exception to Section 3, specifically Exception 2 to Section 375. From the perspective of gender neutrality as well. And when we compare the two documents, one international and national, I think there's a lot of similarity, and one of the significant right which we treat it as a human right, as also which is guaranteed by the Constitution of India, is right to life, liberty and security of a person. So it's right to life and personal liberty, and right to bodily integrity is implicit within right to life. Would it mean the manner in which the social structure, the social fabric of the society is that once there is a matrimonial tie, would a man have an unlimited right to unlimited access to a woman's body as such? And all throughout the globe, I think women's right has always been a contentious issue. Till date, there are grave and systematic violations of women's rights as such, which forces us to introspecting where do we stand now in the context of Section 375 Clause 2. It has been amended by virtue of the Criminal Law Amendment Act 13, which came into force in February 2013. So I won't go to the specific definition due to paucity of time. But how has consent been defined, or how has it been described under explanation 2 within Section 375? And in specific terms, it states that it's an unequivocal voluntary agreement by a woman, so far as by words or by gestures or by verbal or non-verbal communication, showing or expressing her willingness to the sexual intercourse as such. But nevertheless, there is a proviso to this Section 375, which states that if a woman resists to this forcible act as such, then it will not be presumed that she had consented, not consented. It's all subject to the interpretation by the court. And till date, Section 375 Clause 2 continues to be an exception to Section 375. So what has been a judicial trend? I remember in the journey has traversed from Mathura rape case, where the court went, interpreting the word consent as to how do we treat consent as, and then Sakshi versus the Union of India, and later on a significant judgment in which this very Section 375 Clause 2 was interpreted by the court as an exception. In Independent Thought versus Union of India, the judgment was passed by the Supreme Court as late as the year 2017. So if this be, and a bunch of petitions pending in the Delhi High Court on this issue, but the court has in specific terms stated that any such offense, as against a woman or a girl less than 18 years, it will amount to an offense. And making a specific mention of right to bodily integrity, right to her choice of her reproductive choices as well, and Article 21 of the Constitution, right to life, and violation or contravention of Article 15, Clause 3 of the Constitution of India. So if this be so, and Purvi ma'am just made a reference of 172nd report of the Law Commission of India of March 2000, where significantly this section 375 clause 2 has not been, considered by the Law Commission of India, stating that it would amount to an excessive interference in the matrimonial relationship within the family as such. Justice J.S. Verma Committee's 644 pages long report in 2013 has made a specific recommendation that yes, Section 375(2) should be criminalized, and it needs to be repealed and it needs to be deleted as such. Identically, just as Sir mentioned about the UK Offences Act and how do we take and learn lessons from it, Australia has passed a law as early as 1978. Scandinavian countries, some of the European countries have also passed a specific legislation criminalizing marital rape, and these are the debates worldwide. All across that it's high time we criminalize this offense of marital rape. But one thing from a human rights perspective is, ma'am made a reference of the convention, that is the CEDAW convention, to which India has ratified the convention as early as 1993. I'm on this criticism where India has made two declarations which attacks the aim and objective of that specific convention. That's Article 5A and Article 16. And 5A speaks specifically, it makes a provision to eliminate social and cultural patterns which are, which are against women. So it's we who have created, it's we who maintain it well within the societal structures as such. And Section 16, Article 16 makes a specific provision with regard to the state, thrusting an obligation on the state to, come out with affirmative actions and to ensure that there is equality within marriage. So giving a right, woman equal right, in the matter of choices, whom to marry, whether to have sex with her husband, to decide, the spacing between children, how many children to have. Well, we have made a declaration under the guise or with a defense that, okay, it's a pluralistic society and at one go we cannot eliminate, or we can't just erase these practices as such. Besides this, I think it's high time now for us to focus, when we take a pride in celebrating Azadi Ka Amrut Mahotsav that's being marked as the year 2022, and we'll be taking a pride of Azadi. So in the context of Section 375(2), whether can we really term India as an independent nation where all have the same fundamental rights which are put in its place as early as 1950 as such? I think this probably, the continuation of Section 375 Clause 2 to the IPC, which was put in its place as early as 1860, may probably force us to a deep introspection that are our laws truly gender neutral? I think that remains a question mark for all of us to deliberate and, draw a particular inference or a conclusion. So my respectful submission is, let us strive to ensure equality guaranteed by the Constitution as well as the international document, Universal Declaration of Human Rights, without any discrimination whatsoever, and sex being one of the prominent, ground where discrimination cannot be made. So in the context of Section 375 Clause 2, I think this deserves to be debated, and we need to come out with a very valid and justiciable conclusion that it's unequal status accorded to women in the case of a matrimonial tie. Thank you, ma'am.
Thank you, ma'am. Before we go for the poll, I would rather suggest that Dr. Vibhute sir present his views on gender neutrality and marital rape. as much as sentencing guidelines for sexual offenses. Over to you, sir.
Good afternoon to all the participants present here and online. Professor Shashikala Gurpur, my esteemed colleague and friend. I am grateful to her for giving me this floor to share some of ideas with the learned participants on the review of criminal law. Honorable Justice Ambada Joshi, with whom I had interaction at least 4 or 5 times. And every time I learn new things from him, including today. Honorable Vice Chancellor, Justice Sharma Sir, MNLU Vice Chancellor. Then leading advocate, S.K. Jain, my student friends and colleagues and representatives of NGOs. I have given 2 topics to talk on. One of the topics is marital rape. Dr. Rashmi Hoja has made my task a little bit easy, speaking on this topic from the human rights perspective. But being a student of criminal law, which I'm trying to understand ABCD of criminal law since last more than 4 decades, let me exhibit my ignorance about criminal law, which I've been trying to learn. I don't claim that I'm expertise, even though Bindu has said a number of compliments to me, because she happened to be one of my just students when I was about to leave this law department. So let me try to be a little bit more academician when we want to undertake serious review of marital rape, exception 2 to section 375 IPC. Now, if you look at the journey which 375 has since last more than 160 years, as Rashmi ma'am was trying to say, that whole rape law can be divided into 3 parts of developments: pre-Mathura, post-Mathura, up to Nirbhaya, and post-Nirbhaya, including November 18 amendments. So now if you see these amendments, the kind of wisdom which legislature exhibited in making, unmaking so-called law. Now if you see the original IPC, the heading was of rape in the broad classification of offense against human body and life, of rape. And later on, based upon Law Commission recommendations in 2000, in the wisdom of the legislature, they tried to change the caption and they changed it. It is now sexual assault. Now, I, as a student of criminal law, wonder, does nomenclature make any difference of rape and sexual assault? So therefore, probably what we have to think of as students of criminal law, and particularly these participants who are trying to look at a review of these laws vis-a-vis status of women, that what is mean by rape and what is mean by assault? So 3 terms come to my mind as a concept. One is a rape, one is assault, and one is violence. Now, criminal law, if you see the concepts under criminal law, these 3 concepts have different connotations. Rape probably has a connotation of sex. Assault is wider than sex, and violence is more wider than that one. So therefore, legislature has not exhibited its wisdom and reasoned way why they wanted to change the nomenclature, the caption. It is mystery to me. I've tried to look into debates. I've tried to look into Law Commission reports as a student of criminal law. As I said, I've been trying to understand criminal law since last more than 4 decades. So therefore, having said this one, now this exception 2 to section 375. If you look at the rape as such, as understood by us, students of criminal law, teachers of criminal law, advocates, judges, and NGOs, it is generally said as the forced sexual intercourse with a woman, forced, against her will, without her knowledge. And therefore, if you look at the rape laws 375, as elaborately amended in 2013, it pursues that, it gives an impression that 375 talks about forced sexual intercourse other than assault on the dignity of a woman. Is assault on dignity of a woman. So it goes beyond merely sexual relation. And interestingly, from the day one, Thomas Babington Macaulay and his colleagues, 1835 onwards, this young chap who tried to codify criminal law for India, that time he was a briefless lawyer. He came as a first law commission chairman along with his colleagues. He tried to give us Indian Penal Code. He worked for 25 years on this code. I must salute him for his vision of Indian society and social ethos. This is the only law which is least amended so far in India, least amended. So therefore, now if you look at this exception they have called from the day one, that exception is sexual intercourse by a man with his own wife is not a rape. His own wife, not a rape. And what Indian legislature has done so far, only they have amended, it's cosmetic amendments. They have changed the age. And it was 9 years, then 10, then 12, then 15. Now Supreme Court in its wisdom created 18. You know, independent thought was Union of India. 18. So this is a kind of judicial lawmaking. Of course, there's a debatable question. The Supreme Court have power to rewrite the law. There's debatable question. So therefore, now if you look at this marital rape, where husbands are allowed to rape their wives with impunity. With impunity. Now, what would be the rationale behind it? What would be the rationale behind it? Now, if you look at the starting point of this one, this whole rationale emanates from two jurists of 17th century. Justice Matthew, who gave an interesting proposition. Of course, this was just an arbiter. No case came in front of him. But when he just made an observation that husband has a right to rape his wife or has a spousal intercourse with her with impunity in all circumstances, because by marriage, she gives her irrevocable consent by marriage. So the moment she ties marital knot with a man, she forever consents for spousal intercourse. This is what Justice Matthew said, and that has been the starting point of this mysterious exception to Section 375. Then William Blackstone came on the scene, and he brought a kind of new idea. The moment a woman marries a man, she gets united personality with her husband. So unity of persons. And he brought in the doctrine of coverture. She is under cover of man. She's under cover of man. So these two jurists, in fact, are responsible for introducing this exception and giving us impunity to rape our wives. Now, is justified in this 21st century. In addition to this, you find the two prominent perceptions of British society when Indian Penal Code was in the making. Now, they said that any carnal knowledge outside the bond of marriage is unlawful, outside the bond of marriage. And marital rape is within the bond of marriage, and therefore husband are not punishable. Then second proposition or perception was that time prevailing was woman was considered as a property of man. And therefore, 375, in a way, has protected proprietary rights of a man rather than the sexual autonomy of the woman. But nevertheless, in the Britain itself, 3 exceptions were caused subsequently. 3 exceptions. One was that no man or no husband is allowed to cause grievous hurt or wound his wife when he indulges in spousal intercourse. She doesn't have that right, even though he is immune from liability for raping her, but he doesn't have this right to cause grievous hurt or wound her. These are other first exception. Second exception, that he doesn't have a right under marital exception to have a forced fellatio. No way. It comes to unnatural offenses. Third exception was husband had no marital right of sexual intercourse with separated wife. And we took how many years, more than a century we took to bring this amendment in the Indian Penal Code. Look at our progressive legislative journey. We took more than 100 years to have this provision in the Indian Penal Code. So therefore, as a student of criminal law, I think that this Victorian sexual morality mores or moral principles entered into Indian Penal Code as pursued by Macaulay and his colleagues who drafted the Indian Penal Code. But subsequently, the same legal fiction that for irrevocable consent of wife has been extinguished in its birthplace. 1991, in R versus R, House of Lords very quietly said, expressly said, that this fiction, legal fiction, which Matthew gave and Blackstonian willingness, the doctrine of coverture, is objectionable, is not acceptable to any reasonable man, and therefore they said that marital exception is not at all was a part of law of England, and therefore they overturned the common law fiction. 1991. Now, Indian Parliament, even 3 decades thereafter, is bothering itself to or not to be. And if you see the kind of affidavits the Indian Parliament and parliamentarians have made on the floor of the House, they are not in favor of taking this exception from 375. They're not in favor of. Read the statements given by Smriti Irani. Read the statements given by the Home Minister. Read the affidavit filed by the central government. They are not in favor of taking this exception from 375. Now, interesting justifications they gave. I'll come to this one and I'll pose certain questions for the audience to deliberate on. Now, when you talk about review of this marital rape, let us look at what law commissions have said. Law commission is supposed to be a body of learned persons and retired judges. Now, look at what law commission has said. 5th Law Commission in 1971, which for the first time reviewed the Indian Penal Code to bring changes. This first law commission, 5th Law Commission, recommended that marital rape exception be taken out of the ambit of rape and should be made punishable. 1971. Then 9th Law Commission, in its 84th report of 1980, declined to support 5th Law Commission. They said, no, we will not support this kind of proposition. Why? Because this kind of legislative reform would amount to excessive interference with the marital relationship. That will spoil the marriages. Now again, 15th Law Commission came on the scene in 2000, Sakshi and other things which you know probably. Now, this law commission again endorsed what 9th law commission said. No, we should not take it away from 375 because that will amount to excessive interference with marital relationship. Now look at the kind of the so-called learned judges and the lawyers who sit on the law commission. The kind of perception which they take about husbands and their right to rape their wives. They said, no, it will destroy the marriage sacred institution. Now, then J. Sorma committee report came in 2013, post Nirbhaya, and he was a progressive judge. And he said, no, that should be taken out. That should be taken out from 375. And he gave 3-4 reasons why. He said that the relationship between the man and the victim in rape cases should not be valid defense. That means husband should not get in special status to rape his wife. Second reason was the relation between the accused and complainant should not be made relevant in inquiry whether complainant has consented to sexual activity or not. The third ground, they said marriage should not be taken as a mitigating factor to lower the responsibility of the husband when he remarries. But interestingly, again, look at the parliament's progressive thought. When they amended 375 2013, they have changed. Clauses A, B, C, D came in definition of rape, which was earlier not there. They have gone beyond the penile penetration. When they read after 375, they did not pay attention to what Justice Verma committee said. They retained it, and they did not give any kind of thought to take it away from IPC. Now, again, why I'm saying it emphatically, because that shows the way Parliament looks at the status of women under criminal law. They are opposed. Now, see the arguments which have come forward. Arguments for not taking it away. They said the common law fiction that wife gives her consent forever holds good in India. That legal fiction which was buried in England itself in 1991, our parliamentarians say in affidavit that this legal fiction holds good in India. Now, I have some kind of reactions for you to deliberate on. Now, this kind of exception really reinforces the kind of legal fiction which was buried in England in 1991. Now, this is one. This second reason which they have given is that this needs to be retained in 375 to protect the marriage institution. To protect. I'm giving emphasis on the word protect. Now, does it not imply that marriage is linked with sexual relationship? Is sex an essence of marriage? The way in which parliamentarians think and the way in which the affidavit is given to the courts, probably they think that sexual relationship is a must to keep the marriage ongoing. And probably I, as a student of criminal law, I try to look into other laws. Probably what Parliament thinks is right, and because we do have question of conjugal right. Spouses do have right. Okay, probably in that sense, probably I get a feeling that sexual relationship is must to keep the marriage alive. The third reason which comes from not making these reforms is the victim wife has adequate alternative remedies available to her. Probably they are referring to Domestic Violence Act, they are referring to marriage laws, they are referring to 498A. They said, okay, she has available 4I to get a relief. Now, then just give it 2-3 minutes, because I'm speaking in telegraphic language, in fact, telegraphic language. Otherwise, I can speak on hours together on this. Now the other one is that The fourth reason which came from the parliamentarians for reading this one is that if we take it away and if we criminalize marital rape, probably with a lot of certainty, wives will misuse it. They'll misuse it. And what they rely upon is Law Commission's report on 498A. The Law Commission has statistically said that 498A has been abused by women. Anyway, probably that gave a kind of ground for parliamentarians. Now, therefore, having said this, I have some issues. Now, is this a kind of masculine power which Parliament wants to retain it? This is one issue. Second one is it a kind of conscious process of intimidation? Is it violence? Or now, therefore, what you need to look at? Now, as Rashmi Mohammed was trying to say, if you look at right-based approach, human right, dignity, bodily autonomy, freedom to have a sexual choice, probably that would lead to a kind of thinking towards taking it away from. Now, if you look at the NCW question, deletion of marital rape, deletion. Now, deletion means that you are relying upon the parliament to delete it, which is reluctant as I see. Now, therefore, deletion or declaring unconstitutional. Now, here we have two alternatives. One is judicial forum, other one is legal forum. One leaves to legislative prudence, while other leaves to judicial prudence. Now, assuming that if you do that one, now I have some questions to raise. Now, what are the definitional contours of this marital rape? Because if you want really to criminalize it, you have to have definition of this one. What should those contours? Probably that need to be discussed. Now, then consent, what does it mean? Whether wife has given consent, not a consent. Then standard burden of proof on whom it will lie when you make marital rape as an offense. Then last one is what's the quantum of punishment which you need to prescribe for this. So therefore, I have raised these questions for these learned participants to ponder upon and to make a suggestion to NCW that if you are really serious about review of criminal law vis-a-vis status of women, we should address with these questions and we should make recommendations to NCW and through NCW to the parliament that this needs to be effaced from the penal code. Thank you, ma'am. Sorry, I have taken more time.
Thank you so much, sir. Being a world-class scholar in criminal law, I think this is expected of you, and also a very balanced kind of approach on both sides is something. But sir, when it comes to a segment of society which is being affected by it and had no voice for centuries in lawmaking, in the Law Commission also, or in not a very significant representation of women in the Law Commission as well. And in Parliament, now it is entering more than 2 digits. So, I mean, does history justify this? Therefore, the silence, time has come to break the silence. Probably National Women's Commission is the bulwark of this whole legislative silence and legislative hypocrisy. 10 women in the legislature cannot be the voice of millions of women in India. Therefore, a learned body like this needs to be, if not taking a balanced pro and con view, more discriminatory, positive discriminatory view towards women. That is why, as you rightly said, the human rights argument in independent thought judgment, particularly from the child's right, I mean, young wife who is not even mature, who has to bear with the physical, as you said, irrevocable consent for a physical relationship, needs to be recast in the time when women can express their choices as well beyond society imposed circumstance of marriage. And marriage as an institution, if it is of concern, yes, we agree that's the best institution for upbringing of the offspring, for future generation, for cultivation of citizen. But can marriage be built on the tomb of somebody's freedom and dignity? is also a question to be deliberated on the side. Therefore, we urge the poll to go on based on the pro and con arguments which have come here, and the deliberation that Women's Commission has asked. My suggestion is that in the past also, when 498A was going to be diluted, it is Women and Child Welfare Department which stood up, and Women's Commission sent an objection. Today also, I would suggest that in the recommendations, that sense should prevail, where the silence has been not because of, silence doesn't mean fairness. Silence means that a segment was never having a voice or expertise to come into the public forum and discuss, I would say, for centuries. Over to Jain sir. Yes.
I don't know whether this August gathering we like or not, but there are other way also to think of it. Being practicing in criminal law for 50 years, I will request any of you to attend the courts who deals with the criminal bail applications regarding the women offenses against women. And you will find the solutions that what the law should be. The reason that it should not happen that under the pretext of consent will destroy the family or marriage institutions. If a person is scared of such things, then he will say that what kind of consent you want? Whether oral consent, written consent, then written consent every day, written consent on promissory, on notarized, written consent on registered. What kind of consent you are expecting? That shows, you see that in the family law, there are father, mothers, grandparents, we are having so many things. Only to say that liberalizations or this exposure, we should consider the second way also. While framing the law, it should not happen that after going from here to my office, I will say that all women's or the ladies, juniors and everything should go out of my office. I don't want any kind of the risk. The questions I have come across various cases, I can say few or something here and there. A leading law firm, Ernst & Young, not getting the promotions, not getting the favorable CR and everything, cases were lost. So what I will say is that make the law then. I have nothing to do. But then there should be always a precautions warning at police stations and everywhere that if somebody is filing a false case, because such kind of the cases, see the mental tortures under which the persons will be going if they will go on years together. So if these offenses are there, they must be tried within a month, complete trial. And if somebody is filing a false case, false complaint, then he or she who is instigating, abetting or doing it will be punished with the same punishment. Because otherwise it will be a one-way right that file a complaint and get the persons tortured. So, and ultimately, let me with respect say that don't blindly follow what the European countries are doing or what British or what others are doing. Indian is a society with a culture and so many other things are concerned. And so if we want to make a law, don't make a fearful circumstances or environment that nobody will like everywhere and one have to go in isolations or everywhere. Rightly, if I say so, 498A was a welfare legislation, it was a need. 304B part 1, part 2, it was a need. And that is there because so many, and all the acts are concerned. I will say that they are for the betterment of this life, maybe women, maybe child, maybe all others. But always kindly think that we should not destroy the fabrics of the society, fabrics of faith, fabric of confidence, and fabric of everything. And therefore, while legislating, it should be in such a way. Don't try to show everything that yes, liberality and everything, so remove this, remove that. And that will give you. So kindly consider this aspect also, so that it should be there. Thank you for giving me, putting the other side of it.
Thank you, sir. Yeah, thank you, sir. But I would also like to remind that legislation or laws are meant for, as Salman says, recalcitrant minority. A virtuous person may never attract the law. So let us not forget that also, that if somebody has this experience, then the law should be making way for that person to seek justice. Therefore, I agree with you that legislation should be there. There should be proper checks and balances. Yes.
Just one observation.
tradition, under the guise of our great culture, women have always been put down. Yes. And that is not our culture. If you look at the history of women's status through, say, Vedic times or even before, women enjoyed a lot of independence, choice in marriage and everything. They were free to walk out of marriages, they were free to choose their partner. So don't put these things, because these are typical patriarchal ideas, what we spoke about right now. I'm sorry.
Yes.
These are typical patriarchal ideas which will force women down again, and we are not ready to go down, please.
Only
We
one
fought
sentence.
a long war.
No, only one sentence.
No, just let me complete.
Yes, please complete.
Just let me complete. Being an activist, I will not be put down. You can feel sorry that you called an NGO person. Secondly, no. The thing is, when I said women will not be put down, is also another observation I would like to make. Just look at the institution of marriage from today's eyes. It's almost redundant now. You know, the concept of marriage, because living relationships are coming in. I'm seeing a lot of child victims of these broken marriages. Yes, there is another side where you teach women and men to assert their rights. This is bound to happen. So probably many learned people in social field, medicine, everybody is saying that marriage is now a redundant institution. People can come together, and in fact, if you read certain researches by, say, Dere and all, Lajja Gauri is one book I will recommend for those who understand Marathi. It was always men and women who came together for procreation, and if they wanted to stay together, because the humankind had to go on, and they separated. Fine, this is a lovely concept. We can go back to it, but just let's not harp on the wrong concepts of culture. It's a wrong, absolutely wrong concept of culture being, going on and on for ages to put down women.
Only two lines. We had been taught from the childhood that women are source of wisdom, wealth, and strength. So if somebody said we had been taught right from the beginning to respect women's, exceptions are always there, here and there, but exceptions cannot be a rule. So keep it in mind that whatever we will do, if somebody says that marriage institution is to be destroyed on all these things, that is a personal view. That is a different thing. Then you go on up with the legislation that marriage institution should be dissolved, Hindu Marriage Act or all marriage act should be dissolved, no marriages and all this. It will result in, so far as that part of concern, that there will be a chaos. So don't try to put the things. I am saying, this is my view. There are other sides. Whenever in the parts of, we have no time at present, but I can give 100 and not 100, thousands of examples. So the question is that let us try, if we are discussing with the presumption that marriage institution is to be destroyed, dissolved, then that is a different thing. Everything can be put in. But if marriage institution is to be kept, then we have to keep it in mind. Thank you.
I think we have a very interesting discussion here.
Madam,
I'll just
please,
one line that I think on the one hand, you are saying that marriage should not be, one should not go to an extreme of destroying marriage, which is your concern. And ma'am's concern is one should not harp on marriage to such an extent that individuals are destroyed. Those individuals who don't have the power. Finally, marriage is also a power game, sir. And charity begins at home. We have to rectify our homes and relationship. Over to you, sir.
What I just get impression from what Advocate S.K. Jain has said is that this is a debatable issue. We can debate for weeks together. That is not a problem. But what we can think right now is that we should have a balanced approach, so that women should not be subjugated to lose their identity, autonomy. They should not lose their voice. And at the same time, we should protect the marriage and institution. I'm not against that one. But still, what we as a thing, academicians think that we should have kind of somewhere starting point. If suppose you look at the culture, Indian culture, which Advocate S.K. Jain is talking about. Now, in our culture, untouchability was a practice. We removed it through law. Bonded labor was our culture. We removed through law. Okay, bigamy was our culture. We removed it through law. Why can't you take it kind of step at least? A step at least. Maybe that's why I said that what we need to deliberate on is, okay, delete from Indian Penal Code, but at least try to give kind of definition of marital rape. It requires a lot of serious discussion on this. What should the contents of marital rape? What defenses will be available to the so-called husband? What remedies will be available to the victim wife? And what should be the kind of social? And therefore, what we need to, Madam Chair, what we need to deliberate on this, because this is what a straightway question, deletion. Now, the moment you delete that one, you should have substitute for that one. A substitute should not be worse than the exception. Should not be exception. So therefore, now here what you have to think about constitutional morality and social morality versus these two. Constitutional morality, which is based upon preamble to the Constitution, Article 20 and Article 14. Social morality is that what society thinks of. And then if you want to look at social morality, then please remember what Lord Devlin said. Those three questions.
Now that point will come when Professor Purvi is coming into discussion, both that and the gender neutrality. Let us listen.
Yeah, there has to be balanced up.
Sharma ji has something to add. Please do it, and I'll just mention some points. I don't have to argue in favor of either of the propositions.
No, what sir is telling, general rule, we have to give protection to women. In some cases, misuse is there. In case it is misused, protection should be given to the accused also. It is happening in 498A. It is non-bailable. But Supreme Court itself has said several daughter-in-laws are misusing this. Supreme Court itself said, and they made it bailable. So in case any exceptional cases, protection must be given to the accused. That is his argument, I thought. That's all.
Okay, I have 3 points to make and one prophecy. I have consciously used this word. 3 points and one prophecy. Okay, I'll do that. See, as it has been spoken right from Professor Dicey, that legislature's voice will be the voice of community. So if today community wants this change, it will take place. Okay, second point. Community legislature will think of a corollary of this amendment. That is, put it as a ground of divorce. It won't happen that a husband will be convicted for marital rape and still he will come and have conjugal rights restoration. That is second point that I am making. Thirdly, everybody don't undermine the importance of family. Considered what Bertrand Russell said. He even went to tolerate extramarital relationship for conservation and preservation of family, and not an Indian thought. This has nothing to do with Indian culture. And now fourth point, prophecy. Let that amendment come. Amendment will die, not the family.
Thank you, sir. It also depends on how we construe the family. We have different connotations of family coming up as well. We will not forget that. Yes, in live-in and other contexts. So probably we'll have to take the cognizance of that in terms of co-creation of family, chosen family, fluid family. These new concepts are coming up. So, and with the intervention of technology as well. So let's go ahead with the proceeding.
Please just take a vote on this question number 5. Points for discussion. Should the marital rape exception of 375 be deleted?
Sir, that question has been answered sufficiently by all the experts like you, sir, and ma'am.
So what, in affirmative or in negative?
No, we have put it for poll also. We will just send the report. It is for the Women's Commission to make the recommendation finally. Yes, there are 800 responses coming from online. And then we have our rapporteurs noting down all the viewpoints. Finally, it is for the commission to take the call. Yeah. We are here only consulting. Yeah, thank you, sir. Now, quickly, keeping eye on the time intact, we are going ahead with cyber dimension of sexual offenses. Because so far we dealt with the classification idea, different types of sexual offenses, and the history was beautifully laid out and all that. And also the sentencing approaches to this. Any point left out we can take up afterwards, but let Advocate Puneet take over the podium now to give her views on cybercrime as a trigger, COVID time cyber crimes, victim impact, I mean, after that, we'll come to our professor's research in terms of victim impact statement. Yeah, over to you.
No. Okay. Good afternoon. I'm really glad to address on this matter, which is absolutely close to me, on the impact of cybercrimes on women and children. I won't say the impact is not there on men. Honestly, there is an impact on men also. But what tends to happen if we see the statistics is women are comparatively victimized more than men in online forums. And the degree of victimization is also comparatively higher. So it's more from that comparative perspective. I would want to start my talk, and I will also end it on the same note. So I will start it basically if the common saying that goes, history is always told by the victors. So even in India, a lot of our scriptures, whenever any invader came, they would completely destroy all the scriptures. So in a nation where goddesses were worshipped, women were worshipped, there was actually a choice of marriage, 7 types of marriage. Today, what are we talking about? Love marriage, arranged marriage, and live-in. We were actually a culture that had 7 different types of acceptable marriages where women also made their choices. Today, it's sad, but we have become a living relic of what our invaders wanted us to become. They created a history which told a version about how Indians were, how our culture was. We read that, we believe that, and now we have laws trying to regulate this perverse version of whatever we have become. Coming to the COVID times, honestly, that was the worst phase, I would say, for people. Apart from the fact that, okay, the disease itself, it manifested human nature in India, especially in the worst form. A 700% rise against crimes in women online. That's a disaster. In the last 5-6 years, we already saw a 400-500% rise in crimes against women. But COVID seemed to be a trigger which brought out the worst in everybody. So maybe idle mind is a devil's workshop. You have nothing else to do. So you're just sitting on your computers, on your laptops, and whoever are the people who can be victimized by you, it becomes an easy opportunity. The kinds of crimes obviously went on the rise. So let's say if 3 years back, you would have asked me the crimes against women online and what I would be talking about today, there's a drastic difference in my approach. With respect to legislation, it's the need of the hour. Now, I would be going through the different offenses very clearly. And why I would say it's the need of the hour, because if action is not taken, there will be a problem. Now, there is some amount of action. Now, for a matter of fact, if you would have seen the intermediary rules of 2021, that's exactly the book I gave you in the break, which I had authored. These rules were enacted in a bit of a haste. Everybody said, why? Why wasn't it debated? Why wasn't all of this done? Now, this was also enacted at the point of time when, during this COVID phase, the number of cases against women, especially with respect to online platforms, revenge porn, everything was rising. And there was no option there for women. What would you do? You will run to a court to take a takedown order. You will go to a police station and show a video, which is possibly not even your video. It's a deep fake video showing you in some nude form, and then going about asking them to take it down and showing 20 other people. 99% women already feel miserable by that. It's like a virtual rape in itself to try to go on showing people such kind of content about you. So that was one of the key reasons why these rules were so hurriedly enacted. One of the major points that I would like to bring about over here is the amendment to these rules itself. I'm very glad these rules were enacted. But if you see, even the High Court, even the Supreme Court has pointed out that one of the points I would want the National Commission to make, that there are provisions in this where intermediaries, especially with respect to nude content, with respect to women, content which is derogatory to women, upon receiving a complaint, the grievance officer has to, within 48 hours, pull down that content, in some cases even 24. Now, let's say an intermediary platform doesn't do this. There is no penalization in these rules. There is no compensation. So how are you going to enforce it? Yes, you will say the platform may lose its intermediary protection under Section 79 of the Information Technology Act. Now, for that, a woman will go and file an FIR in the police station. Again, this intermediary has violated my right, etc. You're making her get drawn into a full-blown litigation again. So the entire objective which we started with, trying to protect, as a matter of fact, the government of India had even put up before the United Nations when these rules were passed. So there was concerns raised by the United Nations with respect to its constitutionality and validity also. And one of the key reasons the government had put forth was that these rules are meant for protection of women and children. Then one of the most important things that has to come about is penalization of these intermediary platforms. Today, these platforms are monetizing on your data. You see a lot of these apps, platforms, they are using this data. The more viral it becomes, the more eyeballs they are getting at the cost of women, at the cost of children. So penalizing, compensating, bringing them to book, that is extremely crucial. So one of the crucial reforms I would want the NCW to really take forth is the intermediary rules are good, but it's like a tiger without teeth. How are you going to really force these platforms to stop monetizing? Take your job seriously. Take the example of Twitter itself. The rules came about, so many intermediaries have till date not got a grievance officer. Twitter was brought to book by the court, is why even after so many months, they finally reluctantly appointed a grievance officer. Today, you have so many intermediary platforms, and how many of them really have a 3-tier mechanism to deal with a woman's complaints? Today, again, she's running to a police station, she's running to helpline, she's running to NGOs. When the first point of contact for her has to be the grievance officer, please pull down my content, and he has to comply. It's not there. So give the tiger the teeth that are necessary. And that is actually going to be the way forward for women's empowerment in using digital platforms. You give a woman a mobile doesn't mean you're empowering her. You make her safe in the online space and tell her if something goes wrong with your content or something, this is the way you can redress it at one click. There you have empowered her. That's the step to empowerment. So give the tiger the teeth and empower a woman in that fashion. Coming to the new age offenses. Cyber stalking, already the Indian Penal Code was amended to include cyber stalking. Now, one aspect is it's only with respect to women, because I would say a lot of Bollywood movies have completely made the whole story that a man woos a woman and ends up stalking a woman, which is somehow in a very weird way romantic. No way actually that it is. Strangely so, in the digital world, women are also doing that. So whatever the common perception that's happening, people may believe cyber stalking only happens to women. Cyber stalking also happens to men. And there are umpteenth number of cases of that. Sadly, there is no provision under which we can actually file a complaint apart from harassment. The police also doesn't take it too seriously, because how would you really justify that? And I have personally seen a case. There was a doctor who was harassed, and this is just one of the cases I'm talking about. And a woman who so-called wanted to marry him met him at some conference. Now, how do you know the mental state of any person whom you meet? So a simple exchange of numbers, the way we normally meet people, led to this woman stalking him on Facebook, on Twitter, almost everywhere. You don't know who's stalking you online. Do you really know who's viewing your profile all the time? Do you know who's watching your last scene on WhatsApp? This led her to do this continuously, which led to further kind of engagement from her end in whatever in her mind she had. Her attempting to commit suicide when he is not responding to her messages. And the harassment this doctor ended up facing in this, to the tune where she went and filed a complaint, him almost losing his license. So cyber stalking is not an offense which is only against women. There are men also who are stalked. And this particular provision, 350-40, has to be more gender neutral. It has to cover both aspects of where women also could be cyber stalking men, and obviously even the third gender, which we talk about. It needs to have protection to all genders and cannot be only with respect to women. Coming to the next offense I would like to talk about is revenge porn. Now, this has been one of, in the last 3 years, especially during the COVID period, as what I mentioned, the idle mind is a devil's workshop. I'll just give you one example of one of the cases that I came across. A young model, and coming from a very good family, a young model, even the parents are very well known in the industry of, the acting, etc. industry. This young model wanting to make a career ahead, and one fine day, she receives a message of a clip of hers when she was 18 years old. Almost you could say a 7-8-year-old clip that comes to her on message, with somebody messaging her saying that, if you do not give me some more clips, I'm going to make this go viral. Then thereafter, you pay me 50,000 rupees. And she's scandalized. Where did this clip come from? This is something which was when she was 18 and she was in a relationship. And at that point of time, today, youngsters actually exchange such content. Interestingly, when further investigation happened, the police looked into the matter. It turned out to be somebody from her past, the ex-boyfriend, when she was 18, woke up during the COVID period. And what was his justification? I was getting bored. I found this clip on my phone, so I just thought of messaging her and harassing and having some fun. Imagine harassment just for fun. That's exactly what we're talking about in revenge porn. Now, revenge porn also happens against women. It also happens against men. So there is a lot of porn on pornographic websites, which is homemade porn, which is actually taken from people unknowingly. There is no consent. So women also do upload and men also do upload, though against women, this is on a larger scale as compared to men. Now, when I was talking about this harassment, a simple case why I gave you this example where the boy ends up saying, I was just getting bored, it's for fun. Now, why is it in a country like India, somebody is able to do this just for fun? Because we had a section 66A at one point of time, which is struck down now. Section 66A, which penalized such kind of harassing messages, content. Today, somebody can, without your consent, message you anything and everything and get away with it. And what are you going to do? What is the classification of harassment? No definition. That was the exact reason 66A was pulled down. But the sad part is it should have been amended. It should have been remodified, or a new provision should have been introduced for cyberbullying via messaging. Today, let's take an example. We have Mr. Praveen here and somebody messages him. Let's say, hello every single day. How is your day? I can see you every day. I think you look good every day. Isn't that harassing for you, Mr. Praveen? Now, it would end up becoming, it is harassing, right? Every single day, this kind of a thing happening is harassing, irrespective of gender, man or woman. Now, this form of harassment on message, when you do not want a person to contact you, unsolicited contact itself is harassment, cyber harassment. And the more today we are getting digitalized, all of us have multiple instant messaging accounts, etc. So imagine the amount of attack vector you're providing to a person who can just harass you and hammer and play with your mind all the time. At some point of time, I'm quite sure it would play with Mr. Praveen's mind. He would be sitting over here and be thinking, oh my God, somebody, again, that person has messaged me. When I'm going to go home, that same thing would happen. Sure. Sure. So these things are very important, where section 66A should be also either modified, amended, and this was always on the cards for the government, but it never happened, and it should be made possible. The next is with respect to deep fakes and flashing. Now, these also are new offenses that came about only in this COVID period. Deep fakes, where somebody's picture is picked up, let's say from social media or LinkedIn or any of these platforms, and then there is nudification of these images. There are multiple apps which actually provide this, easily available on app stores. Problem in India, we don't have an app regulation law. It's still in the pipeline. Absolutely needed. Why are such apps even available to people is the first question, which are enabling people, empowering people to create deep fakes, create nudes. Obviously, everybody is aware of the bully bye case also that happened. So a strong app regulation is very important. Spying apps, which I always say, app regulation will also end up covering that, where a lot of these applications are spying on all your data, even your private data, which is there in your cell phones and devices. Another major technical point I would like to bring about is certain offenses like sextortion. Now, as a matter of fact, even my learned colleague, Mr. Sharma was talking about consent. Now, when we are talking about sextortion, there is an initial consent when people are having cyber sex. Is the consent there for the recording? The recording which is leading to an extortion. So this is like a combinational offense of 2-3 things. There is a consent for the act online, but no consent for the recording of the act thereafter. Now, how would you really classify something like this? A very clear definition of something like this has to be included within the current provisions of either extortion or under the definitions of sexual assault. Consent over here, how would you really validate whether the consent was free or not? Because in many cases, there is child grooming that happens. Many cases, there are women who are forced to share such kind of images and acts online also. So there it becomes a serious issue. And in my opinion, it should be included in the definition of extortion in the Indian Penal Code, to include this kind of extortion with a very clear definition of what consent would constitute a valid ingredient under this offense. The next very important thing which I was talking about, which I wanted to touch upon, is intermediary regulation. We do have intermediary regulation, but how many of you would have seen, let's take a platform like YouTube. I see that. I have a young daughter, 1.5 years old, and I see that suddenly in the middle of nursery rhymes, you have a raunchy ad that comes in. Now, why exactly this kind of content? Lack of content regulation, which is depraving young minds. During the lockdown, I'm sure all of you saw OTT content. You saw different programs which had open nudity, poor language, and all of which, and we have the intermediary rules over here, which are giving them a framework. But where is the penalization again? Today, when they're putting up such content, it is there. It is there definitely. They're not promoting it in the top 10. The content is there on these platforms. Where is the penalization for such content? Today, if a movie does this, if a TV serial does this, would they be able to get away with it? No. A lot of OTT platforms, even now, despite the rules, are getting away with this. So I would come to the end of my talk with this, wherein I would like to really urge that NCW with respect to revenge porn should have a separate helpline. Now, the reason I say this, a helpline which would be able to enable women. Today, a lot of women don't even know that, okay, there can be a grievance officer, whom can they contact on the platform for taking down that content. So a helpline from the NCW level itself would be one of the biggest initiatives which can help. You have started that. That is absolutely great. Please do promote it, because even I was not aware of this. No, I had actually recommended this in my previous thing also, that please have a helpline, but I wasn't aware if they have actually implemented it for revenge porn. That's awesome. I'm glad my recommendation was taken. Last year, I was harping on this completely. That's why I was again reiterating. Yeah, please do, because even I was not aware this was implemented. So I'm happy one of my recommendations is implemented. I'm really happy about that. Oh, no, but promote it even for revenge porn so that women are aware. And along with, okay. And psychological counseling for the same, if you could definitely do that, that would be really great for women. And with this, I would come to an end, and where I started my discussion, which was with respect to how exactly, the history talks about the story of the winner, the version of everything that the person who is the victor wants to promote. I would like to close this with, end of the day, we have become those people is what I started my discussion with. Today, it's your choice what you want to make your son and daughter. With respect to the digital age, you cannot avoid them being there, but how you train them, what you teach them, that is of key importance, and how you groom them to respect the other gender online. So respecting them physically, all parents are teaching. Respect digitally is what you need to start teaching now. Thank you.
And quickly we go to, as the polling is going on, quickly we go to Professor Atmaram and team to look at two themes quickly, 5 minutes. One is victim impact statements during sentencing and role of compensation, especially Manodhairya scheme kind of. One is Manodhairya per se, and could we explore it for afternoon session on maintenance is what I was talking to District Legal Aid Services. And second is on the category of offenses like stalking, liability person present who fails to prevent the commission of the liability of the person who is present and fails to prevent misogynistic hate speech and insulting modesty of women. After that, we'll come to Advocate Jain sir's learned contribution. Yeah, over to you.
Thank you, ma'am. Honorable Justice Ambada Joshi, sir. Honorable Sharma, sir. Honorable Dr. Shashikala Gurupur, and Honorable resource person. We got two topics to discuss. First is impact, victim impact statement. So right now we are not going to discuss about jurisprudence, background, or section per se. We are directly leading to the recommendation. Because you know the section already, and there is lack of time also. Now, recently in Karan versus State of NCT of Delhi 2020, the High Court of Delhi has referred the victim impact statement, and according to High Court, it shall be made compulsory. Right now, we have provision under CRPC, that is section 235, wherein the this one hearing to the accused is given, but hearing to victim per se is not given. Lawyer is given definitely. Now, this victim impact statement is implemented effectively in America, in Canada, in Australia, and in many other European countries. As part of the victim impact statement, there shall be financial assessment statement, wherein actual loss, hospital bills, loss to the wages, etc. may be considered. Second part of the victim impact statement shall be psychological assessment, which will be done by the expert. Third part, which is not considered, that is damaging the capacity or disability to the person, that is the victim. Now, in Manodhairya case, this point is being considered partially, but for the punishment part, it is not being considered. Fourth point need to be considered under this victim impact statement is impact on the future prospect, like marriage, like employment, etc. Next thing which is not considered in criminal justice system is secondary victimization, in India at least, wherein if there is something with respect to sole earning person of the family, will take care of the children, etc. is not being considered in criminal justice system in India, that need to be considered as part of the victim impact statement. And other things like pregnancy, transmission of the diseases, etc. may be considered. Now, this victim impact statement shall be used at 3 levels. 1, while providing sentence in sentencing. 2, while providing compensation from the accused person, if accused is capable or having money to provide the compensation. Third, very important thing we want to recommend is maintenance of the victim, which is not being considered in the criminal justice system in India. Now, this victim impact statement shall be done immediately. It shall be a time-bound process, and it shall be implemented by the state as first level. Because after proving offense, prime facie at least, the liability can be imposed on the accused person. Before that, state has to take care of the victim. And therefore, this statement shall be utilized by the state. Not only because it violates Article 21, it shall be considered because it is failure to maintain law order situation by the state, which is primary responsibility of the state. And this shall be auto and time-bound process. Right now in Manodare also, compensation is paid. Sometime it is delayed, sometime it is not paid, and therefore it shall be auto. Auto means the officer shall go to the place of the victim rather than victim is coming and making application, etc. Now, after that, there is section 509, which was allotted to us. It is relating to modesty of the woman. So we under IPC, we have section 509, wherein insult to modesty is considered when there is a uttering word, sound, gesture, or exhibition of the object. Now, first suggestion with respect to this section is it shall be gender neutral because word woman is used. And therefore, this section is not being utilized till today by men and by the members of eligibility community. Second, in this section, word intention is used as part of the mens rea. So whoever is intended to insult the modesty of the woman, that is the wording used. We suggest that apart from intention, word knowingly and reason to believe shall be incorporated as part of 509. Apart from that, on internet also, there can be violation of modesty. It is not only uttering word or gesture, etc., which is physical act. It may be by uploading, by forwarding, by exhibiting the image, etc., which is online or digital. It may be with help of meta tag or linking, framing, or by using sexual oriented words and linking that words with the profile of the person. So somebody is typing that word rape, for example, for any information, the profile of that person may appear, and that may lead to violation or insult to the modesty of the person. It needs to be considered. And apart from that, if there is violation of modesty on any social network like Facebook, Instagram, etc., that need to be incorporated as part of section 509. And there shall be different punishment for the second and third level offense. So that are general recommendation with respect to that. I'll take one more minute, ma'am. Next section is about 354E, that is liability of person for in case of failure to prevent the commission of offense, which is part of 354, 354A, 354B, C, and D. Now, under this section, what is the requirement? Presence of the person is required. But in case of digital offenses, presence may not be there. 2, if person is not able to prevent, then information shall be provided to the police officer or to the magistrate. Now, with respect to this, our recommendation is now physical presence may not be required in some of the cases, and therefore knowing or knowledge and reason to believe. These two words shall be incorporated as part of 354 capital A of Indian Penal Code. And if it is forwarded on social media, etc., and person has some knowledge or reason to believe that it will violate the modesty of person or it will be insult to the modesty of person, that need to be considered. In addition to this, if person is having any authority, different punishment shall be given or more punishment shall be given, more than 3 years, which is part of 354A. And if person is having capacity to prevent the offense, additional punishment shall be provided for that purpose. Third, if person is public servant, may not have capacity, but he is or she is public servant, additional punishment shall be provided for that purpose under section 354 capital E. Next section, which is part of deliberation, is 354, that is assault, criminal force against woman in order to outrage the modesty, and up to 2-year punishment is given. Under this section, we recommend there shall be addition of digital assault, which is not part of the section right now, because it is not physical assault, which will lead to violation of modesty. It may be something which is digital, like scary images coming up on my screen, which may violate, or it is relating to something which may outrage the modesty of the person, it shall be considered, which is not considered right now or under this section. Next was about a little bit discussion with respect to Manodariya scheme. This is one of the good scheme, but it is applicable for limited offenses only, like in case of rape, in case of acid attack, and in case of any sexual offense with respect to children, this scheme is applied. And up to 1 lakh to 10 lakh compensation is provided by the government. Now, there are three basic problems with respect to this scheme right now. One, there is lack of adequate fund as compared to the cases. Two, because of social stigma or fear of outcasting, people are not approaching, victims are not approaching. Three, poor people are not able to take advantage of scheme, and therefore the officer shall go once case is registered. Officer has followed, officer should have liability to follow the case. So it shall be time-bound process. Adequate fund shall be provided. If fund is not distributed by the district legal services, there shall be some liability to impose, or some explanation shall be there with respect to that. Now, with respect to all digital offenses, I will not talk much about that, because in this week only, we have banned multiple apps from China, because that, as Punit ma'am has mentioned, they are taking away our data. They may use or misuse, whatever may be, but definitely they are taking away. And there is lesser liability on the service provider under 79, because exceptions are provided. So rather than following take down approach, which is followed right now, we have to follow take care approach. They have to take reasonable care with respect to data, which is stored on their server, or which is shared with help of this one, their network, etc. So this was from our side. Thank you very much for opportunity.
Thank you, Dr. Shelke. I'm sure the issues have been put up for polling. Meanwhile, I invite Advocate S.K. Jain, criminal lawyer, to reflect on 108 clause 3 CRPC new clause, security from accused for sedition. So any other comment also? SR has already richly contributed. Okay, sir.
When you just made suggestion about 509 and 354E, have you looked into IT Act? Rules made there under?
You are asking about
509 and 354E.
Under IT Act also there are no effective provision right now.
Rules have you seen?
Rules there are 2008 rules are there.
No. Latest rules. Latest rules. Have you seen them?
Not with respect to 79 acts. I don't think there is amendment in the rules with respect to service provider.
No, I don't exactly. I don't remember the rule number, but the latest rules have taken care of your suggestions.
Sir, you may give that suggestion. You may give that suggestion. I have just yes.
Honorable Justice Ambadasji Joshi and all dignitaries, taking effective actions under sections 108 or all other provisions of security for keeping peace and from good behavior. I think that this chapter covers all the things to prevent the mischief. As we know that for an offense is concerned, there is the intentions or motive, then preparations, then attempt, and finally it's an offense. So far as this simpliciter intentions or motive is concerned and preparations are concerned, in majority of the offenses, there is no punishment for that, or it is not amount to an offense. And there the society is facing all kind of the offenses because we think of the offense after it is committed. And then for punishment is concerned when the trial begins, and after only in exceptions, we say that one incident has occurred and within 7 days, the offender has been punished. But the normal rule is that it takes years together. So according to me, now we have to give more importance to preventive actions than the other parts are concerned. Because preventive action is going to protect the society from the commission of offense. And therefore, what we want to incorporate under 108(1) Roman 3 is to bring all these mischiefs under section 354, under the marital rape or all other parts are concerned, for taking a preventive actions. To make it more clear, nobody can do, only in exception cases, there are instances that an instantaneous act amount to an offense. Otherwise, there are preparations. We find that if somebody is chasing the girl in the college, if somebody is doing something, other parts are concerned, initially it is ignored. If the preventive actions would have been taken right at the beginning only, the things could have been avoided. Now the questions come, and what I want to make suggestion is that before whom these proceedings are going on. This is going on before the executive magistrate. And who is this executive magistrate? In the commissionerate area, it is the assistant commissioner of police. In the rural area, it is a deputy superintendent of police. Being an executive post, they have got so many other things to do, and they are giving the last preference so far as these proceedings are concerned. And these proceedings are also going on for months together, in some cases for years together. No doubt there is a provisions of getting interim bond and other parts are concerned, but that is not also effective. So my first suggestions will be that to make it more effective, along with the proposed amendment of 108(3), everywhere, either it should be an independent officer for taking the preventive actions in each commissionerate or in the district, and that also of the rank of deputy commissioner of police or additional superintendent of police, or if possible, to give power to the magistrate court who can take it so far as that parts are concerned, so that they will understand. The second part is that we should fix the accountability of the officers who fails to take the preventive actions in time. So these parts I will request to add it. So far as seditions and other parts are concerned, because for want of timely amendment in security proceedings and preventive measures proceedings are concerned, they were not taken. So all these sections which are relating to the offense against women and all these things, they should be incorporated by way of 108 Roman 3 with subclauses also, so that the cyber crimes, the digital crimes, all these offenses are concerned, preventive actions can be taken. I will put one more things at the same time, that the platforms, Twitter or Facebooks or YouTubes, now because of these present government's actions, they have tried to compel them to have a authority in India who will be answerable to all these acts are concerned, omissions are concerned, which amount to an offense. So they can be called upon by way of a preventive measures, actions can be taken if we find that any of the platform is giving more space for such kind of the digital or cyber offenses are concerned. Then take the preventive parts or undertaking from them, that they will not allow their platform to use such kind of the things either by way of advertisement or in any manner. I will draw attention of this August gathering, as at least as in Pune is concerned, that there are advertisement on SMS and other parts are concerned, which are totally unwarranted. What kind of the advertisement? Even though we have got social welfare department with the police, women's cell with the police and all these things, but every day you open the mobile and you will get such kind of the nasty advertisement for having a company, for having this, for having that. So whether there cannot be effective for preventing such kind of the advertisement, because that corrupts the mind of the youngsters. And all these things are concerned. So I only will say that 108(1) Roman 3, incorporate as much as possible and fix the authority, which will be at a superior level. It should be an authority which will do only the exercise the power for this purpose, and not as one of the power with other responsibilities, so that there can be effective remedy. And also those who are responsible for not taking the preventive measure at the right times, their accountability also should be fixed. Thank you very much.
So with that learned exposition, the polling also getting over on that particular part. As we move to lunch, we have a few minutes left. So before that, we have one advocate who has only slot available now. which is Advocate Uday Varunjekar. He will be speaking about armed conflict and sexual offences, which is one area left under this. And secondly, the compatibility between Section 114A of Indian Evidence Act and Section 376 of IPC. And after that, we will have Madam Sahasrabuddhe, Anuradha Sahasrabuddhe, to respond to the issues from her point of view as an activist. We have a few questions which are given, and these questions will be taken up by Professor Lasya after this. And that brings us to the end of panel 1. I'm just giving you a bird's eye view. I heartily welcome our ILS, famous ILS Law College's principal, who is present here, Mr. Jain. Dr. Jain, Professor, a warm welcome to you. And we are honored to have your presence. And I know that we are going to deliberate in the afternoon on the issues related to CRPC 18 clause 3, which Advocate Jain just now, your area is going to be overall reflections on part 2 or panel 2 issues. Welcome, sir. Now I would request, as per the discussion, sir, you want to respond? Okay, please.
Sorry for intervening. This is question for Advocate S.K. Jain about 1081 Roman 3. Now, disseminating seditious matter. Now, the term itself is very vague and ambiguous. And if you look at the Law Commission's working paper on sedition, working paper which is available on internet, the Law Commission tries to cover up this one. But as an advocate, what I want to know your reflections on the term seditious matter. That is quite controversial and subjective one.
I think that long deliberations will be required because the term seditions has been defined by courts of different countries in different manner. So far as the India is concerned, we have to cover up as much as possible so that we can prevent any kind of the offense against women. Maybe stalking, maybe digital, maybe cyber crime, maybe offense against women in the marital rape or other parts are concerned. So in the preventive actions 108 is concerned, it should be so elaborative that the officer will be entitled to take the preventive. What is preventive actions? That is a security proceedings. If it is brought to the notice of concerned officers by the police officer that he is likely to commit an offense, he serve a notice, call upon him first to give the interim bond that he will not commit this offense, and then to give a final bond if it is proved that he is indulging in such kind of activities. So if at the stage of preventions only, or preparations, I'm sorry, if we stop these persons, then I think we'll be saved. I will make it more clear. As we can find that these acid throwing cases or the rape cases and other parts are concerned, it has not occurred in a day. If that would have been, but the girl must have made complaint to the principals, to the professors or other parts, or to the police station by her parents that this is happening. But the police ignores it. What they say, "Arey kuch hua to nahi hai, fir dekhenge, kai zala hai, kute kai hai." If the preventive measure would have been taken at the first stage only, calling that person's, his parents, and take the bonds, give him a warning and protect it, that girl or whosoever is there, this thing would not happen.
No, sir, my curiosity is not about that one. My curiosity is about seditious matter.
That is to define this part. So that's
now,
what
would you like to rely upon section 124 of IPC for that matter?
Huh?
124 of IPC, would you like to rely upon that one?
No, that sedition is different. That is a war against the state and other parts are concerned. This originalistic and
including dissent, dissent or defamatory comment.
No, not so. This is, and that's why I say that bring all under the seditions and take the preventive measures right from the preparation stage, instead of making the things to occur and to go for punishment. So as it has been said, prevention is better than cure. In the criminal analogy now, we have to give more importance to the preventive measures along with the other parts.
Police may misuse it. They will just put 1083. They will not
rather file the complaint under relevant section of IPC.
That's correct. So the questions will be that, as I have said from the beginning, that the checks and balances are concerned, that fix the accountability on both the sides, not taking actions at the time of preventive stage or taking a mischievous actions. Because as far as the Pune, not Pune police, I am saying about the police at large, all over India. The credentials and other parts are concerned, as Supreme Court has said time and again, and High Court said, that don't hear your master's voice of that political party who is in power, but being an independent police officer, then will be fully protected. I think that deliberation is most required. Then all these things are concerned. How police will be independent, then the politicians or the party in power. Unless that deliberation is there, all other things are concerned may not have that effect or impact. Because ultimately, all the things will go to the police. We make the law. And if he doesn't file complaint, if he files the complaint, we have got so many examples that I will take the complaint and I will ask the accused to go for anticipatory law, anticipatory bail. So many things will happen. So let us be that first of all, sometime, this is not a forum, but I will suggest the law commissions that how the police force will be independent of party in power or the politicians, then only the society will be safe. Otherwise, you make 110 laws, it will have a less impact. That is my humble.
No, but sir, you must be recalling Supreme Court has given elaborative guidelines in 1996 judgment.
Sir, even today, I am talking about a session judge who has given one of the things that 41A has been violated. And still, he has not given bail, he rejected the bail applications. No, if the session judge doesn't understand what the High Court and Supreme Court has said, how can we say anything? I'm not criticizing any individual here and there. But I say that first, if at all, the good deliberation should be that how effective the police machinery will be there to protect us or to maintain the law and order. As we say that they are all his master's voice.
Sir, can't we establish special courts for dealing with sexual offences?
Sir, these special courts are bogey because the strength is not increased. We have got 20 courts.
The Rajya Sabha report which shows that fast track courts are
I will tell you, if suppose in Maharashtra take the case that 20 districts are there, we'll say that 20 courts are to be formed. So 20 judges of the sessions court level with their staff and everything, the finance ministry say we have no fund. So what they do, that when the High Court pass order Supreme Court, they designate one of the existing judge as a special court. He has to deal with 10 more classes of cases. He has to deal with administrative. So he is only a namesake. Even the fast track courts, these are all eyewash, because unless you give the additional extra courts of that kind, आपको negotiable instrument, these politicians, what they do, they go to the merchant chambers, will make a special code for the negotiable instrument act. They will go to the women's side, will make a special code for women's. They will go to the children's that part, will say that we are making special codes, but they are not increasing the numbers or they are making it with that, but designated. So that High Court has said, Supreme Court has said, we have completed the formality. So that should be in the true spirit special courts, then only we can be safe.
The cyber appellate tribunal is not functional and the DTSAT, which is a telecom dispute resolution settlement body, is trying to hear matters at that point. How many matters of the year? We are honestly like, what tends to happen is the appellate being coming in the fold of regular magistrate. I think a lot more cybercrime cases would have been resolved that there are no investigating officers. Like in the middle 3 years now, Maharashtra, Mumbai will still have an investigating officer. Most of the states don't really have. And in Maharashtra, in the middle, there was a phase of 3 years where there was no officer appointed. So it is such a bad situation really. In other states, people actually plan to call up and say, this is happening, what should we do? We're like, we're sorry, we don't have a forum in your state. And then, you go by a petition to the Bombay High Court because there is no other forum. Then you prove that the other forum is not sitting. And that is when they will enter your complaint. It's like, it's a
The tribunal also abolished. They abolished cyber tribunal. They abolished.
Okay, since I mean, the matter is going for polling, on the other hand, we have Advocate Uday waiting there. Shall we start his deliberation? Yeah.
I would like to just take a moment to introduce Advocate Dr. Uday Varunjekar, sir. He has been a practicing High Court advocate at Bombay for more than 26 years. He has successfully filed many public interest litigations. Sir was a delegate in the first Law Asia Human Rights Conference, New Delhi, and he presented papers on new technologies, privacies, mass surveillances. Will human rights survive? He has been a delegate in the BRIC Legal Forum at New Delhi from 2016 to 20. He was the vice president of the Bar Association of India, Delhi, and holds the post of president and of the Consumer Court Advocate Association in Mumbai. He was an elected member of the Bar Council of Maharashtra and Goa, a statutory body since 2011 till now, and has been the ex-vice president of Advocate Association of Western India, the oldest bar association in India. He will be deliberating on the topics of armed conflict and sexual offenses and Section 114A of the Indian Evidence Act to be compatible with the Section 376 of IPC. Over to you, sir. Very warm welcome.
Thank you for your kind words. I could see several known faces. Of course, there would have been a better occasion to meet again and again, but because of this pandemic situation and coupled with this today being a working day, kindly excuse my physical presence. I'm sure all honorable speakers and invitees, they must have deliberated on different topics. The topic which has been assigned to me in this regional consultation is little different than the initial first segment. I am told that this topic which has been assigned to me was not debated, was not deliberated in the first segment. Therefore, it's a pleasure to place a thought before all of us so that we can discuss, we can find out whether there is a need. If we are convinced that there is a need, then how the Women Commission can take this issue further. These are the basic things. Having said about this basic aspect, I must say that I could not listen, nor I could hear to the different views which have been expressed by the other honorable speakers. Therefore, it is possible that there may be overlapping. It is possible that there may be something different thought which may come. But after all, it's a regional consultation on the review of the criminal law. So therefore, I'm sure the Women Commission will welcome these different thoughts. It may be a duplication, it may be a new thought, it may be something else, but let us start. Of late, there has been a increase in the different new dimensions which are added in the legal framework. We have seen after Nirbhaya, large number of new offenses have been introduced in our Indian legal system. There are some corners from whom the demands are being raised that with reference to armed conflict and more particularly sexual offenses, there is a need to address that issue and place within the legal framework. There are some allegations which have been made right from 1991, where 4th Rajasthan Rifle from an Indian army was accused of commission of sexual assault. That was in 1991 in Kupwara district of J&K. We are aware that there has been an allegation against the 17th Assam Rifle of Indian Army about use of their excessive power and commission of sexual assault. In the year 2004 in Manipur, there have been some other allegations in respect of Chhattisgarh, where National Human Rights Commission was also required to take up those issues. And the facts and figure goes to show that they compelled the government to pay compensation. You must have heard that I made a statement that there have been an allegation. Why? Because it is difficult to prove. Nobody has gone to that level of making an attempt to prove whether these were individual incidences or whether it was an outcome of an armed conflict. It depends on case to case. It may be a individualistic offense, but still it's an offense. But when we call it as an armed conflict, then of course it becomes a little different than an individual person who has committed such offenses. And now therefore I use the word that there have been several such instances where allegations were made. The fact remains that though allegations have been made, the Women Commission will have to take into consideration the need of the society. We as a student of law, we are aware that there are two ways to react. One is what has happened in the Nirbhaya case. Even today, a large number of students of law criticize that it is a knee-jerk reaction which has accelerated different things. There is a one way to look at it. The another way to look at it is this, that there was a need and our legislators failed to assess that need and introduce the amendment. So viewed from this both angles, with reference to armed conflict, now we will have to discuss whether there is any such a need to take cognizance and introduce a separate category of an offense in the Indian legal framework as on today. We are aware that there are separate legislations. Armed Forces Special Power Act is one of that legislation which has been debated recently. With reference to Assam, there has been a demand which has been made for last several months again and again that the powers are required to be reduced or denotification should be made. I'm sure as a student of law, we must have seen that act. It's a very small piece of the legislation. Now, once there is already a legislation which gives a special power to the armed forces, whether the amendment in that act is required so as to protect or prevent the sexual offenses, that is one way to look at it. Another is whether in the Indian Penal Code, can there be a one more creation of a separate offense, and that offense will be with reference to the offense, sexual offenses committed by the armed forces. This is the second angle. So one is, as I said, that to make an amendment in that Armed Forces Special Powers Act, or the second would be in the Indian Penal Code create another separate offense where the armed forces have committed such heinous offense. The topic which is given is about the sexual offenses, which involves the different concepts. We are aware that a compulsory or forced pregnancy is also one of such sexual offense. No doubt about the pregnancy, there are separate legislations, but this issue is not covered under those legislations. I am making a reference to the PCPNDT Act, which is Preconception, Prenatal Diagnostic Technique Prevention, etc., etc. 1994 Act, amended in 2003. I am making a reference to the new legislation which has come last year in the month of December, that is a surrogacy or even ART. These issues are not addressed in those legislations. Apart from a compulsory or a forced pregnancy, there are problems when the armed conflict creates a situation when there is a forced abortion. And as a student of law, we are aware that even that issue is not covered under the MTP Act nor under the Indian Penal Code. Indian Penal Code deals with a separate situation, and essentially both these enactments are intending to protect the medical professionals. Having said about this, the forced sterilization on account of the armed conflict phase is also one of such issue which is not addressed in any of these legislations. Though the example which I wish to give is nothing to do with the armed conflict, but since this regional consultation is taking place in the Western Maharashtra, there is a temptation to give an example of those laborers who are cutting the sugar cane. I'm sure we are aware about those stories where there is a allegation that the compulsory sterilization takes place in respect of those forced labor or those contract laborers who are engaged in cutting the sugar. But as I said that this may not have a direct nexus with the topic which has been assigned, but I gave an example that in the phase of armed conflict, these issues which are also not addressed by any of the legislation. Apart from that, we are aware about the forced marriages during this armed conflict phase. There are such cases where the forced marriages have taken place. The sexual slavery is also one of such allegations which has been reported in the rest of the world. Compulsion about the prostitution during this armed conflict phase, that is also one of the such concerns. And right or wrong, these concerns have not been taken into consideration by our Indian legislators. Therefore, now the time has come to consider whether there is any such need to discuss this, or whether we are still at a first stage when the legislators will have to see the need of the society in the future. I am aware that we are in Pune, so therefore the Marathi word is drashta. The Marathi word drashta means that the person will have to foresee what is going to happen in future, and he will have to frame the legal framework. The legislators will have to be a drashta. They will have to foresee what will be the requirement of the society in future. As on today, there are allegations about the armed conflict in India. It is possible that in near future there may be an immediate necessity to enact some legislative framework to deal with such offenses. Having said about this, let me tell you my personal opinion. According to me, there is no such immediate necessity to make any changes as on today. Of course, we all are students of law, so therefore everybody will carry his or her opinion. There may be persons who may differ from this, but I respectfully submit once again that unless there are such concrete examples, nobody should make any undue haste in making a legislation. Let me go back to that particular phase. After Nirbhaya, again a question comes whether, with reference to the armed conflict and sexual offenses, whether it should be a knee-jerk reaction or whether it should be any action which should be initiated well within time. We are aware as a student of law and also a human being that in India, such allegations are being made. There are persons who are making these allegations. There are persons who are taking these allegations across the world. There are persons who are propagating continuously with reference to use of excessive power by the armed personnel. There are persons who are affiliated or associated with different lobbies. We as a student of law, we will have to keep those things in mind. We can't say that there is an immediate need with reference to an amendment to bring this armed conflict and the sexual offenses within the framework of the law. Of course, this is my opinion.
Sir, Uday sir, can we shift to the next dimension you were supposed to cover, which is compatibility between 376 and 114A of Indian Evidence Act, please?
Thank you for reminding me. I am aware that the time which has been given to me is a very specific time, but still, I wanted to take more time with reference to the first issue. The second issue is concerned now. In the concept note, the questions which were asked by the Women Commission is, what should be the standard of a consent under section 375 of the IPC? Again, I must say that time and again, the Honorable Supreme Court has said that each case will have to be considered on its own merits. The facts of that case will have to be considered. There can't be a general yardstick. Now, the question which has been framed creates a little confusion in my mind. Let me elaborate it. Whenever there is a sexual offense, the presumption under 114A, that is a one of the basic rather creation of a presumption by the state. Legislators have created that particular presumption by keeping in mind the Indian society, the usual phenomena, usual features, usual constraints of Indian ladies. Now, if we are trying to come out of that particular presumption and say that what should be the standard of that consent, then we are doing it in a different direction. We are going in a different direction, in my humble opinion. Why? Because in each and individual case, the standard will differ. There is no need to categorize the degree of a consent. Is it a case of a direct consent where there is an express consent? The answer would be no. If there is a direct express consent, then under the touchstone of the Indian Evidence Act, the advocate for the accused can bring that direct consent before the court. If it is a case of implied consent, then the degree or the standard of a consent will come into it. Once that degree or the standard come into picture, then of course the question comes, is there any such need as on today to deliberate on this topic and create a further sub-classification? Let us go back to 114. 114A, we are aware that there is a presumption which has been created. That presumption, though, is sufficient. Now, in some cases, there have been allegations that no, the consent was obtained by adopting different mechanisms, different methods. It was not a free consent and so many things. So again, with reference to that, according to me, there is no need to make a degree, maybe 100% standard or maybe 50% or maybe less than that. In an individual cases, there is a possibility that the person may be able to prove that whether the presumption is rebuttable or not. Let me come to the question number 4, which is whether we should grant whether the ground of vitiation of the consent be expanded to include the cases whether victim has been put in fear of an injury other than physical hurt or death. Of course, that can be done. The second is perpetrator is impersonating other person and not just husband, as currently provided under section 375 of the Indian Penal Code, that victim should have knowingly consented to. I think that can also be done. These are the additions which have been suggested. I think question number 4 is concerned, we can respond positively. So far as question number 3 is concerned, in my humble view, there is no need of making any standard degree of the consent. I think this is enough for the time being, but I'm open for the question and answer session or any further input from my side. Yes, I'm thankful. The question is questions which were assigned to me. What should be the standard of a consent under 375? According to me, the answer is there is no need to go to that kind of a sub classification, because again it will be difficult and it depends on the evidence of the each and individual case. The second question, which was, should the ground of vitiation of such consent be expanded to include the cases where the victim has been put in fear of injury other than the physical hurt, or that yes, the perpetrator is impersonating any other person and not just the husband as currently provided in section 375, that the victim should be otherwise knowingly have consented. Yes. So these are the two things which according to me should be considered. The question number 1 should be answered in negative. Thank you. Perhaps mic is off.
Yeah, Jain sir, please. Sir cannot hear unless you speak. Uday sir cannot. Yes, you are. To Uday sir, you are audible only. No, he can hear me. Varunjakar sir, you can hear me, na?
Yes,
but,
yes, of course.
Advocate, I mean, Professor Jain, the principal of ILS Law College, are you able to hear him?
No. Can you pass on mic to Dr. Sanjay?
Sir, can you hear me now?
Yes, Sanjay, please go ahead.
Yeah, it's pleasure to hear you, sir. My question regarding standard under Article Section 375, although I'm not a criminal law person, but if I were to locate the women with disabilities, and particularly the women with mental disabilities and their molestation, don't you think that we need to make some kind of accommodation in law, even in terms of age also? For example, there was this very interesting case before the Supreme Court in respect of the age, how to determine the age of mentally disabled women. If physically a woman is 21, is she also mentally 21? So that we can presume consent. And even in respect of vitiation of consent, I mean, taking into account the aggravating circumstances of the disabled women, don't you think that there is a need to locate women with disability? I don't find any location for women with disabilities in criminal law. I may be making a very loud statement. That's what I think, and probably during the afternoon session I will speak more on this. Yeah.
Okay. Quick reaction to what Dr. Sanjay Jain asked. RPWD Act came in 2016. We as a student of law, we are aware. Though that act is having a different object, there is some reference about sexual exploitation as well as the other rights, including the reproductive right of a disabled person. I'm sure our all participants must have seen those provisions. But once we come to a offense, then that offense is within the framework of the Indian Penal Code, because that's a basic statute as on today. With reference to the offenses under the RPWD Act, we are aware that those offenses are which are provided under that act only, and the sexual offenses are included to a limited extent. Perhaps the legislators were of the view that there is no need to make any provision in the RPWD Act, because already the present basic act, namely the Indian Penal Code, is sufficient to deal with such situation. The question is whether the age to be considered or not. That debate is still on. The different views are being considered. But according to me, the RPWD Act also need a further amendment, because with reference to the new enactment, several new categories have been introduced. We are aware that under our PWD Act 1995, there were only 7 categories of the persons with disability. Now we are having 21 categories. Not only that, the other rights are also included in the RPWD Act 2016. But having said about this, my still humble opinion is this, that there is no need to make any amendment with reference to the disabled person in the Indian Penal Code, because the present law is sufficient enough and the honorable judges are enough sensitized to deal with such situation. If we create or if we demand that there should be a further amendment in the IPC to protect or to protect the disabled lady or disabled child, then perhaps we will be making it too compartmentalization, and that may not be required at this stage. Coming to the second question.
Thank you.
Okay, thank you.
Go on, sir. Second question, quickly, if you can answer.
Yes, sure. The second question, which was asked about the compatibility, I'm sorry, I lost that link.
Yeah, compatibility between 376 and 114A of Indian
Correct,
Evidence
but
Act.
what Professor Dr. Sanjay asked, I'm sorry, I forgot that.
Vitiating consent in case of disability.
Yes, again, the same answer will be there, because the Rights of Persons with Disability Act is a new statute where a further amendment is required to be done. And I agree, and I'm thankful to Sanjay that such issues are raised and they require further more deliberation. At an appropriate stage, further interaction can be done about amendment in that act also. I think that is sufficient. Thank you.
Thank you very much. Anybody else wants to respond? Then we move to Madam, Anuradha Sahasrabudhe ma'am from Childline to respond to overall categorization of offences and also general views. Advocate Uday Waranjikar sir, thank you very much for a kind support and wonderful deliberation. From a senior practitioner's viewpoint, it has really enriched, and many points will go into the recommendation proposals. Thank you.
Namaskar. I am going to place before you some hard-hitting facts. It's a ground reality. As I've said, I'm not a legal person, though I am all the time dealing with the procedural matters of law. Number one, I would like to ask all of you a question. See, all these laws and legal provisions that we are discussing, as a legal fraternity, it sounds so nice and so sweet and so supportive to victims maybe. As activists, we are always criticizing. These are the two sides of the situation. But then can't we, when we are on such forums of consultation and we are talking in line with status of women, consider these loopholes that all over these years, 75 or even before that, been talking about in the procedural matters that ensures that no justice is done. I'm going to be very strong on it, because every day I'm seeing children and women suffer at the police stations, at the courts, and so on and so forth in the whole procedural system. So if we are making amendments in laws or making new laws, can we make watertight procedural, what would you say, situations where justice is, I mean, that's a cliched thing, justice delayed is justice denied. But 99% of the times I see justice denied, sometimes because of the procedural matters, and sometimes because procedural matters put off the victims from seeking justice. Kaun jayega police station, kaun jayega court, and who has the money, and so on. Plus, there are social pressures, especially on women and girls, that the victims are the abused. The abused are the guilty party, and that guilt they are going to carry lifelong. This is a favorite question I started asking at various forums, ranging from IT professionals to doctors to lawyers to police to everybody. I asked them a question, and I'm putting it to this platform also. In a Nirbhaya-like case, as an activist, I'm going for a morcha. How many of will you come with me? All hands go up. Sometimes 2 hands go up. The second question I ask is, a 2-year-old girl was raped when she was like 2 years, she was raped. How many of you will have her in your, as your wife or as your daughter-in-law? Not a single hand has come up. I have questioned hundreds and thousands of people, not even from the women activist groups. This is the reality of society. So girls and women are told to shut up. First of all, these culture wrongly classified patriarchal ideas about culture are put on them. This is also an end result that you are the guilty party. You must have done something to attract this. Even our ministers are talking that language. तू ऐसे कपड़े क्यों पहनती है? अरे तुम्हारी नजर क्यों खराब है? That's the question. Whether it is now the hijab thing or somebody on TV channel asked me. So I said, you go around nude, no problem. But the uniform is a law of that particular institution. So you have to abide by it. So, you know, and messing up this, politicizing, putting ideas in children's heads and all, this is what is happening. Basically, all these patriarchal attitudes being fostered and coming to, girls are not coming forward to report. And when they come forward to report, I will just place before you in a very short time. I know everybody's hungry. We have been taken care of to some extent. But there is a POXO case. Now, POXO cases are to be finished within 1 year. I'm dealing with many POXO cases. There was one case where in a Karzat ashram, I went to rescue 2 girls and we found 35 victims in captivity in a very, very perverse manner. They had been, boys and girls have been sexually abused. Even to get that man to book after the statement of that girl in front of the CWC and the magistrates, other magistrates, I had to literally go to the DCP, then DCP to IGP, then directly to the chief minister. Only then things got moving and the case went to CID. It is 2014 case. It came up for hearing a year before last at Alibag court. And then I had to go all the way. Now who's being victimized? The girl who was raped, and one of the girls who was raped and completely in a shock and traumatized condition, lying straight like that in the bed, couldn't even talk. We got her to talk after counseling. Now she's settled, educated, married somewhere else. Given the social situation, now she's again called to court. So reopening of wounds. First, the girl or the woman talks to the somebody loved one, then the police, then even in POXO, this is happening. What law are you talking about? Please tell me. Now, in all this procedural harassment, a 5-year-old girl in juvenile board sits on a mama's lap and is deposing, and the lawyer in a very, very insensitive language is asking questions. When I object as a magistrate sitting there, he says that's his job. Okay, so he will do it. It's like the lawyer saying, murderer hai to hamara job hai, hamara pet ka sawal hai, and we will do it. So now that is also harassment to me as an activist. So do I file a case against that lawyer? Do I file a case? Now the judge is sitting there. One girl is raped. She goes hostel because she's being coached to go hostel. She's been already married, child marriage. He doesn't even think now he has to talk about child marriage also. No, that is a different case. It's not in my brief. Wow, so what is the law? And with these different circles, this is what I wanted to place before you. And last but not the least, this whole thing boils down to behavior versus value. Recently in a police training, we were doing 498 and POXO training. And I asked the police, how many of the police men sitting here beat their wives? And I asked the ladies there, how many of you take the beating? Nobody denied it. And in the lunch break, they said, Madam, kitna kharab bolti hai aap. And they don't think it's wrong. If the police women who are dealing with 498 don't think so, they are not sensitive enough to even deal with that case. Cyber crime, same thing is happening. They're putting us through the red tape. There are helplines. But if we go to the helpline, यहाँ report करो, वहाँ report करो, अरे, there is a confidentiality angle to the whole thing. Nobody is taking care of. So when I'm talking several things on several points, but at the point I'm trying to make is first, let's introspect. Whether you are a commoner or whether you are a judge or whether you are a lawyer or whoever, a policeman, what are our values? Are we fit enough to even deal with this case? And then let's talk about amendments and then what is the accountability of that lawyer or that judge or that policeman? Is there any penalization for that person? Otherwise, women are going to keep on suffering. So please, my humble urge, and thank you for giving me this platform to say this, that when the national, now let me come to National Child Rights Commission also. Sorry, sir, my words are sometimes very harsh and sometimes very strong, but I'm talking of reality. Whether it is National Child Rights Commission, National Women's Rights Commission, or either the State Child Rights Commission or State Women's Rights Commission, when citizens or NGOs approach them, and Sister Lucy will concur on that, again, they actually tell us, when we ask why isn't justice being done, because they put us again through the whole red tape situation, and then everybody gets fed up with them, and then they say, yeah, we have the power, but we don't have the teeth to bite. So why are you there? That's the question person like me would ask. I'm sorry, sir. I mean, I don't mean to insult in any way. And I don't mean to say that this commission shouldn't exist. Of course, they should exist. And like a woman in a village once told me, when I went to talk about legal provisions for women to them, she says, I mean, I'll end on that note. She says, it's nice to know this, that these laws exist. We feel supported. So it's nice to know that these commissions exist. We feel supported. But we are never going to take advantage of them because we know nothing is going to come out of it. And plus the society will throw us out. The families will throw us out. So the social situation, the reality of legal procedures, and the law amendments or law systems that we are talking about, all, please, they need to go hand in hand and they have to be very sensitively dealt. Thank you so much.
Thank you, ma'am, for that very valuable and passionate input. Coming from experience. One point we can note down probably for recommendation is women-friendly courts. How to make, whole court procedure, right from the police investigation, etc. Provisions have been there, but are they really being implemented? So, yeah, it should be women-friendly because above age of 18, everybody is a mature woman, which is coming under the purview of this deliberation. But then vulnerability, what we consider in jurisprudence as a problem. Vulnerability as a woman, depending on rurality, depending on minority religion, depending on Dalit status, could be much different, and educational exposure and things like that. So that is the important takeaway that I see. Madam, I would like to, sorry. Yes, sir. I would like to differ a little bit with your view. Which, your view comes from utmost compassion, and I have no difference with that view. But I would like to add my experience as an activist in my pre-Symbiosis days in my home state, that in the villages, when we discuss law, we make women aware of law. They don't always say they are not believing in it or nothing is going to happen. They say that you gave us an insight. Now I will rethink my position. So it has given them that inner, it gives them clarity on what they're going through is wrong. Their conscience somewhere says that it is wrong, but it is our literacy sessions which give them a clarity. And when I went back to that community after 4 years, I had seen so many being transformed. Either they have rearranged their relationship with their in-laws family, or they would have found their own space, or they would have juggled their home and social life, engaging in rural politics, etc. So transformation begins with knowledge, madam. So legal provisions, if they are women friendly and they are incorporating the voice of women, they definitely make a change by their very presence, if not in the 100% way, they trigger the change. That's my belief and experience.
I am sharing something. You just see how it can be included in the system. This I have done as a judge of High Court. Unfortunately, I have no followers. See, I never caught hold of the wrongdoing officer. I always caught hold of his supervising officer, requiring him to file an affidavit after reading the investigation papers to the effect if he is satisfied, okay, if not, why, and what steps he has taken. Numerous investigations were set in order just with this simple technique. So whenever the complaint is that the complaint is not taken, person is made to move from pillar to post, there should be an arrangement to inform the superior officer that had gone to police station and there is report is not taken, he is alarmed. And about 20% supervising officers I have seen excellently sensible. Please consider how this can be brought into as a wider proposition.
And then before we move to the afternoon panel, beginning with Professor Jay, we have a lunch break of about half an hour.
Thank you very much, ma'am. And thank you to all the speakers and dignitaries for your valuable inputs and lively deliberations. There were several questions that have come up during the session. I will only take up two questions. The first question was addressed to Advocate Puneet. The question was, considering that a large number of cyber offenses go unnoticed, particularly in the sphere of sexual harassment, which often is committed through private messaging means and is only discovered by means of public callouts, etc., which potentialize several such instances going undetected, what provisions can enable tracking of such offenses to increase the standard of regulation and accountability?
I have already part answered this question when I said 66A needs to come back with an amended version. Why for the last 4 years it has been off the charts and not in the minds of legislators is very questionable. So about this whole harassment over private messaging, a very clear definition is very important. And this is something which NCW also should take up further as a recommendation, that women, men, both are affected, women to a very great extent. Today, women, the moment they receive harassing messages, they just leave the social media platform. They don't know what to do. I'll just uninstall the app. That's the easiest way, but that's not the way to live in today's world. So 66A has to come back with its modifications, with proper definition of what would constitute harassment in messaging, content that is abusive in nature, content that is harassing in nature. This is something which is the need of the hour, and about traceability. So the intermediary rules already specify, the intermediary rules of 2021, that the first originator of a message can be, the details of that can be obtained by the law enforcement through a court order. So there's been a lot of upheaval in the media. Multiple times I'm asked, your privacy is breached, anybody will know about it, but there's a process in place. Today, you cannot just approach the platform and ask the intermediary, please give me this detail. He's not going to provide it to you. It will happen through the police route. It will happen through the court passing an order. And in the nature of offense, where a judge is obviously a reasoned, intelligent man who's going to pass an order, please share the details of who was the person who has circulated this message or who has initiated this message. So this is already there in place partly, and the 66A part, which I mentioned, it's very important that it should come back.
All right. Thank you very much, ma'am, for your response. Now, the next question was either for Advocate Puneet or Dr. Vibhute. The question is, when considering misogynistic hate speech on the online fora, how does one differentiate between speech that is merely harsh speech and protected by the right to freedom of speech of individuals versus hate speech as recognized domestically and internationally?
I will answer only in 2 words. It depends upon his motive and state of mind and intention.
With respect to harsh speech and hate speech, there's a very big difference. Like when we talk about freedom of speech, there is an exception where it cannot intrude or it cannot violate another person's right. So where a person is simply expressing an opinion in a manner which is reasonable. So there are grounds for reasonableness also, which in multiple judicial precedents have been laid down. Considering those is the bifurcation that we make with what is harsh, what is false, and what is genuinely a positive criticism or a criticism in the right direction. So what a reasonable man, there are this test of a reasonable man, we always hear it from your law school days, and there are multiple judgments which really lay down even about the freedom of speech and expression, what a reasonable man would consider as a hate speech or a harsh speech, and what would be reasonable criticism.
Thank you. I do not think we have time for any further question.
Intention, I think that there are 5 distinctions. Fair criticism or putting a thought is a one thing, and with the intentions to damage, harass, or to commit an offense, speak, that is another things. And therefore they say that if you are criticizing on a philosophy, on the subjects, then it will not come under hate speech. But if I am targeting something and I want to criticize, I want to defame, I want to damage the entire women community or one woman or one group, one school, one everything, it will come under the hate speech. And Arnav Goswami's case recently, then Sunanda Khole's case in the High Court, recently Bombay High Court judgment, they say that one has to examine the entire things in the text of it and the circumstances which are surrounded by it. Thank you.
Thank you. Thank you very much, sir. Now, before we break for lunch, due to their mid-session arrival, I would like to request Dr. Shashikala Gurpur ma'am to kindly felicitate Advocate S.K. Jain as well as Dr. Sanjay Jain, Principal of ILS Law College.
That's what
Two 40. Okay. Yes. So this brings us to the end of plenary session 1. We will commence with plenary session 2 at 3 p.m. Thank you to all the online participants. Those of you who are yet to give the poll results, please put in your poll opinions. Thank you.
read from it. When was the order dated? Like when it's trial 5/17.
So it was dated after the amendment. And that is what the petitioners are saying here.
See, this is when the amendment came, 2011, 2006, and the order was passed on.
Perfect, 2017, a year later. Or a few
A
months,
year
6 months.
later.
6 months later.
Yeah, but still later than that.
Yeah, and that is fine. The petitioners have stated that amendment is applicable only to the payment transaction including before or after the date of commencement of the act. And this must have been before
When the first search started using that, right? See the this the
Shorts
दीदी बस 2 मिनट देना।
Check, check. A very good afternoon to one and all. We will now begin with the plenary session 2 on improving the status of women, discussion on law relating to dowry, death, offences relating to marriage, and family-related offences. To introduce the resource persons, I would like to once again call upon Professor Dr. Bindu Ronald, co-head of Skalsar SLS Pune.
Good afternoon to all the resource persons and to the faculty and students who are there attending online and offline. After a very interesting first session, we're now going to the second plenary session, which will focus on law relating to dowry, death, IPC, CRPC, and Indian Evidence Act relating to marriage and family-related offenses. This session is also graced by very eminent persons, and we look forward to some very interesting discussions, deliberations, and outcomes. I'll briefly tell about the resource persons who are there for this session. We have Dr. Jain, Dr. Sanjay Jain, Principal in Charge, Associate Professor, ILS Law College. He has 22 years of experience as a faculty in law and has an expertise in comparative constitutional law, jurisprudence, international economic law, and feminism, etc. His scholarship has international and national exposure with participation in more than 100 conferences, workshops, and seminars, and he has more than 20 articles to his credit and 5 books. He's the recipient of various awards, such as the Shanti Bhushan Award, Professional Competence Award, Biannual State Level Ideal Teacher Award, etc. We also have Professor Dr. Purvi Pokhriyal. Dr. Purvi Pokhriyal is the founding dean of the School of Law, Forensic Justice and Policy Studies. She specializes in the area of criminal justice studies and justice education. She has been a consultant and a resource person on various aspects of legal studies for government as well as non-governmental bodies. Dr. Purvi Pokhriyal was conferred with Senior Social Scientist Award by the Indian Society of Criminology for her significant contribution in the field of criminology. She also has been selected for the Best Law Professor Award by the Business School Affairs, and she has several research papers published to her credit, and she has presented more than 50 papers in various national and international conferences. We have with us Dr. Rajashri Varhade. Dr. Varhade has been associated with the University of Mumbai for almost 22 years. She's a professor and former head, Department of Law, University of Mumbai. During her time there, she has organized legal aid camps, Lok Adalat, seminars, workshops relating to human rights, disaster management, environmental law, etc. She has edited several books. We also have in this session Justice Ambadas Joshi. Sir has already been introduced in the inaugural session, and all of us had the privilege of listening to him briefly. And in this session, we will once again listen to Sir. We also will have Ms. Purnima Gaikwad, DCP, Pune. She's an alumni of Ferguson College and Pune University. She went on to become the Deputy Commissioner of Police, Pune. She was in the Intelligence Department, and she also served as the Superintendent of Police, CID, Konkan Range. She is now serving as the Deputy Commissioner of Police, Zone 3. Recently, she also handled a very sensitive case of a mother selling her child to a childless couple. Next, we have Professor Dr. Tapan Mohanty from NLIU Bhopal. Professor Tapan Mohanty is Dean, Department of Distance Education and Chairperson of Center for Socio-Legal Studies at NLIU Bhopal. During the last few years, he has worked extensively in the area of globalization, tribal development, and culture of consumption besides sociology of law. He has various research projects to his credit, and Professor Mohanty has also conducted various training programs for different category of professionals. He's the member of the State Supervisory Board of Implementation of PCPNDT Act in Madhya Pradesh. We have Professor Yogesh Dharanguti again, who's an assistant professor at Symbiosis Law School, Pune, and teaches family law, law of inheritance and succession, law relating to marriage and separation. He has many publications to his credit, and he's part of the Community Legal Care Center of Symbiosis Law School, Pune, and also heads the Prison Legal Aid Clinic. We will also see in this session, once again, Advocate S.K. Jain. Sir has already been introduced. And with this, I'll call upon our first speaker, Dr. Sanjay Jain, to give upon his deliberations. Dr. Shashikala Gurpur will be moderating the session.
Okay. Do we have a stand mic so that somebody can hold it? I will use my braille material. Yeah, yeah. I mean, I can stand and talk. Not a problem.
Then somebody has to hold the mic first.
So shall I start? Yeah, good afternoon, one and all. Professor Vibhute sir, former Judge Bombay High Court, Honorable Joshi sir, Gurpur madam, and number of my co-panelists. Thank you very much, Bindu, for introducing me. With one small correction, recently I've been designated as professor, and I'm happy to be amongst most of the professors in the panel. That's a small feat of satisfaction, you know. As usual, let me dedicate my talk to my teacher, mentor, Dr. Deshpande, who untimely passed away last year. And therefore, I have decided to dedicate my all talks, lectures to his fond memory. And it would not have been possible to me to make it here without his contribution in making me. Now, I don't know whether I have paradoxed myself in this consultation because I'm not a hardcore criminal law scholar. I'm barely a student of criminal law. But why I decided to squeeze this opportunity and come to this consultation mainly to find out whether women with disability have been located by the government, by the state, because our identity has already been taken away from us with a new invention, Divyangjan, which I abhor extremely fiercely. And therefore, I wanted to find out whether National Commission of Women is cognizant about the women with disability. And I hope if this point is not there explicitly, implicitly, the point must be there. Now, let me recall a very important judgment which was recently delivered by Justice D.Y. Chandrachud in Patanjalan case, which is popularly known as Andhra Pradesh rape case, in which I think for the first time in India, a judge of the caliber of Justice D.Y. Chandrachud officially acknowledged the exclusion of people with disability in general and women with disabilities in particular from legal discourse. And he emphasized how it is important to note the aggravated form of violence faced by women with disability because of the intersection of disability, sex, and sometimes caste. So caste, sex, and disability, when these three different identities, when these three multiple identities intersect, then what amount of aggravation with which the violence is perpetrated on these women with disabilities has not been taken cognizance of by Indian legal order, and that's what Justice Chandrachud very clearly lamented in his judgment, and he copiously quoted and other scholars on intersectionality and emphasized the need to apply intersectionality and ensure that women with disability, when when they face violence, violence meted out to them need not be taken as simply as a normal violence. Normal word is wrong, but short of words, I'm using the word normal violence. After all, violence is violence. But now, the point which I want to make before this August gathering is this, that have we really taken the violence against women with disabilities seriously? And my answer, sadly, has to be no, because National Crime Record Bureau does not have the rubric violence against women with disabilities. And I strongly recommend the Commission to do needful and take upon itself the task of conscientizing NCRB and so that there is a rubric with regard to violence against women with disabilities. Now, why this rubric? What is the necessity? Because we heard Varun Jekar sir, and he was saying why to classify. There are two reasons. Firstly, the violence meted out to women with disability is a more aggravated violence compared with violence meted out to women who are non-disabled. This does not in any way mean that violence meted out to non-disabled women is less serious. But then the compounding factor of disability, how disability in intersection with other identities, how it aggravates violence needs to be highlighted. That is first point. The second point is UNCRPD, which has been ratified by India categorically. And one of the provisions of UNCRPD very clearly cast obligation on state parties to generate disability disaggregated data. And in absence of data on violence, it is easy for any state to write in its report that, okay, there is hardly any violence against women with disabilities. So to give visibility to the violence meted out to women with disabilities, it is important that we collect data, and the data is collected in a disability disaggregated manner, because now the RPWD Act enlists 21 different disabilities, and Government of Maharashtra has added 2 more. So there are around 23 disabilities. Now let me very quickly give you a brief background of some very important provisions in the RPWD Act and how these provisions are not merely under enforced, but I wonder whether they have even visibility. So just quickly, let me cite 2 or 3 provisions very quickly. The first provision is, and this is a provision with the marginal note of the provision is women and children with disabilities. Now again, RPWD Act has adopted a twin track approach. Apart from recognizing the rights of persons with disability, it also dedicates a separate section to women with disability, highlighting thereby the need to provide visibility to the women with disabilities and their vulnerability. The appropriate government and the local authorities shall take measures to ensure that the women and children with disabilities enjoy their rights equally with others. So the presumption is that already women with disability have rights, but what the law says, they should be able to enjoy these rights equally with others. But whether women with disabilities have rights, if you read Saptarshi Mandal's account of how courts treat disabled witnesses, how courts treat disabled litigants, we will realize that the situation is far from happy, and only on paper this provision stands. In fact, most of the states in India, and please mark my words, most of the states in India have not made any significant progress on implementation of this section particularly, and implementation of RPWD Act generally, because hardly any state has come out with rules, and Maharashtra is not an exception to it. Even when you look at the central government rules, I don't see any rule touching the rights of women with disabilities or touching on their schemes pertaining to empowerment or schemes, seeking reasonable accommodation for women with disability in administration of justice, criminal aspect. Now, just a minute, madam, just a minute. I have just two very quick points and I will wind up. I would like to quote subclause 5 of section 3, which imposes or casts obligation on the state party to provide reasonable accommodation to PWDs and women with disabilities, and criminal law is no exception. And I would just very quickly draw the attention of the audience to section 6, which talks about protection from cruelty and inhuman treatment to women with disability. Again, it is a long section, but again, a paper tiger, because we have not explored its interface either with section 498A or prevention of domestic violence vis-a-vis women. My last quick point, there is a provision in the Act for establishment of special courts. The provision lays down that in consultation with high courts, the state government must designate in every district one session court as special court. To my knowledge, Pune district has one special court, but whether again it is visible. Then there is also a provision for appointment of special special prosecutor to defend the rights of women with disabilities. But again, this is a paper tiger. So while winding up, I would recall Professor Menon's formulation when he used to say there should be normativity, there should be institutions, and there should be personnels. And when I look at people with women with disability with criminal law, I find nothing. Thank you very much.
This has dealt with 493 to 498 in terms of response to this issue. But whether they should be repealed or modified is still subject to be dealt with. Meanwhile, there are other segments, particularly in terms of domestic violence cases and 125. I would request Senior Advocate Shri S.K. Jain to respond, please. And I would also request Sister Lucy to intervene once this is done from your experience point of view.
Thanks, Dr. Gurpur, to accommodate me. Because as it always happens, and we are slaves of the courts, and when we get the message, we have to rush. The topic which is given is quite interesting. So far as the compensation is concerned, it is recently dealt with. Earlier only one section 357 of CRPC was there, but that was not adequate for compensations. Compensations can be given out of the fine imposed or a special provisions by giving a compensations by the accused to the victim. That was not sufficient, and therefore, as per the other provisions of the CRPC, the state government is required to come up with a scheme of providing funds for giving compensations. Now, whether these are adequate and sufficient. Ultimately, the way in which the incidences are occurring, these are not adequate because the provisions are concerned, the funds provided allotted is concerned, they are not sufficient. Can we leave the things as it is? And therefore, this discussion is there that what else can be done besides the government funds, court funds, and corpus funds, and other parts are concerned. I think that at the right time, considering the number of offenses increasing against women, there has to be a drastic provisions for the things. What it can be, one of the things which I am suggesting is that if the FIR is registered, a person is arrested, then attach his property preliminarily, temporarily, so that during the time of the trial which takes place, he should not dispose of his property, or the victim should not be without any relief. Because ultimately, if somebody is committing an offense, he must be ready to pay the compensations. Now, what will happen to that? You attach the property as it is under the enforcement directorate and other parts are concerned. And after examining the same at the initial stage, a part of it, if it is found prima facie by a senior judicial officer of a district and sessions court level, then it can be given to the victim at the initial stage, need not wait till the conclusions of the trial. If that is so, and if after the trial is concluded, and if that compensation is to be given, remaining part of it, that may be given from his own assets of the accused, because by the taxpayer should suffer, and from their budget the provision should be made, so far as the mischief of that particular person is concerned. And therefore, I will say that for making the provisions, if the FR is registered, a prima facie case is found, then the property of the concerned person should be attached, and if offense is proved, fully compensation, and before that, a timely compensations with other parts are concerned. I will draw some other parts also. That it may happen that the person is without any assets or so far as that parts are concerned. If he is working in some organizations, some companies or some things, and if the company is negligent about the duties or to protect the women's or the other parts are concerned on their premises, then the company may be asked to compensate. Company may not be prosecuted. Company may not face the criminal part of it. But if company has not made adequate provisions to protect the women's or other parts are concerned on their campus or premises or at any part, then the company can be called upon to pay the compensation so far as that part is concerned. The third part which I was trying to make out, that paying money is concerned not at all. If it has been found that woman is victimized, she has suffered, offense is proved or not proved, that is a different thing. Can we put some reservations in a job as per her qualifications? Because ultimately, how we are going to rehabilitate? And if she is a good at qualifications, then after having a psychological treatment, or if she required or other parts are concerned for rehabilitation, there should be provisions for reasonable reservations so that the victim may not feel that society has neglected her, or she will be find it difficult to come before the society unless she has a good ground for rehabilitation. And so I am suggesting that either in the form of employment or in the form of giving financial aid by the banks, which are the national banks or other parts are concerned. Can we provide her financial assistance to put up her startup or some business or other parts, so that she can be again given an opportunity to stand before the society in a proper manner without affecting the wrong things for which she has suffered. So I think that the present provisions are concerned, they are not adequate. Ultimately, if the government is concerned also, as we find it that it is not there, or if there is any other provisions, this is a very far-fetched. But if the women are working women, if they are even the entrepreneurs and other parts, can there be a possibility of the insurance against the wrong things are concerned, so that she can be compensated? Look, now we have to find out the new ways to compensate, and not from the present only sources are concerned. So can we do? We have to find out various ways, but in my view, these provisions are not adequate so far as that part is concerned. At the same time, I will also add, it has been said in the first sessions, Section 358 of Criminal Procedure Code is a provisions which is again unjustifiable. It provides that if a person is wrongfully arrested or arrested on a wrong complaint, or it is found that the complaint was false, then what the provision has been made is that he should be compensated with 1,000. So I think that this is a ridiculous provision. A person will go under the torture and trauma, and therefore in that event also the amount of compensations for the victim of falsely prosecutions should be adequately compensated. And for that purpose, there should be that if it has been found that the complaint is rather mischievous, or the complaint is there, but the officers concerned, maybe at a senior level of the deputy commissioners or other parts,
Very practical point, sir. Thank you. I hope our rapporteurs are taking note of that. There are other dimensions which may come in. Justice Ambadas Joshi sir's reflections. In the morning also, he gave certain input. Now I invite Dr. Purvi Pokhriyal ma'am, who is the Dean, National Forensic Science University, Gujarat, to speak about live-in and Section 494, the mutual connections in terms of gender neutrality and constitutionality. Over to you, ma'am. Would you like to respond to this? Yeah, when sir is
I will wait to listen your this part. I will be happy. Because
after women and also children. So what happened is that, recently we had one case where a girl walked into my hair and the law says because she is a minor, we cannot take. Okay, we cannot keep her in a home. And but then what was happening is that she was not getting the support of the mother. The father was harassing her. So in this case, we just did not know what to do. So we approached the police. Police said, no, you cannot give her admission unless she comes through the mother. Mother is not giving support. So, in this kind of things, we get caught up. We want to help the child and law says this and we don't know how to do. So that's another thing. Another thing what we face, these are thousands of cases that come to my head. Okay, so that's what where in the field we get caught and we don't know what to do, how to help them. Another thing is that the girl is being raped, she's become pregnant, and the mother says, please do not make a case because I have four other girls. And if it comes in the newspaper, my children will not be able to get good partners and will not get married. And also the father goes to the jail. That means who will look after my girls and myself? Okay, so this type of case, how will I don't know how you would have helped this case, or how you would advise me how should I help?
I think that this is a typical case, but there are no incidents without remedies. Always there are remedies in law and in practice. So if this is a positions, you can approach the district court, who is a guardian of these remand homes or other parts are concerned, and get I think that not district court, high court under the inherent jurisdictions can help you so far as these parts are concerned. Because the trial courts are concerned, they are bound by laws and procedure. But the high court is concerned, they are not bound by law and procedure. They are having an inherent power when they are exercising. And so definitely they will give you a relief because they have got a wide jurisdictions. So certainly there is a provisions that can be there. Look, there are legal aid provisions are there. And look, these are the exceptional cases. You are right, but when you say so, but ultimately where to go? Or there should be a sufficient legislations on that point that if such eventualities arise, then discretion may be given to the office bearers of the rescue home.
Madam, in this case,
And the second part which I was saying, I was just missed it, that as CSR is there for women's rehabilitations or for compensations, from the CSR, some funds can be diverted to for this purpose, so that you see the fund should not be a problem. In India is concerned, you can get the funds if you have a desire from any angle. And these parts are concerned, these are there, and which we are also facing same things. But then the question is that either we have to educate them, or the police can force them to file a complaint. But even if we file the complaint, he will not depose what is to be done or what is that. So that part is concerned. I think that more counseling, more other parts are concerned, that is to be seen. But for the first part is concerned, I think that you may get relief from the High Court, or under the POSCO or children's other parts are concerned, from the special judge or from the special courts, you may get something.
Sir, like National Commission for Women, any commission is there for children in India? Then madam can approach that commission for children. That is better, madam.
There is National Child Rights Commission, no? National Commission for Protection of Rights of Children.
No, mother is not willing.
Sir, 1 minute, sir.
Mother
Sir,
is not
just
willing.
half a minute. Sir, you made a mention of section 358 of the CRPC. In case of unlawful arrest or detention, compensation to the victim of unlawful arrest and detention. Earlier, the provision as it existed was 100 rupees. Now it's extended, it's enhanced to 1,000 rupees. But there is one more lacuna within this provision, is it's giving a discretionary power to the state with the user of that word may. The state may award compensation to the person who is unlawful.
That has to be amended.
It has to be amended. So there should be an enforceable right to compensation in case of such unlawful arrest or detention. And that provision exists within the international law.
I'm thankful that you are looking from both the sides.
Sir, just a footnote, what she has said. Recently, Law Commission submitted a report on malicious prosecution. And in this report, Law Commission has given interesting reforms. Suggest. Yeah.
Yes.
The Law Commission report is there.
Concerned,
yeah.
But after 7 years, more than punishment, earnest judgment is not applicable.
But at least some consoling fact is there.
No, but if you are giving a complaint of rape, where is the earnest one? Then there are various exceptions, and what the people do, that they give a formal notice, keep you detained, and after 5 hours or 7 hours, they will show your arrest. Compliance with earnest command.
Undated FIR.
We are very intelligent to come out of the
obviously.
So again, I say that the spirit of all the citizens in India must be there to protect the rights of everyone else than himself. If that spirit will be there from our education system, right from KG, then only we will have a better days, and which we all should make the effect of it.
Just another footnote in 357C of CRPC, the point which you are raising, that whether the accused is identified, arrested, prosecuted, convicted, the victim is bound to get compensation.
Yes.
He's already there. He's already there in CRPC.
Because by the time the trial will conclude within 4 years, 5 years, he will dispose of all his properties.
No, but even if he disposes of his property, you know better than I do, 421 CRPC is there, which says that it can be recovered as a land revenue.
यहाँ पर prosecution होने के बाद में 25 साल से निकाल होता है आपको सुप्रीम कोर्ट. So immediate attachment is the only thing.
These are theoretical knowledge, yours is practical knowledge.
I'm sorry, whatever I speak is from practical. I am not learned or academicians like you, so I learn from you. Whenever I come here, I say that I will get something to learn because I have no opportunity to learn my time when I should have learned. So I'm thankful that.
As far as this question is concerned, since this case.
I want to make a small point in the same context. I remember a very important document by Supreme Court for criminal injury compensation board. Yes, and I don't know what happened to that scheme, but the Maharashtra, the Manodharya scheme has come. And when you see the allocation of budget, it's terrible. I mean, I don't know how they decide budget district wise. And the substantive point which I want to make is this, that in India still compensation is regarded as an ex gratia measure. Still, we have not given it a stature of either institution or as a civil right. And we also have a reservation to this effect on ICCPR, International Covenant on Civil and Political Right. Although Nilavati Behra's judgment has to an extent, I think, blunted that reservation. Therefore, till substantively we accept right to compensation as a civil right and we institutionalize it with some cohesive body, you will have schemes like my own area where one district will get so many crores in another district.
Dr. Sanjay, what you are saying is already taken care of in 357C, which says that every state government, in coordination with the central government, shall establish a compensation injury board. There's a mandate now.
So hopefully
No, that's a mandate. There's a mandate, sir. There's a mandate. And well-established procedure is provided in the CRPC about the payment of compensation. So it is no more a charity, it is a matter of right of the victim woman.
So the other question is whether it should be only for that or should it also be extended in cases of in lieu of maintenance? Like in maintenance, commission has asked for recommendation that if the husband is absconding, today that district legal aid services authority guy was saying that husband goes absconding, husband doesn't have proper source of income, then in that case, whether district court can have a corpus fund.
CRPC provisions, it can be recovered as land revenue, the maintenance cost.
No, but
Yes,
such
yes, sir.
guys, usually such guys are losers, sir. They don't have anything.
Land revenue का recovery Jain साहब ने बताया ना 30 साल नहीं होगा. So that is not a remedy. No, let us look at practically. Therefore, in the morning, I gave that suggestion. Then let there be a corpus, let there be a general insurance fund. No, that is, wait. Once you call budget, it goes to state exchequer. My suggestion is let us have an insurance fund where at the time of marriage, 100 rupees will be paid. It's no money. But when it becomes a corpus, it becomes plenty of money. You know how much is the reserve with the provident fund.
That's true.
Therefore, let us be practical.
No, but sir, so how can a contract laborer have a provident fund?
How is your problem, not my problem? Yes,
No,
it can be.
a contract
I'll tell you.
laborer-
No, I'll tell you. I will tell you.
Term insurance.
Yes, it's possible. It's possible. Insurance of this type is possible. And for your information, I'll add, when Vikhe Patil was the minister in the finance department, he had coined a general insurance policy. Unfortunately, it was abandoned within 5 years. I know this. I had entertained a writ petition at Nagpur, which was ultimately allowed by the bench of Justice Brahme and Justice Gawai. You issue a policy, enter into contract, recover the premium, and then withdraw the policy. So it is possible. It's not a business. Therefore, I had used word in the morning. It's a social security measure. You pay for flood, you pay for snake bite. Why don't you pay for this type of calamity? And then I added, don't have everything from state exchequer. It's providence. You don't care for yourself, providence never cares for you. Contribute a little amount. For a poor person, we have CSR. We will mobilize the fund for their insurance. It's possible. That is how, since Mr. Jain was not in the morning session, he had freedom to raise the same point.
So, yeah.
I agree that beyond state also we should go. Look at the allocations. How much bailout?
No, please wait. No, please wait. Let me tell you. After I delivered that judgment, Amruta versus State at Nagpur, thereafter this scheme came, not because of my judgment. It came because of 96 Supreme Court. After the scheme, after the law was amended, there was a PIL at Nagpur. and the division bench gave an order to coin the scheme. Thereafter, the scheme came. So there is total lack of wholeheartedness, total lack of application of mind, no survey as to how much amount is required. And why may? Why not shall? Now an amendment is being proposed by an institution at Nagpur. I mentioned in my note that name is there, Disha. They are pursuing with the government for amendment. Funniest part, see, sensibility is the issue. All that I am arguing since morning is this. No sensibility. Honorable Minister told Secretary to give appointment to this institution, and Secretary doesn't receive the phone call. Total lack of sensibility. It's a matter of time. It doesn't happen overnight. Destruction has occurred over a century. Repair will take at least half. See what happens, this type of discussion, recommendation by Women's Commission, many articles in the newspaper, journals will trigger the issue further. Public opinion building.
Only Women's Commission can take.
Yes, yes. Therefore, this suggestion, I told in the morning that this is not a part of agenda, but someone has to initiate the discussion. So I took this opportunity. And as I told you people, I had opened it before 25 years. Even the audience did not accept it. Forget about government accepting it.
Okay, since we are dealing with, sir.
Even in Muslim law, there is no provision for maintenance. Only Waqf board is maintaining. Like that here also, the state should take the responsibility through endowment department, because Waqf boards are there. Here endowment department is there for Hindus. So for Hindus, TTD like that, if they approach, TTD is very rich and it is unable to spend the money also, that much donations it is getting. And it is refusing. Suppose for food, if you send donation, it is refusing. I don't want. Already enough money is there. For health, they are taking now. So TTD or endowment department like Waqf board, I think we have
That
to
suggestion can be going into the recommendation.
Why I did not support everything to be taken by the government? The historic legend of cradle to graveyard is fading away. Government is realizing the limitations. Salary budget of education department is 90% of the budget available for infrastructure. So let us not add to the burden of the government. Let us give a solution. Therefore, I said there should be contributory. The endowment orchestra. Please have the mic. See, this is, I am on the, wait. I am on the enhancement of prestige of the receiver also. Receiver gets out of a premium 1 rupee paid by her. Wait. There is no issue. I am welcoming this. I am saying one who pays 1 rupee has a title to get it. There is no charity involved in it. Therefore, that 1 rupee is according to me prestigious money. I am in support of all women claiming money with prestige, not for begging. Therefore, I said, let us have contribution.
Sir, thanks for the creative suggestion. It's a very good suggestion because we know we have an experience of Tata Trust sponsoring penalty money for women prisoners. We ourselves paid for one prisoner. A prisoner means we can use the word inmate who was not able to pay a small sum of money. She was accused under PITA, so we had to take the onus on community legal service and do that. So women are under such conditions that they are not economically independent. So this is a very creative suggestion that government, private public partnership.
CSR will pay the premium, but they will not pay the compensation.
Yeah, that is the way we can.
I am head of some temper. It is suggestion is not for that purpose.
But it's a good idea. We have so much arrested wealth in the country in that form. Yeah. So over to Dr. Purvi, who is waiting.
Thank you.
To
I mean, it
now
was
under
very
our,
interesting
segment.
discussions. Thank you. Honorable Justice Doshi, Professor Sharma, Dr. Shashikala Gurpur, all the esteemed panelists. I just would like to give quick 2 remarks. The first is very general and the second one is the specific on the topic. So when we talk about the improvement of the status of women, or whenever we talk about the empowerment of women through law and policy framework, the biggest challenge for all of us, right from if we see the history of the last 150 years, the biggest challenge for all of us, that how do we build a progressive framework which would be able to resonate to the changing situations from time to time. This is the biggest challenge. And this is what we all have been confronting in this. If you look at all the topics, most of them, we are talking about bigamy, adultery, we are talking about 493, we are talking about the neutrality of the provisions, inclusivity in the provisions. It's all about the aftermath of generation of reforms that we have identified. So in this regard, what I found is that I was just going through the standing committee, parliamentary standing committee report, which the committee has represented to the MHA in the year March 2021. And they have given the statistics of conviction rate of the offenses against women. And the data says that if we talk about 2017, the conviction rate was 24.6. If we talk about 2018, the conviction rate was 23.1. And in 2019, it is further reduced to 23.0. So the conviction rate for all the offenses against women has been considerably, drastically decreasing day by day. And the Ministry of Home Affairs have given a suggestion that what is the problem, where we are lacking. And they said, why can't we have an online investigative tracking system? And that's the reason some of you may be aware about, we have a justice clock that have been inaugurated in the Gujarat High Court by Honorable Justice Dhananjay Chandrachud. The same way, the Ministry of Home Affairs has suggested that can we have, specifically for the offenses against women, the online investigating tracking system. And they have been, MHA has mandated to all the states to set up this kind of a decoy system. But I don't know whether this kind of a system is yet to be developed. So in this regard, what I found, the NCW is doing a marvelous job. But at the same point in time, whenever we talk about the reforms in criminal law, and the first and foremost thing is the constitutional law teacher, and Professor Vibhuti would agree with me, that how do we constitutionalize the criminal law? Is not only about the substantive part of criminal law, but the procedural aspects. How do we bring the procedural justness, fairness, and reasonableness? How do we bring the dialogical approach that we grossly missing, and specifically in the case of women victims? We never ask women what do they really want at the end of the day. So where is the dialogic process? That is something which we have to think through very, very minutely whenever we are talking about this kind of a reforms. So in first case, we talk about bringing the changes in the existing set of system. That is one aspect of it for which we all gathered over here. But the other aspect is that can we, first of all, look at and study the existing framework? Are we really happy with the way, with the dispensation justice, with the having the set of laws which we have under IPC? I mean, what are the issues we talk about? Some of have already referred about the inefficacy of the police. We have been talking about the modernization of police forces. 3,000 crore budget in this. In the recent budget. 3,000 crore for the modernization of police. We have been talking about the having a scientific temperament in the investigation office, and that's the reason that the university like us, National Forensic Sciences University, we have a mandate to have every state should have a forensic science university, and the courses to be run by all the universities, because in a way we really wanted to see that how do we bring the objectivity and the scientific temperament, how do we lead the evidence in scientific way so that it reduce the subjectivity, and probably there are chances of increasing of conviction rate. So the first part of the things which probably we as an NCW or as a education institution we can talk about, that why the conviction rate is so low. We talk about 2019 conviction, only 23%. What had happened to the rest of the 77% cases? And state-wise, we take the data. I mean, the offense-wise, what has been the conviction rate in the rape cases in each state, where India Justice Report Professor Sharma has talked about. But then India Justice Report is only focusing on the main 4 pillars of the criminal justice administration system. I am suggesting that how can we go further dig down? I mean, we further dig deeper into this thing and look at the different kind of offenses and what has been happening, because we never had this kind of studies in the entire history of the Indian criminal justice system, that, in each state, how many, in how many rape cases what had happened, in the outraging modesty cases what has happened, in this cruelty to women, 498 mein kya hua. We never had this kind of a very detailed study, and probably once we get into this kind of a research, we will be able to identify so many other obstacles, and try to remove those obstacles first before we try and create new kind of a legislative framework. That's what I feel. But at the end of the day, what I'm being asked to speak on is 494 and live-in relationship. So it's very interesting to see Professor Vibhuti talked about the history of criminal law, talked about Lord Macaulay, how he started in 1931. So I was just going through the chapters of IPC. So all the scheme of the IPC is offenses against state, offenses against religion, offenses against public tranquility, public health, offenses against marriage. The whole IPC never talk about offenses against man or offenses against women or offenses against specific gender. But if you look at the offenses against marriage, invariably all the sections right from 493 to 498, I'm not talking 498A, because this is not a colonial gift. It is the gift of us because we introduced in 1983. But right from 493 to 498, which the original drafted by Lord Macaulay, invariably we presume that offenses against marriage, the person who is going to be sufferer is a woman, because we start with, even look at 493, start with a man, or a 494, it's a neutral in a way that it talks about male and female. But at the same point in 497, that thanks to Joseph Saine and Justice Chandrachud and others, now we are talking about the decriminalization, but 498 as well. So now if we minutely observe and read section 493, so it talks about deception. The first of all, deceiving someone, deceiving a lady and pursuing the lady to cohabit, right? Now, and then and we look at the punishment, I'm just trying to look at 375 and 493. Here we presume the consent, but the consent is given by deception, and consent is by deception. And under the deception, the consent is given and this cohabitation takes place. And then that is being considered as a lesser gravity offense than section 375. And in that case, I was the other day, I was going through the Richard Posner economic analysis of criminal law. And then he talked about that, ideally speaking, deceiving under section 493 is more serious than forcefully having the sexual intercourse under 375. Because here, the lady has an idea that I haven't given a consent and still it is being done. Here, the deceiving something that had happened, which is more serious and more graver in compared to 375. So the question comes over here is that do we talk about the sexual autonomy if we try to retain section 493 or for that matter section 498? Because again, it's all against female, it's only talk about only the men can elope the female. A female can also elope man. 493, a female can also deceive a male and then pursue the male for cohabit. But then that is something which is not an inclusive provisions. And when we talk about the empowerment of a women, by retaining this kind of a provisions under the statute book, I feel that we are undermining the sexual autonomy of a female. And how do we I mean, to what extent we go for this? Because what happens is, I mean, under section 493 or 494 or 497 for that matter, we have presumed that once there is a marriage, so marriage is giving you the lifetime permission, a lifetime consent to have a sex. You know, because once there is a marriage, there is the consent. I mean, the same thing, section 375 subclause 2, that all the recent discourse of Delhi High Court judgment. So I mean, so my humble submission before the August gathering is that if we are trying to retain 493 and 498, somewhere we are devaluing the individuality of a female and its sexual, her sexual autonomy. Because, you know, I still remember there's some, we have a very interesting incident, and probably you would like to know. We have an NGO called Ahmedabad Women Action Group in Ahmedabad. It is being run by Ilaben Pathak. She is no more now. But then, you know, at her center, there was one lady who had come, and she was complaining, and she was crying and complaining that, you know, today I was being beaten up by my brother-in-law. Because, you know, every day my husband used to beat, and that's fine. I mean, if anyone can beat me, he could be my husband. How can my brother-in-law beat me up? So likewise, you know, in marriage, you know, once you have, there are certain things which have been presumed, the same thing, the consent for the sex, or the kind of a liberty to impose some kind of a violence, some kind of an abusive, verbal abuse or a physical abuse, is something which is being accepted. You know, I mean, accepted in the sense this happens, that has been the accepted norms. And if you raise a voice, then probably you are, as someone was talking about, with all due respect to the advocate Jane, but it is being considered as you are someone who is not cultured one, who are not tolerant woman, and that goes against the Indian ethos and Indian culture and things like that. So my humble submission before this panel is that section 493 is at the most is a cheating, and then if we are considering anything more than the cheating, then we are undermining the sexual autonomy, and probably we need to rethink on these issues. This is what. Thank you. And the other thing I think I was to talk about the live-in relationship, because that's what is again there. So, you know, again, I mean, when we talk about 494 and 495, it's so difficult even to prove the second marriage, because the solemnization of the marriage is so difficult. You need to have it. So evidentiary value is something which is expected is very high. And in that case, we have been observing that people have been, you know, saying, and as the earlier speaker said, that, you know, live-in has become so very common in at least in the urban part of India. So at that point in time, there is no such law which prohibits an adult man and women to have any kind of a relationship and to stay together. So why can't we? Because, you know, if you look at the Domestic Violence Act, we have given a permission. If you talk about the Indian culture, we have a Gandharva Vivaha. If you look at the Muslim law, we have Mutta marriage, which is something which is being accepted. So it is something which was very much traditionally and culturally is also there in India, and in many other cultures as well. So, and domestic violence is already accepted, the live-in relationship. If we talk about the 125, the maintenance is also being considered. If we talk about the legitimization of a child, which is also now being considered. So I don't think so that live-in relationship is something which is which can be negated with the legal validity with the changing time. So this is what I wanted to submit. Thank you. Yes, those we have. I mean, under DV Act, we have already, if DV Act, under the Domestic Violence Act, we already considered as the.
Coming in offenses relating to marriage, the question is whether the offenses which are identified in relation to marriage should be automatically extended, or should we make an amendment in those relevant sections? Marriage and relationships are resembling.
I think in some cases court awarded maintenance.
Yeah, 125 maintenance, even the legitimization, inheritance rights. We have a recent judgment of 2017 when the inheritance rights was also been awarded. Yeah, we need to have a codification. Yeah. Yeah, yeah, yeah. There is a huge conundrum. It's no one. I mean, I think it's not much discussed. Professor Vibhute was there after Navtej Singh Johar judgment. The remaining part of 377, there is no need to have a separate, because the remaining part of 377 does not constitute it a separate offense. It is always to be read with section 375. And then we make it as a gender neutral law. So somewhere I think this is something, because 377 loses importance. It doesn't constitute it a separate offense unless and
First part is unconstitutional, second part is intact.
yeah, but second part does not constitute it a separate offense. You have to read it with section 375. That's what.
For example,
Yeah, so that I agree, but then with, I mean, the bestiality part we keep aside, but I'm talking about the human interactions. At that point in time, with the human, you have to read it with section 375. That's what the point is. Guardianship is also allowed. Everything is allowed. Inheritance, guardianship, maintenance.
The father, the children should have shares.
Share.
No, 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 no.
So when you're talking of criminal liability, it has to be beyond reasonable doubt. Now, in countries like Denmark and a lot of European countries, they have something called a domestic partners registry. Today, if I decide to go and live with somebody, all I have to do is walk into the office, two people sign, we are going to live in, and tomorrow, let's say any offense happens. That gives a ground for one party to file a case that, okay, I have been wronged by this person who was my partner, or as what, with respect to live in, if whatever doesn't proceed further, things happen, anything goes wrong. So when you're talking of criminal liability, there has to be some ground. Today, like, let's say somebody files a case against somebody stating that, okay, so-and-so person has done something wrong to me. First of all, something has to be proved that there was a relation. Now, a domestic partners registry will actually give some standing, like Denmark has already implemented this. And it's so simple. You just have a book. You just go and write it. But that's a very difficult process to prove. See, who's going to fight it that long? Why not make it easy with a registry which is there in other countries? Yes. And just have a register where, people just walk in. It's free. In Denmark, it's a free registry.
Proper definition.
You won't even be removed from that registry. That now I'm not living with so-and-so person. Something on that line, if we can have it in India, when we are legalizing it in every avenue like guardianship, maintenance, why not just have a registry?
If you will ask for the documentation, they will not come forward. They will not recognize this.
She's saying a registry, like we have in police stations, there is a registry of domestic
People will
workers.
just walk in, both people sign with their ID proofs, and the day you're not living with each other, go and inform in the registry, you don't live together. You have to just give the proof.
So where should there should be an online registry? Yeah. So that is a
Ma'am, that becomes a contract, in fact. How that becomes a contract? How does it come under criminal law?
People may live in it's not a contract, just a registry. It is an acknowledgement by two parties, because if they are staying together, there is no offense. Right? So it's an acknowledgement by two people, I mean, two partners, that we are staying together by mutual consent. It's rightly pointed out. So suppose you stayed for 1 month, you don't agree and you don't want to register. That's it.
It's cohabitation. But whether every cohabitation is marriage like that's the yeah.
No, but I don't call it a husband and wife relation. It's a domestic partner.
So the registry can have those conditions. Yes. Yeah. Registry can have that checklist. which will say whether we are living with
So at
consent
least,
as
when
couple
you
plus.
criminal litigation are not going on, where in any conviction for any criminal case, I'm sure any criminal lawyer will tell you, it has to be beyond reasonable doubt. Circumstantial evidence will support. But there, a good lawyer will find enough of reasonable doubt, enough of loopholes that can be created around that. So, when you have such strong basis, people support a law.
Which department will go and register?
And the confidence of people,
Which
like
person
younger
will-
generation today, see whether
Whether we will go to the DM.
No,
Yes.
see, see, that I think it is the only conduct of companionship. It's a companionship. It doesn't come under criminal law. Even if you register, it's a companionship. You have agreed to stay with me, I have agreed to stay with you.
Agree to stay, but that doesn't mean licensed criminality.
No, where is criminality?
So that's what we are dealing with.
No, but see, if criminality is there, sir, एक minute, I have another point to make. Now, if you look at penal code, fornication is not an offense. And if you read the Supreme Court judgment, they are well defined what is live-in relationship. The man should be married or unmarried, but the woman should not be married. That's if you look at the first judgment, I think Nagappa judgment, just Nagappa.
Even women is married.
Now it is married.
Now, when we are fighting as a domestic partner, both of them know we are not talking marriage. We are talking, okay, for let's say 6 months, we are going and signing, we are living together. So then the question of consent, the question of somebody taking advantage, so many things are not there. It is a very clear communication between both parties on the expectations. From that perspective, so you are actually reducing a lot of, you are actually.
Madam.
Yeah, no, what I was thinking, why I am talking about, like when it is not registered or legalized, what happens is when either partner dies or anything happens, and say the property belongs to one particular lady, and that person died. Okay, so the partner who was living with her has, because her brothers came and said, this is all my property and I own this. We own this, not you. And so she had gone there as a servant and later on became a partner to that particular lady. And then this lady is left with nothing. Okay, that is what we are asking. Once they are domestic, it has to be legalized. Otherwise, what happens when it is not legalized? Then they suffer.
May I add? May I add?
Yeah.
The moment you are naming the domestic partners registry with respect to inheritance, in the case that apart from their
Let us not mix. Let us not mix civil law issues right now. Please wait. Please wait. So let us separate it. We are considering the criminality aspect of it. I have something to add, but Mr. Abhankar is waiting to speak. I'll listen to him.
When the court will find, and since between the promise, misconception of fact, promise, these cases, then couple is coming together out of that, the relationship, promises are given to each other, which is a common phenomenon. And the problems are created in matter of rights. To take a revenge, why not to prosecute him under 375? Then in such cases, why the accused is to be totally blamed for? When she has participated equally with full understanding. Why the accused to be blamed for? Is it the right remedy, criminal responsibility? The court has answered it very clearly, saying that maximum remedy she can avail of thinking.
Mr. Abhankar, you are talking about the definition of rape. We are not on that. No, wait. They are already living together. Question is whether it should be equated to marriage for the purpose of all these sections. That is the debate. That is the debate.
Section 19(4) when both are living together out of relation, out of passion, out of love affair, promising each other, promises are given, and both are lived for some reasonable time period, and later on she decides that now I want to take a revenge and I'm going to prosecute you under 375. Let me see what you can do. So what is the question?
In fact, the point of consent in such deception case is already dealt with by Madam Purvi, that this should be considered as an aggravated form, worse than the lack of consent.
Maximum remedy in these cases, specifically, that civil remedies can be from going to civil court and claiming compensation. But criminal prosecution, you cannot compete with by imposing liability.
No, that is well taken. Point is, when they are living together, there is ill treatment, what to do? That is the issue going on. Wait. And for that answer is, wait, we are not on the remedy. We are discussing about law. For that answer is, there is a first question and then answer. Do you want to equalize the living in relationship by amending the definition of marriage? Then it becomes bigamy. Nobody wants it. Nobody wants it. Therefore, be cautious while we suggest an amendment. That's all that I want to say.
So what should be the amendment? Let's come to the solution.
Then tell the amendment that you propose.
It is true what you are saying, that, but what I feel is, supposing this guy, now we know that it is, I mean, there are so many couples who are living that way, okay? So why make them live, how you call it, secretly? Let it be open. If it is legalized, then I feel it will be, I don't know how you call it, I don't know.
It's not illegal even today. It's not illegal.
Yeah. It is true. It's not, what you are saying, it's not illegal, but neither it is legal.
Shall I say something? Mr. Ambedkar, yeah. When this question, court tried to find out that when it can be looked upon as cover and she can claim as a matter of right starting from there. For considerable period together, and in that he both were considered as couple together. That kind of impression we are able to create, that she can, and other partner can claim right.
So this, please tell your amendment, sir. What is the exact amendment? No, not your suggestion. Your suggestion.
If you are convinced, some amendment is required, please tell them.
So what should be the approach for future if we are bringing in living relationships in parallel to marriage? What should be the precaution? What should be the approach? Do we totally exclude it? Leave it as it is? We can't, because living relationship have become order of the day.
Yes.
So how do we incorporate a provision which does not result in total injustice also? A very balanced provision. How should we?
So what madam is telling, we can say both unmarried couple, in case they have live-in relationship without registration, is an offense. No, without registration. No, if you incorporate that, persons. No, if they want to live in, no, it is a.
Recognition under the law of the
we can leave it on circumstantial evidence. First, give the definition and leave for the prosecution, leave it on the circumstantial evidence.
That is much better.
Circumstantial, when there's a problem.
Then when there is problem.
There is no problem.
Now they are doing that only, sir. Now they are doing, courts are doing that only.
But we have to codify it. We have to codify it. We have not yet codified it.
So what is the codification we are asking the house? What should be the codification?
We have to amend the definition of marriage and we have to include this in the.
Okay.
One minute. Other rules or something like that. Amend marriage first. Do we include? Marriage means and includes
relationships in semblance of marriage, such as live-in relationship.
No, anyway, considering the, no, let me add something now. Considering the overall feel of the people and the suggestion that had come with one rider, whatever Madam Shashikala had said, I just put few words to that. You please continue with whatever dialogue you had done. Limited for the purpose of criminal liability. Do that amendment. Welcome.
Anyway, this is one recommendation, that's all. That is up to them. That is not the problem. Okay, this is relating to marriage.
No, wait a minute. Please don't forget the basic canons of criminal law. Offense has to be specifically defined. Liability for what?
No, that is there, sir, the sections which we have taken.
Which section? Which section?
Which the commission has
No,
specifically
his point is, where is the definition of wife?
Huh? Justice?
She doesn't fall in the definition of wife.
Yeah.
That is your point.
Yeah. Liability for what? No, but Benji, liability for what? Criminal law has to be specific. There's a basic canons of criminal jurisprudence.
So my understanding is that live-in relationship is not illegal as on date. It is already recognized. Socially accepted.
Sir, only for section 494.
And the legal rights are also being accepted.
Only for section 494.
494 comes into play only when one of the partners is married.
So we are saying.
Not married.
But you know what, my thing is that at the end of the day, when their partner dies, and if she is not legally married, the other partner gets nothing, no right to that thing. That's what my point is. So if
That
there
is out
a-
of the bounds of this one, because this is criminal law. We are only talking about offenses. Yeah, that is a separate issue to be taken under personal law, which has been, in many cases, courts have reflected on.
No, ma'am, there are cases in foreign jurisdictions, even that woman can claim for compensation for leaving the chastity. She can ask for losing the virginity. That becomes civil matter, not under criminal law.
So here, how do we go about with 494? The commission is asking the question, should live-in relationship be deemed to be relationship in the nature of marriage? Semblance. 494. 494. Section
494 कैसा आएगा मैडम?
That is what
Married,
commission is
none of
asking.
Give a negative mandate, I'll tell you why. Because
ये कैसा आएगा?
That
They
is
become
what we
married.
are asking.
but that won't come.
498 में आ सकता है, 494 वैसे ही
कैसा आएगा?
बहुत कम आता है।
नहीं, 494 में कैसा आएगा? Married नहीं।
Theoretically, 494. One 494, second 494.
Sir, Madam, offenses relating to marriage, a provision can be added separately. which
Then it
will
is
take-
498A for the purpose of 498A.
No.
Actually, we are discussing this only for the 498A. We are discussing all this topic only for the 498 Act.
498A will come into picture when there is a marriage.
Yeah.
So this is not.
No, we are saying there is no marriage, but there is violence.
But then we have.
So should we exclude it?
No, it will be covered by general law. It will be taken care of by general law.
Ma'am,
When there is criminality.
no, ma'am, there is already a domestic violence act is there to take care of this. Already is there.
Domestic Violence Act is a civil law.
It's civil law, but 125 maintenance you can get.
Provision of blue and black
Like
marks
section
है.
375 subclause to exception है, ऐसा यहाँ पे proviso add कर सकते हैं.
I suggest there should be an exception or proviso to include the living relationship. Yes.
In domestic violence, can they add that?
But a civil remedy, sir. See, domestic violence is a civil remedy. They won't get a criminal remedy under domestic violence.
हमारा problem क्या है? Add करने
Protection or offices में, they will get a shelter. Domestic violence is a civil remedy. It's not a criminal remedy.
In offense related to marriages, we can provide, we can define.
जैसे आपने वहाँ पे exception किया ना 375 subclause to ऐसा आप यहाँ पे कर सकते हो.
No, sir, madam, 498 में you are missing the basis of 498. 498 talks about cruelty in demand of dowry, if I understand correctly. Wait a minute, sir. 498 talks about cruelty for asking dowry. Cruelty, that's true, cruelty, na?
Yes.
But if she is harassed, she can ask for remedy under Domestic Violence Act.
No, that is civil.
Married women, whether she is accepted as
Sir,
a married
हमारा
woman.
problem क्या है? उधर marriage के लिए
प्रॉब्लम इसमें है सर, मैडम, प्रॉब्लम ऐसा है, slowly law is destructing the institution of marriage. If you add this one,
marriage है तो ऐसा होता है.
destructing this institution of marriage. Okay, madam?
Marriage क्या है sir?
Recognize this one.
Sir, it is chicken or egg situation. If there is violence, it's not a marriage anyway. It's a dead man. किधर है chicken? What is, we cannot have contradictory or logically flawed approach to these things. Either you say that our main aim is to address the crime, which is a stumbling block in human development.
That is done at the NCW. Wait for some time, socially recognized, and we see.
Socially recognized this country में होता नहीं हुआ. Sir, Tirukural में already recognized for centuries in Tamil Nadu, in Kerala. Fantastic examples are there. Sir, social acceptance can trigger the law, but law can also trigger social acceptance. Law can also reflect social acceptance. India is not a country. There are communities, the community I belong to. Women have the right to leave husband's house and live with any man they want. It is there. So culturally, we are not that backward.
One more problem.
I'll say when.
Living relationship, if it is both, in case both parties are Hindus, are Muslims, are Christians, then the personal law also will come into picture.
No, we are looking at a crime.
The way we
Crime also.
sir, we are equating violence, domestic violence remedy in the criminal law by any proviso under 498. They have to be an equal footing.
Then what about Muslims? What about Christians? They are amendments only IPC.
Sir, we are IPC की बात कर रहे हैं, criminal liability की बात कर रहे हैं. जैसे उसका मतलब ये कि दो लोग साथ में रहते हैं. अभी वो married, they are not married, they cannot go to 498. अभी वो live-in relationship का provision रखे हुआ है, even if they are not married. Someone is creating, the husband is creating cruelty, the living partner can file under 498. Jैसे domestic violence.
So let's conclude in 1 minute that a marriage or relationship. क्या बोलते?
Okay, one provision within 7 years from the date of marriage. That section. After 7 years.
304B that is dowry. 304B
that we are recommending to dispense.
498.
Yeah, let's go fast.
Can I tell the feel of the participants? Should I describe the feel of the participants? Collective.
Give your verdict.
Yesterday only I read the principle. That is not a
Sir, Indians have never agreed on it.
Yes, that is what. So when we do not agree on anything, we agree on the agreement that we don't agree. And we find a common factor. That is how it is done. So common factor here is, for the purposes of 498A, living in relationship will be deemed to be marriage. That is the question that is in the mind of the commission. That is the question in the mind of the commission. Mr. Vibhuti, that is the question in the contemplation of the commission. I have followed your point. In text of the question, it is not there, but in the mind it is there, which is expressed. While you are discussing amongst yourself.
494 talks about different thing. 498.
This was 498A only.
So 498 is more.
That is the focus. Therefore, I said, let me give a concurrent feel.
This has come from NCW. He is clarifying.
Right now representing NCW.
Not necessarily, ma'am. This is mine.
Okay, but that is the probable view. It's not an extraneous view.
So should the sexual offences be gender neutral? Should sexual offences, this is one of the recommendations of the Law Commission. Yes. Should sexual offences be gender neutral?
Yes.
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 And in the light of constitutional
In that
morality,
case,
etc.
we need to have a
Citizen
provision, we need to
committee.
remove the woman word from the section of 375.
No need to.
Even,
Just
so we are talking about
re-
gender.
re- replace man word by person.
Ah.
When it is a man, it is a word by person. Both genders come.
Very good. Person.
And need
So
to
that will
define the
include
explanation
transgender.
part also.
Yeah.
Section 375 explanation is also to be removed, no?
Which explanation?
So the explanation part.
One explanation.
In alpha integration is to be removed then.
One explanation says.
Modified. Not
I mean,
removed.
modified.
Modified.
No, then you say the first explanation be suitably modified.
मॉडिफाइड कैसे अभी दैट इज अमेंडमेंट एक्ट के अंदर भी मॉडिफिकेशन हुआ है वो मॉडिफिकेशन इधर पढ़ना पड़ेगा इट्स ऑलरेडी एडेड आई थिंक या
इस पॉइंट पे नहीं है थोड़ा मॉडिफाइड
हां थोड़ा मॉडिफाई करना पड़ेगा इन द लाइट ऑफ द अमेंडमेंट व्हिच वर्मा कमिटी सजेस्टेड ओके दैट इज डन देन शुड लिव इन 498 in the light of 498 okay done. So now let us go to the next speaker, and the next speaker is Dr. Rajashri Varhadi, who is
Please consider question number 10 minutes to listen because it is going to have very long-term implications.
You need mic. Everybody who got here.
no live-in relationship exclusion is
No,
not
I am requesting this body, including the chairperson and our lordship, don't be in a hurry to answer question number 10 because the way in we are going to suggest is going to have long-term implications. But because they are going to take our suggestions very seriously.
Sir, 1 minute. What is your worry about question number 10? You are talking about that end part, which is a section. Leave the section. As far as offenses relating to marriage in broad sense, let us look at broad concept of offenses relating to marriage. आपका problem क्या है?
मुझे प्रॉब्लम 494 मेरा प्रॉब्लम 494 से भी है 498 से भी है. Don't make mention of any section. Other than I don't have problem.
No, the question is relating on top. I mean, if I can talk about interpretative principles from the title, if you go, it is a generic title of offenses relating to marriage. So if marriage is defined to include live-in relationship, what is the harm?
Limited for the purpose of this chapter.
Here only we are talking about, sir, we are discussing the general clauses act. We are discussing.
Maybe narrowed down.
In sexual offenses, before we cross that point, we include digital sexual offenses, which can carry as separate sections. So whether it may be consent with consent videos which are misused later, revenge porn, or anti-spyware, malware, which is like spyware on your cell phones, which is taking your own personal videos and uploading.
But didn't we pass that in the morning? Didn't we pass that check in the morning, saying intersectionality of cyber offense should come in IPC? That has come. That gate we have closed.
Chapter can be.
Including for digital play, wherein when you are talking about the definition of this in a proper fashion with the ingredients, it is very complicated actually.
Yeah, that is relating to sexual offenses. We are now talking about offenses against marriage. So in offenses against marriage, those segments will come in a general way. We are talking about offenses against marriage and defining marriage. While defining marriage, live-in should be considered as relationship.
For the purpose of this chapter.
Madam, then one thing that a lot of cases for those who are practicing in family court, most adultery today is what is adultery on WhatsApp. Whether a person has had a physical relation or not, today it is a concept on Facebook threads, people are having affairs on.
That's not an adultery. It's not an adultery.
It's not, but majority of your cases are actually being filed on these cases.
No, it cannot be an adultery. It doesn't fit into the
No, it's a fact of the matter.
Cases are being filed.
Evidences and other things. Now let's come back to this. We'll cross this check gate. So how many of you say that live-in relationship should not be considered as equivalent to marriage? I mean, this is a settled point of law in the personal law and other areas. So in criminal law to bring it, sir feels that marriage institution is under threat. If that is done.
It is going to be long-term implications.
What is long-term negative implication according to you?
This is the anxiety. Let us not give a concurring opinion. Say we need time to deliberate.
No, that time इनके पास नहीं है ना. We give from this house. How many of you say that live-in relationship should be included as marriage?
Should be included. Yes.
Included where?
498A में proviso डाल के.
with the provision.
494
Sir, that is told now that it might be an error or broad thing, but.
We are not agreeing in terms of the question, saying that do
Talking
it in
about bigamy
494.
and we are talking
We are
about
saying
broad
do it
things.
in 498.
Actually,
So majority are agreeing, done first. Okay, let's go to the next one. So please, Rajeshri. Yeah. Because we are already 4:45. Yeah. Yeah.
The last speaker embarrassment.
One more is there.
Tapan Mohanty is there. There are 2 more speakers. Madam is there.
Honorable Dr. Shashikala Gurpur, Dean and Director of Symbiosis Law School. Honorable Justice Ambadas Joshi, sir. Honorable Professor Dr. KVS Sharma. Honorable Dr. Vibhute Kushal. My dear friend Dr. Oza, Professor Tapan Mohanty from NLIU Bhopal, and other distinguished delegates and participants. We are going to discuss here about section 304B of Indian Penal Code. I think we must seriously look into the definition where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death, she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry. Such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. This is a definition, and I wish to raise concern about the word soon before her death. Soon before her death is not defined here properly, means how much is the period soon before the death. So it is 1 day, 1 week, 1 month, 1 year. We don't know. It is not specified, and it leaves scope for acquittal of the accused person. And another, this itself is a vague term, soon before her death, and this why 7 years of her marriage is specifically mentioned here, because sometimes this kind of causes are continued till many years, and that is why this 7 years we have to think that whether we have to change this 7-year term. Other laws relating to dowry death prescribe section 174 and 176, which deals with investigation and inquiries related to causes of unnatural deaths by police and magistrate respectively. Indian Evidence Act 1872 prescribe provision under section 113B, which has been created regarding the burden of proof in dowry death, according to which court has to presume that a dowry death was caused by the person who is shown to have subjected the woman to cruelty or harassment soon before her death. Again here, a 7 years period is prescribed, and I think we should give a thought. There are dowry death causes due to several demands of dowry much of the time, and it continues for a longer time. Recently, National Crimes Record Bureau finds it out. As per their data, dowry deaths number in 2001 was 6851, and in 2012 it was 8233. Pending trial cases are 21,922 in 2001, and 2012 27,969. You see pendency of cases, which shows that before judiciary, cases are pending for years and years, which many of the time resulted in acquittal order of the accused person. This is a shocking statistics. In 2015, dowry deaths reported were 74, and in 2016, 92. In between, we have faced Corona period in which very few mega cases were reported, but National Commission for Women receives, they have started helpline, and domestic violence cases were increased. And they try to help them by counseling and other ways. I wish to point it out to this August gathering
that what happened about cases which are not reported. There are people, there might have cases increased, their dowry deaths must have occurred, but cases are not reported. There are several reasons. They might not have reached up to the police, or due to illiteracy, or due to their prestige issue in the society. People do not report such cases before police, and that is why such kind of things are encouraged. This also happens. We should not feel happy that there are less number of cases, but rather I feel disturbed that cases are not reported. Cases have taken place but not reported. Much of the time when these women are reached to police station, then nowadays women police are there to help them, but police are reluctant to register FIR. And in this way, they do not wish to go there again and again. In courts also, many of the years cases are pending for years and years. Fast track courts are established, but in sometimes we have observed that justice hurried is justice buried. Much of the time it happens after the death of a daughter, few relatives are interested in punishment for the offender, but much of the time father thinks that now my daughter is not there, and why then again and again go before the police and go before the court of law and repeat everything and prove everything, and that is why they leave it, and it leaves scope for the offender, which resulted in their acquittal. In under the Dowry Prohibition Act, punishment prescribed, which is that imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years, and with fine which may extend to 10,000 rupees. Now you just imagine such a minimum punishment with 10,000 rupees, which means nothing. Anyone can commit this offense and just give this amount, and for these 2 years, minimum 6 months. You just imagine, so it leaves no deterrent effect on the minds of offenders. It rather encourages them to commit such kind of offenses. Madam, Dr. Gurpur, madam, we must have stringent punishment, and which should leave impact of deterrent effect on the minds of offenders, so that they should never deter to commit such acts. In the second year of the pandemic, the National Commission for Women received 30,865 complaints, of which 72.5% fall in 3 categories: to secure their right to live with dignity, 36%, protection from domestic violence, 21.6%, and the matters of harassment of married women, including for dowry, was 15%. National Commission for Women, as per their data on the portal, in 2021, the complaints pertaining to securing the right to live with dignity shot up 44% to 11,084 compared to 7,715 in the previous years, which shows that awareness about working of the National Commission for Women is increased. And credit should go to Dr. Gurpur and other academic institutions which time to time organize such kind of consultation program and awareness program about the rights of women. NCW launched a 24/7 helpline for women. It also helps them a lot. The cruelty has to be proved during the close proximity time to death. It should be continuous. Such continuous harassment, physical or mental, by the accused should make life of the deceased miserable, which may force her to commit suicide, is observed by Justice Hima Kohli. In Vismaya versus Nair and Ayurveda medical student was found hanging in the bathroom of her husband's house at Sastamakota in Kollam district on June 21, 2021. Her father gave statement that they gave hundreds or inches of gold, 1.20 acres of land and car worth rupees 11 lakh. But Kiran harassed my daughter saying that car does not fit his status. So nowadays, for dowry, it has become a prestige issue. And sometimes it is observed that even daughters' parents are very much interested in giving dowry and spending money at the time of marriage because it has become a prestige issue in society that we are rich, they wish to show. And they think, parents think that they will give her more respect once she goes to that house. But actually that is not correct. We have observed. Another case, Vismaya Nair dowry death case, where the 500-page charge sheet says that Vismaya committed suicide due to dowry harassment. There were about 102 witnesses and 56 pieces of evidence in connection with the case. The evidence also included digital proofs of Vismaya being tortured by her husband. Aisha suicide case, it was also very much popular. 23-year-old Aisha ended her life by jumping into the Sabarmati River in Ahmedabad. Police have accessed a call recording in which Aisha's husband can be heard telling her, "Go, die, and send me a video of your death." Family alleges Arif was having an affair. Aisha's family alleged that Arif was having an affair with another girl. The claims are being investigated by the police. Police are also investigating whether Arif used to harass Aisha to bring dowry money because of the third woman. So many cases are going on about these dowry deaths, and I think we are unable to prevent such kind of increase in number of dowry deaths cases. First issue of section 304B, which requires some perusal, is the 7 years limit for dowry death. Claims to benefit from the presumption that the defendant caused the death. Section 113B of the Indian Evidence Act 1872 will allow this presumption if evidence of cruelty is shown and only if unnatural death occurred within the first 7 years of marriage. The 7 years limit must be reassessed since the reasoning for its existence is flawed. The rationale behind providing this limitation was that 7 years would be an ample time to calm an abusive relationship. But as we heard about the cases where criminals are waiting until the 7 years are over to kill their victims, it becomes clear that the abuse will not stop as long as there is economic gain from it. 7 years limit only postpones murder since demands for dowry recur throughout a marriage. Time should not be a determining factor when claims may be brought. As long as the abuse continues, it should be punishable by the law. These ingredients of section 304B of IPC are vague in nature and must be defined concretely to cover all aspects under dowry death. Death of a married woman must occur within the 7 years of marriage. Demand for dowry cannot be limited to first few years of marriage, which there is need to review this tenure of 7 years. It must be revealed that soon before her marriage, she was exposed to cruelty or harassment by her husband or any other relative. The term soon again creates confusion and it should be specified specifically. My question before this August gathering is that whether we can prevent dowry deaths. I feel very sad whether we are unable to reach such victims of dowry deaths, and we are unable to provide them all assistance. We are unable to empower women that when she is harassed, someone kills her before that. Why we are unable to reach our assistance, our help to such women so that such dowry deaths can be avoided. Purvi has raised concern about low conviction rate in offenses relating to women. Whether state government, NGOs, police are unable to reach and save life of victims, we must discuss what can be done more. We have sufficient laws, several legislations, but I think in implementation we are lacking, and deterrent effect is absolutely not there. And day by day, offenses against women are increasing. More stringent laws and punishment should be prescribed so that deterrent effect should be there. Women should not be treated like a commodity, and dignity of a woman must be respected in all manners. Thank you.
Very important issues, and you have recommended that this 7-year limit should be deleted, and you have also said the vagueness in the legislation in terms of soon, so I do agree with you. We conducted a public trial, I still remember, with the assistance of Vimochana NGO and in Bangalore, and we came to know that most of the parents of these dowry victims did have the clue, and violence was in a kind of escalating, ongoing kind of way. So what we can suggest here is, how did they arrive at that 7-year formula? I mean, there was no rationality on that 7-year formula. Today, a lot of mental health evidences, psychological evidences, a flurry of case laws are there. So based on those evidentiary dimensions, we can probably suggest some modification to this section and put a kind of proviso. They may ploy to, they harass and then they ploy to kill after 7 years, maybe one day after 7, 1 month after 7 years. Such evidences have come before, and because maybe police will tell better about that. So this is the kind of gist of what you have said, and it has been put for polling. Thank you, ma'am. Very well done. Now, we are coming to the next part where we have a very important executive officer, Ms. Purnima Gaikwad, Deputy Commissioner of Police, Pune. We have been very honored to have you with us, ma'am. Ma'am's biodata I request Lasya to beam. And Dr. Bindu, please, you can introduce ma'am maybe. And ma'am is going to highlight on very important provision related to pre-arrest or other procedural safeguards in 498A. Because I don't know, ma'am, if you were privy to that about 3 years ago. We were still in the old building. I vaguely remember in Pune, in a family, all the senior members were involved in such a case. At least they were booked. So one elderly member committed suicide in the aftermath. So there is a boomerang effect on booking of all family members. But on the other side, as activist, I would have seen this strategy working in getting the whole case settled faster also. So I have seen both sides, but I would leave it to your experience and wisdom to come through in the light of 243rd Law Commission report. I remember I was on the 19th Law Commission and I was a single woman member, and defending the non-bailability and cognizability of 498A and non-compoundability was very difficult. And one of the things they introduced, they allowed finally subject to this guideline, but it has been slightly diluted in the current report and current proposal before the government. I think here we need to be very rational and very neutral. I'm sure you will do a good job. So over to you.
Ma'am, before we request Purnima ma'am to speak, may I request Gurpur ma'am to felicitate madam. Thank you very much. And Madam Purnima Gaikwad is an alumni from Ferguson College and Pune University. She is the Deputy Commissioner of Pune Zone 3 She was in the intelligence department. She also served as the superintendent of police, CID, Konkan Range, and commandant, SRPF. We are very happy, ma'am, to have you with us, and we wait to hear you on your talk.
Good evening, everyone. Good evening, sir, and the esteemed dais here. Good evening, all member participants. I was given this topic at the very last moment, and I'm sorry if I do come across as unprepared. I will talk from experience here. We all know, I will not waste my time on it, but why Section 498A was introduced according to the amendment, and in 1983, and 413A was made a presumption clause was added. And the subsequently all the case laws that came up with, which was seen to be sort of safeguards against the misuse of, so-called misuse of, and I say so-called misuse with a lot of responsibility. I to you certain statistics that that I could source. The National Family Health Survey of 2005-2006 says that 40% of married women between the ages of 15 to 49 years experienced emotional, physical, and sexual violence at husband's hand. For men, in that same period, it is just 1%. So according to 2011 census, that amounts to 9.7 crore women. Of the 24 crore married women who were subjected to sexual, emotional, and physical violence. The NCRB data shows that of these, only 113,403 cases in 2015 were registered who faced marital violence. And of these, around 90% were charge sheeted. So this shows that the efficacy, and only 3,314 cases fell for mistake of fact or law. In my experience, we have seen that although it is non-compoundable, that most of the times when this has been failed is when the woman succumbs to all the sort of requests from the husband's family members, and that is when she refuses to stand to her version of the violence in the court of law, and that is when it fails, not because of any investigation failures. So having quoted these statistics, there should absolutely be no doubt about the need to have 498A with all its concomitant safeguards that are there. Quite a few safeguards were introduced by the Arnesh Kumar case, which said that 41A should be given out as a notice before effecting arrest of the husband. That is being very scrupulously followed by the law enforcing agencies. Sort of, again, so to say, precursor was introduced by the Lalita Kumari case, which said that the preliminary inquiry should be instituted by the police before registering an offense into 498. In this, I would like to state that a lot of commissionerates in Maharashtra at least have a good foolproof system of having a sort of a conciliatory mechanism at the commissioner level or even at the unit level, DCP level, where we have a system of having experts, we have a system of having counselors on board who will sit and counsel before and try to counsel before agree or before saying that fine, this is an irreconcilable conciliable case and 498A should be filed. And on that report, we go ahead with the filing of the 498A case. In Pune, especially, we have a cell called the Rosa cell, which is a very, very foolproof institutional arrangement that has been introduced to safeguard any kind of fallout, any kind of, in the sense that if the conciliation has to be reached, it has to be reached before filing of the 498A and not after it. So that kind of a mechanism is very much alive, kicking and working in Pune. And it has, I must say that it is a very successful experiment with respect to 498 cases being filed. Another case that introduced a lot of safeguards and which in fact flagged this entire issue was the Sushil Kumar case, which said that legislature needs to actually deliberate on how we can prevent vexatious complaints with respect to this 498A. And the latest the Rajesh Sharma case. So that in fact has given a lot of provisos with respect to directives to the police, in which you have to do certain things. In fact, an SOP has been spelt out, a list of 8 to 10 directives where the police should go to a magistrate with a checklist if he's seeking detention of the husband. And that checklist has to be verified by the magistrate. The magistrate has to give his reasons either for or against. If both of them, the police and the magistrate, fails in their duty of enumerating the causes, departmental inquiry shall be initiated against both of them, is what the directive says. Another thing that has to say is that if you're not also effecting arrest, you have to state your reasons. The police has to state the reasons of why we are not effecting arrest. Then we have to give, it is compulsory to give 41A notice within 2 months, if I'm right, within 2 months of registration of such offense. And only, even when we are effecting arrest after 41A notice, we have to seek the magistrate's permission. So all these safeguards are already there with respect to 498A. I think and this is my opinion as a professional too, all these safeguards, I think make it very foolproof. If we have this law and if we have these safeguards, which none of us violate, because that is an SOP for us now, laid down as an SOP. One more thing that can be added at this moment is the magisterial supervision over the investigation, which I feel is unnecessary, because the SOP with respect to the provisions of law are also very stated, and we are more than expert at applying the Evidence Act and applying the provisions of law. But if there has to be an additional necessary safeguard, we can have a supervision over the investigation of 498 cases by the magistrate. Other than this, I feel all the safeguards that have been introduced so far are foolproof enough to ensure that this very valid, very important, very necessary section in the IPC should not be violated, or should not be abused, or should not be used frivolously. Thank you.
So clear. Any question from our criminal law experts? Yeah, please.
Lalita Kumar, as far as 154 is concerned, is overruled. Is overruled.
It's not overruled. We are still following that.
I think it is overruled. I don't remember the case. I think I read some it is overruled, because preliminary inquiry is not necessary now. But we have to check that. Preliminary inquiry is not required.
In Lalita Kumar only it was decided.
It was decided, but
Yeah.
I think preliminary inquiry is no more required.
It is still certain category of crime. In one of them is matrimonial dispute, commercial dispute, and many other disputes. We need to preliminary inquire there only. Thereafter only you have to register the FIR. In that judgment stage.
No, that is true. It has not been overlooked. It has not been overruled. P is still important.
It is still valid.
There is the CRPC says that when the complainant comes, you have to register. That is the so that is the provision of the law. But Lalita Kumari has said that if you do get an application at the police station level, the maximum time in which you can deliberate upon whether it is a cognizable or a non-cognizable. See, sir, we have to see this entire cognizable and non-cognizable thing from the point of view of colonial history also. There is no other developed country that has this cognizable and non-cognizable offense. So when we are
Yes, we will send it to them. So we will also verify before we finalize for the commission. Any other comment other than what sir told?
No, but as a police officer, you endorse the confirmation.
With respect to Lalita Kumari, yes, yes, yes.
What's the remedy for it?
Remedy for, you said.
For preventing misuse of.
How do you prevent the misuse?
If the case comes in.
Yeah, so we have already said that I acknowledge and I abide. We as law enforcement agencies, we already have an SOP with respect to these judgments that were laid down and the SOP, subsequent SOP that has come up. One more thing that I said that can be added is a magisterial supervision over the investigation. So what we can do is we can quarterly or till the time we file the charge sheet, weekly submission of the reports of how the progress of investigation is happening, what are the evidence that we have gathered so far, and how we are proceeding with the investigation. So we can submit a weekly report to the magistrate.
But I heard you saying that you are not happy with that magisterial supervision. I heard you saying that one.
It's not that I'm not happy, sir. The thing is that 498A, the provisions are clearly mentioned. The evidence that has to be gathered is clearly mentioned. So we know that when there is cruelty that is subjected, that 4-5 types of cruelty that you have to examine. We go and take evidence with respect to that 4 or 5 kinds of cruelty that are there. And we take statements with respect to that. We take evidence with respect to that. And at the end of all this, we still submit a charge sheet. Or we say that there is no case made out in law, and we send a final report. So both these still go to the magistrate, and there is still a provision where the magistrate can refer back the case to us saying that it is inadequate before taking cognizance of it. So these provisions, they being there, having a weekly supervision over it, because it is a special that we are doing, it is overlapping and it is unnecessary at this juncture. Anyway, any which way we are going to a magistrate at the end of the yeah.
It's not humanly feasible jurisdiction.
Yeah, thank you. So one question in your presence, ma'am, we were discussing about that particular section where relationships in the nature of marriage. We have arrived at a kind of discussion. I want to tell the whole house. One is that this provision is 494 IPC, which is relating to bigamous relationship. Now, I gave an example to sir and he got convinced that, let us say there is a couple A and B, and the husband goes secretly and takes another wife in his sense, by marrying in the dark corners of a temple. It's not a marriage in the Hindu marriage sense. There may be a ritual and there is no evidence created, no photograph, no, and he brings the woman home and starts living in some other place. It may be to force this woman to leave him, or it may be to simply for his own choice, he may be doing it. But when they start living together, it's not a marriage, it's a live-in. So this kind of complaint when it comes to Women's Commission, where police have not acted, or police cannot act directly in case of 494. So in such a case, if this provision is giving scope to include live-in relationship within the scope of marriage, then any cruelty including the mental cruelty which is committed because of this, other than becoming ground under personal law for divorce, it can also become a ground for criminal procedure. And as such, the efficacy of criminal law is something that can act as a deterrent to such tendency. So is that okay now? Yes, so it's convincing. Yeah, many times police have expressed their helplessness. I have passed as an activist also, so I know these cases. So thank you. So that's about it. Now we go to one more speaker who is coming from Madhya Pradesh, which is Professor Tapan Mohanty, who is a professor from National Law University of Bhopal. And he is the representative of Vice Chancellor, Professor Vijay Kumar, who is a very senior law professor in the country. So Professor Tapan Mohanty's research is going to be coming across now: maintenance of wives, children, and parents, modification of grounds for Section 125, Clause 4, and 125, Clause 5 to come now. So over to Professor Tapan Mohanty. Sir, please.
Thank you very much. Am I audible?
You are audible, sir. You are very clear. Maybe your volume can increase, and all the onlookers, offline and online, please take note of sir's rich CV there, which Dr. Bindu has already introduced. So over to Professor Tapan.
Thank you very much, Professor Dr. Sasikala Gurpur, ma'am. It was nice and pleasant to see Professor Kusal Bibhuti as well, and Professor Sharma. And thanks to the chair and my friend Rasri and Rasmi Oja, and ladies and gentlemen. I was listening since morning to the rich discourse that we're having in terms of the criminal law amendment. And in fact, long back in 2005, when late Professor Mulchand Sharma was the director then of National Law University, I was given a project to engendering criminal law by the National Commission for Women when Mrs. Purnima Advani was the chairperson. So since then, we have a long association with the National Commission for Women. And in fact, recently, last November, I was a part to that discussion on Maternity Benefit Act. I was the research person there as well. But anyway, leaving that aside, what is interesting to note here, and since all of you are discussing, I put a point in from Madhya Pradesh. Only yesterday, a case has been reported from Madhya Pradesh, where a 55-year-old railway employee has established a physical relationship with a 25-year-old woman. And when the woman raised a problem issue, the man said, okay, I will marry. And he married her in a temple. And later, she came, both stayed together. And after a week or so, the man's wife came and she threw the lady out of the house. And when she approached, as you say now, it was not a case of marriage. And then finally she went to the police and filed a complaint, FIR, on rape. So police is now investigating the matter. It came only as today's newspaper. So there are maybe issues which are less in number, but as society is changing, and that is why I said whether law is actually breaking down the institutions of marriage or family, or it is helping to develop a new jurisprudence that we have to living with changing times. And if you look the issues of law from a jurisprudential perspective, you will find, as sociological jurisprudence say, people like Elric, that it is the social consciousness that makes a foundation of law. On the contrary, it is also the social developmental mechanisms and its evolution also pose both a challenge to law as well as get changed through law also, like institutions like sati and child marriage, etc. So therefore, you find a very symbiotic relationship between law and society. And it is in this context, I say, if you look at whether family is breaking down by the family laws, or it is the marriage is breaking down by marital laws, then we also need to look into these dynamics of law and say this relationship how it is evolving and changing and providing a challenge to that. I'm very glad that NCW is taking up these issues. And I have a very specific mandate, so without diverging from many dimensions, I will try to focus on some of them, but it is impossible to put them in perspective without a background. And that is why I said in today's world, the institutions are breaking down, beginning from a family as the smallest institution in social history to the United Nations. So these are institutional mechanisms that are changing. But then we try to put law only sense, because today also we're discussing whether law can hold afloat the following dimensions of society. Probably no. But I think, as someone say in the literature, that let there be a storm in the sea, tempest in the sea, but I will continue to become a lighthouse. So in that sense, law had to play a defining role. And the three the conditions that I want to discuss in terms of marriage is about the section 125, which talk about maintainability, to maintain, not even maintenance, because maintenance is more in terms of a linguistic than a literary word than that of a legal word here. But however, as you understand commonly, because looking at the principle of interpretations in law, so we need to look at this maintenance and maintainability together, that whether it is a wife, whether it is a child, and whether it is the parents, it becomes necessary, and the person who is in a position to pay must provide the maintenance to them who are otherwise unable to do so. The question here becomes, when there are exceptions to that, particularly when the woman is working, particularly the other exceptions are that when the children are whether legitimate or illegitimate, then also it talks about whether the child is mentally sound or not. And we have discussed about the persons with disability as well. Now, and of course, the same question is also reversed, because whether the person who under whom the charges are made, is he in a position to pay? That's another question. That if he doesn't, what options will have? And I think finances has never been a problem in India, despite many of it. And the reason is simple, that when we are thinking of in 2009 to have this Mahatma Gandhi National Rural Employment Guarantee Act, the government earmarked then 40,000 crores. And there was a debate whether 40,000 crores is there in state cover to do so. And today, even if you make 1,50,000 crores, still government of India can afford to do. But the question is, there must be a political will. And this political will not necessarily comes through instrumentation of law. But there is a possibility that we can think otherwise, because as Professor Sharma was talking about, if there is Waqf board, when Supreme Court made a decision again in Madhya Pradesh, Muhammad Aslam Khan versus Sahabanu, the idea was that maintenance to be paid. But then the government of India reversed that one, saying that it will pay it from the Waqf board's funds, not from the Muhammad Aslam Khan's personal fund. So therefore, we look at these are political, social issues. But I think what is challenging now, or I think why issue is talked about these dimensions, whether it said when a woman decides, that need to be changed. And this is my suggestion number one, that when says if a woman refuses to stay with the husband, then she is not entitled to receive the maintenance money. Now the question is that what are the evidentiary value? What are the reason for that? Even if women refuse to stay with her husband because she feels a threat to her life, which is not documented, which is not based on evidence, but in psychological fear. Now, many of you might have seen a movie called Sleeping with the Enemy. There are the problems with that, where a woman just simply refuses to stay, not because there is actually a threat, but there is a psychological threat to her. Secondly, there is discordance, but yet she is unemployed. But does that mean it's her refusal to stay in the matrimonial home or with her husband is the reason enough to dismiss her petition or application for maintenance? So I think that because today's world, these things are coming more and more. It is not by forcing a woman to stay in her matrimonial home would be a violation of human rights and gender rights as well. So therefore, the reason to say that to get the alimony, she has to be in her matrimonial home, I think it's at current time, it looks absurd. Therefore, we need to look at that. Second question that we talk about, that whether the maintenance should be given from the date of application or from the date of order. I think this choice should be given to the woman, not to this court. And then court also, that only court can verify whether from the date of appeal, from the date of application, whether what was the status of the woman, and after that, that can be verified by the court of law, which is a fact-based one. But it cannot be given to decide the court to decide whether it should be given on the date of order or otherwise state on the date of application. That sort of laxity, that sort of choice to the court, it should not be given to the to court, rather than it should be in law itself. That or it is on the in the request of the woman, the date should be decided, not by the judge concerned. And then the third question is that whether the 1 year period is sufficient. I think ordinarily the 1 year period is sufficient, but we do not know what happens. Look at today. From last 2 years, we are already even having academic discussion we're having online. Now think of a woman who lives in a rural, remote area. How would she would access the court to tell her plight when the courts themselves are online? She may not be computer savvy. She may not have internet connection. So how if it, in 2 more 2 years are gone? And if there is no chance of revoting measures, then how she will do? And clearly conditions on the ground of procedure or application will be ipso facto rejected. That would mean it is not an administration of justice, because we must understand the justice is more important than the procedure itself or the due process. So therefore, due process is only a clause to ensure justice, but we cannot make justice a victim before the procedure.
Sir, if I may interrupt you,
Yeah,
can
please.
we wind up in 1 or 2 minutes? Key
Thank you very much. If you don't like me
recommendations.
speaking, I will wind up now. No issues
No,
there.
no, sir,
It's
no.
okay. It's okay. Yeah.
We
And last
are
point,
trying to.
I will take 1 minute. Fine. I will take only 1 minute.
Thank you, sir.
The last
It's
but
okay.
not least, I want to say this maintainability is only seen when what is the definition of maintenance? I think as we discuss about the best interest of the child in child right custody case, I think it is also to keep in mind the best interest of the woman if she is pregnant, if she is going to mother, or she has a miscarriage. Then all the medical expenses should also be part of maintenance. And then all said and done, provided that husband has the capability to do so. Now, with these short forms, I think, now, of course, I understand when we are too late and then people become hungry, they tell to become angry. I don't want to make you angry by listening to that. And the best way is that influence people by making friends, but making them enemy is by speaking too much. So I think I would leave it here. So thank you very much for giving me a patient hearing and all the things we can note it down. Thank you very much. Good day. Yeah, I rest my case.
Thank you very much, Professor Mohanty. That was such a pertinent kind of point you made and the research that you brought in. Thank you very much. Now, connected to Professor Mohanty's representation, we have our own in-house faculty who is specializing in family law, Professor Yogesh Dharangutti, to come in and talk about possible modifications to be suggested.
I have only 2 suggestions to make over here, and these suggestions came from the class discussion which we had with our students. The first suggestion is coming from the case decided by the Lord Nicholas in 2000. The doctrine is community of property. Particular 125 started in 1973 because personal laws were not able to give the immediate or speedy justice to the victims, right? So we started with that. But now gradually people are not able to get the maintenance because of many reasons. So the female who is spending her time in childbearing, in homemaking and all other things, she should be getting the 50% property from the day when she is married to that particular person. So by that date, she will be able to. This is a self-acquired property. I'm not talking about the property which is the ancestral property. But and again, this community of property should not be a absolute right observed by the court. Discretion of the court should be applied to that. And in at least 90% cases where females are not able to maintain themselves, should be getting the 50% self-acquired property of her husband because she has taken pain for growing that particular, and that should happen. That is one. Second recommendation is coming from the Muslim law. So Muslim law has a unique concept where a person can registered property in a will. So likewise, if we can incorporate something, or law can suggest a specific amount which can be reserved only for the maintenance of wife and the aged parent.
You mean to say testamentary limitation? Yeah.
Limitation to the giving away the entire property without any restriction should not happen, because these people will not get anything. These are the only two suggestions from my side. Thank you.
Very much. Now, yeah.
Clause 4 and clause 5. And after Joseph signed the judgment, are we doing away with 124? I mean, we had.
That's what Mohanty was arguing. Yeah.
So, I mean, it need to be done away with that, right? 124
Yes.
I mean, 4 and 5 both have to be repealed or. Redundant. Yeah. No, it has adultery in any, the other part is that, any other sufficient reason. So that again, the autonomy, the individual autonomy, it needs to be done away with that.
Yeah, but law will look neater and up to date if we do away with that in the light of this judgment, right? Yeah. So, so in the light of that, we would request our senior legal luminary, Justice Ambadas Joshi, sir, the Lokayukt of Goa, to take over, reflecting on two key themes. One is cruelty by husband and relatives under 498A, which under NCRB data is the highest crime committed against women. Highest number of offenses are recorded, and it is escalating year on year. So at the core is this whole idea of marriage and other related cultural mores as well. So here I would request sir to talk about, in the line of what National Commission for Women has asked. One is the scope of this 498A, the amendment in relation to that, the punishment, bailability and compoundability in the light of 243rd Law Commission report, as well as the maintenance related issues which Advocate S.K. Jain had suggested in terms of fund, etc. Sir, you have already contributed, so we may spare that. Mainly under the Prevention of Protection of Women Against Domestic Violence Act, Section 20, computation of maintenance, how it should be compatible with 125(3) in terms of procedures to make it less repetitive, less cumbersome, and more women friendly. The compatibility between the two. This is an issue in Kerala as well. In some judgments I was watching. So I request you to deliberate on that. Thank you, sir. Yeah.
Good evening. The subject as is narrated in the list is 498A in the light of the report, 243rd report of the Law Commission. See, many amongst in attendance, I take it they have read the report, perused it, and therefore there is no point in referring to each of the points contained in the summary of the report. But I have underlined few words in each of the points. They guide and direct us towards what is the feel and focus of the report. I'll only read those underlined words and then let the House come to conclusion as to what should be the recommendation. 19.1, para 19.1, misuse of section 498A. That is the key word in this paragraph. 19.2, creating awareness. 19.3, effort of reconciliation. 19.4, conscious effort to delay the registration of FIR, not as a demerit but as a recommendation. And I know the difficulty which police people will face if they delay the registration of FIR. I have some solution which is practical. I don't know to what extent law commission can further dilate in that. Sorry, women's commission. I'll mention that point. 19.5, make it compoundable. 19.6, it would continue to remain non-bailable, but every unwarranted arrest must be avoided. Again, a very difficult, most greatest puzzle to be faced. Due and necessary steps to ensure and guarantee the safety of the complainant, so also independent custody of the accused. Proper mechanism to be devised for guiding the police department. That was 19.7. 19.8, prevent arbitrary and unnecessary arrest. CWC should be established for adequate training to the personnel. And another is the most difficult job for the government, to create arrangement for lodgement of these victims in the event they are thrown out of their family. Now I want each one sitting here to take a feel as to what was that hounded the minds of the learned, erudite members of the law commission in the background of the statistics which speaks contrary. On one hand, there is a larger number of offenses being registered. Statistically and numerically, the figures is frightening. At the same time, an apex body like law commission notes something which is equally serious and quite adverse to those figures, indicating few things. First thing, offenses are reported fairly departing from the reality. Why it leads to acquittal? One of the reasons is witness has become hostile. The lady feels, repents for whatever has been reported and wants to go back to the family. For a casual anger, something serious has been reported. Therefore, at the cost of repetition, but mentioning, not arguing in detail, an effort to make the family homogeneous right from the pre-marriage age till marriage age, marriage and post-marriage counseling is necessary. Then the value of life, outlook towards money from the husband's family, their counseling, that is equally necessary. The word which I had used was backward integration. It is necessary in this case also. Why there should not be compulsory pre-marriage counseling? This could be misunderstood, but it could be taken up by the community. A big family has now become nuclear family, and there is nobody in the family to counsel them. Our materialistic way of life has added to the cost of life, and the way of extraction is maybe found out in the family of the girl. So some counseling at that stage is imperative. Now, in the light of these recommendations, what do we venture to recommend? It is a serious issue, it's not a simple issue. What do we recommend? In my point of view, in view of Lalita Kumari judgment and even otherwise Justice Swatantra Kumar's full bench judgment of Bombay High Court, after a reasonable pause, as Justice Swatantra Kumar in Bombay High Court judgment had written, after a reasonable pause, it could be an hour to 12 hours, FIR must be registered. Okay, done. What investigation thereafter? Quickest recording of the statement. Madam Gaikwad, I'll mention you for your information. In one sensitive case from Solapur, when I was sitting at Aurangabad, Mumbai, I suggested the police officer that you should not be held responsible for negligence. For that purpose, ensure a statement in the handwriting of the complainant. Let him not later on say that the police officer wrote down some other thing. Let that come in his version, normally which is not required. Because what all that is required is, there is a duty on the complainant to report as nearly as correct, and there is a duty on the police officer to record as accurate as possible. But then he says or she says that my version is distorted by the police. So if the person is literate, have it in his own hand. So officer is not blamed. Thereafter, whoever are the witnesses, explore them as quickly as possible. Alarmingly, offense is very serious. No supervising officer efforts to neglect. So as I mentioned in the morning in some discussion, investigating officer and supervising officer, both should be on their toes for investigation and then a conscious decision whether to arrest or not upon recording note thereof. Therefore, an amendment in relation to the provision for arrest could be suggested, that though it is non-bailable, arrest is imperative. As much is a duty to arrest, as much is a duty not to avoid an arrest which is unwarranted. Now there are reported judgments where FIR is written, 10 accused are mentioned, but no imputation against 6 accused out of 10. Why they should be arrested? It's a risk on the state itself. So where there is no imputation of individual nature, act or omission attributed against an accused, arrest should be made an exception. This could be one of the suggestions which should be incorporated. Now, one thing should be kept in mind in the light of numerous judgments where such a serious offense courts have been granting bail. It is only on facts. So discretion of the court, discretion becomes a widely misunderstood word. It's objectivity. It's not discretion that the court says I will grant bail or I will not grant bail. Documents do not support continued detention, and hence objectively bail is granted. So ensuring that objectivity, some suggestion can be given. Let the House consider, discuss and do it. I think as far as this 498A is concerned, any further and more discussion may not be warranted. However, if some point comes and if I am also enlightened in some discussion, I am open, because as I recollected how many judgments I have delivered on 498A. And most of the times it was absence of evidence, absence of even adequate enough to raise the presumption. In some judgment I have also written that to raise the presumption, some primary evidence was required. Even that was not done. There was no dowry demand or related demand at all proved. So the provision was not attracted. Now coming to section 20 of this Domestic Violence Act, and there is a conjoint question, what to do with the limitation under 125(3). I think that was the focus of question than 20 of Domestic Violence Act. Yes, in my view, this 1 year could be extended to 2 years. There is a basic reason for that. No lady, Indian lady, would hasten to quickly go to court. She would delay, try to find out a solution. She is driven out, still she will think twice. One of the members in the audience had mentioned about the lawyer's cost. I understand it. For habeas corpus, I wanted to offer that, come on, I can give you 10 lawyers at any bench who are willing to work amicus, pro bono. But I don't know whether in 125 they will be available. But then legal service authority is the best fora available, where the person can go and say that I want to file a petition for maintenance and there would be no difficulty. Yet, going to a lawyer itself is a calamity for the litigant. I know one of my very good friends of my college days, he searched another 3 friends to contact me, that he wanted to entrust his case service matter. People are really scared going to lawyer. Therefore, this 125(3) should definitely be amended, and this 1 year could be extended to any long period. Only question is how long you will keep on arresting him for every accumulated amount of maintenance. And this is a general question which is always guiding factor of deciding the period of limitation. In the process of teaching or illustration, I used to tell the people, why is the period decided? A civil appeal in district court 30 days. In High Court 90 days. Under workmen's compensation 60 days. Under civil law 90 days. For defamation 1 year. For mortgage 30 years. This limitation is decided on the type of evidence that you require. It banks upon the memory, that banks upon the perishability of cause of action. Therefore, here the recovery may not be possible, multiple arrests may not be possible, but barring the claim ought not be done. Ultimately, it is based on resource. If the person does not have resource, no law on this earth can put somebody behind the bars. Now, as far as making section 20 more effective, it could be read, unlike 125 CRPC, to be comparable with right of maintenance in civil law. The woman would be entitled to maintenance of her normal status and status of women in the family of husband. And this formula could be argued, and for that purpose, amendment may not be necessary in my view. However, a clarifying amendment, amount of maintenance corresponding to the status of the members of the family of the husband could be added. This is my suggestion. If some points come for discussion, we can proceed to discuss. I think on the points given to me, whatever I have addressed could be sufficient. I had kept the sections ready with me in my mobile, but I don't think those are required to be referred. Thank you.
Thank you very much, Justice Joshi, sir. So that brings us to the end of all the deliberations. We have covered everything, although we have gone past the schedule. Some minutes are thanks to the lunch and a little late start in the morning. But however, we have finished discussing all the issues, and our learned house has brought out many dimensions which we never thought when we were designing this deliberation. So thank you all quickly. And I would... yeah, any points on any of these issues as enforcement authority, especially
With respect to 498A? I was taking notes. I have gone through many judgments, and I have very, very high regard. So one of the things that sir has drawn out, and which I take as a learning lesson, is the absence of evidence and no evidence to attract presumption. So at my level, whatever sir has suggested with respect to this, we will definitely convey this to my unit commander, and about this, we will see to it that all the lacunae with respect to investigation are addressed as soon as possible. With respect to recording witnesses, having the complainant state the FIR, in my jurisdiction, sir, I say this with a lot of responsibility when I say that I insist that the ladies coming to us, they write their own complaint, and I take it in writing from them that माझी जी complaint मी लेखी दिलेली आहे तीच माझी complaint समजण्यात यावी. So verbatim, sir.
Trial lawyer, though I did trial lawyering for a very short period, but and I use this language which I am now using in the training of the prosecutors. I made a statement that is very funny. It's funny and of course meaningful. I told that I never trained a witness to appear before the court. I have never tutored the witness, but sorry, tutored is the correct word I want to say. And then I told that, but I never took an untrained witness to the court. What does it mean? It means that I never tutored it, but I always started directly cross-examining my witness. Then I always made the witnesses to feel the temperature in the court hall. I am using the same words which I used to give. Come and sit in the court, see how the judge behaves, how the lawyers behave, how they question. And after his 2, 3 days, 4 days sitting in the court, on 5th day, I will take him in the witness box. This practice I used to adopt. So whenever a complainant comes, in your absence only, I told, police question the complainant severely and rightly so. No objection in that. Maybe he is frightened, cool him down. As I said, offer a cup of tea, coffee. If required, I have seen a police personnel offering a blanket to a complainant. He took out his own blanket and put it on the complainant, said, sit down for 5 minutes, warm up, and then I'll talk to you. So first settle him, then sternly cross-examine him, because people are not trained even to reveal the truth the way that it has occurred. In the life, you are very reckless. त्याला विचारलं मराठीमध्ये, most people understand मराठी. का रे सकाळी जेवला का? तो म्हणजे काल मी काकाकडे जेवलो होतो. अरे बाबा तुला आजचं विचारलंय. People are so reckless in their life that they have not cultivated the habit the way Sherlock Holmes does detective logic. त्यामुळं person coming to file a complaint is to be interrogated, made to explore, to be given a training, give a sheet of paper to write down, note down, rearrange them clockwise, time-wise, and thereafter write a complaint. As taking instructions, I had prepared a note for lawyers, a full 6 pages sheet. How do you take instructions? Write them sequence-wise, time-wise. Then rearrange them because you don't remember whatever has happened. Therefore, whenever a complainant comes, settle he or she, grill, not to frighten and insult and run away, but to explore her or his own story and then write it down. And for this purpose, you may probably have to train your officers. Please do that.
Yes. Another suggestion that we have as long as we prolongate the process of lodging of FIR, I would like to bring to notice the procedures that are followed. What we have done here is we have established a process set where every complaint of 498A that comes to the police station is referred to this process cell. Where there is the husband and the wife and the parents go through an elaborate session of counseling. There are legal experts there. There are counselors, and only after the deliberations of these counseling sessions and upon a report where they say that reconciliation is not possible, do we go ahead and lodge the FIR. So the intention here is not to make the woman here, in any way change her mind, but it is an intention is here to sort of give them a pause, as sir had said, to reconsider everything that has gone wrong and give them a pause and give them an opportunity to maybe correct that wrong. And again, at the process cell, sir, there is an overwhelming incidence of irreconciliation coming at the end of this deliberation. So it's not that all the deliberations that happen there or counseling sessions that happen there do not result in 498 being registered. In fact, it is the other way around. We have overwhelming recommendations from the process cell where they say that there can be no reconciliation and hence 498. But it is a very important pause, as you had said, with respect to this entire edifice of this marriage, the social thing that we have. So this thing, sir, that the complainant should state in the FIR is a very, very valid suggestion. And in fact, it can be taken up as a one of the safeguards when we suggest any recommendations or the thing to 498A, where we can say that the complainant herself should give in writing whatever she has to say, and the police is bound to register that as a complaint. It is a very valid suggestion. Thank you, sir.
Thank you very much. In a hurry, now we need to wind up because people have to leave for Mumbai. Then Praveen's flight is due. So I call upon Ms. Lasya to take over and finish the procedures. Yeah, thank you.
Thank you very much, ma'am. We've had once again several questions. The poll for the last questions that we have discussed is on. So the results of all the polls will be registered and consolidated into our report. There were certain questions that came up for the members, resource persons. So because of paucity of time, we will just take one question that was specifically for the NCW member, Mr. Praveen Singh. The question was that shelters and support systems instituted by the government have historically required regular mechanisms that oversee and inspect the standard quality of life assured by the shelters, support systems, etc. So how would this oversight mechanism be tackled in light of issues such as marital rape, which heavily involve elements of psychological trauma inflicted on the victims?
Regarding shelter home, we, as a NCW, we generally visit the shelter home regularly, and we keep giving recommendation to the state government, to the district governments for the improvement of the shelter home. For the marital rape, it's in the matter is the sub judice, so let them decide it. Right now, we cannot comment legally about on that point of things. Okay.
All right, thank you, sir. So because of the paucity of time, we will be moving forward to the concluding ceremony, and I would like to invite Dr. Aparajita Mohanty ma'am, Deputy Director Academics of Symbiosis School, Pune, to kindly deliver the vote of thanks.
Here to give a formal As I stand here to give a formal vote of thanks, I am indeed humbled by the august presence of stalwarts from academia, lawyers, representatives from NGOs, helplines. Each esteemed resource person has deliberated on the assigned topics in the most profound manner, and I'm sure it will go a long way in shaping the outcome document that will be submitted to NCW. Thank you, madam, and sir, for consenting to be a part of this exercise, which I'm sure that it will bring about the expected reforms. I place on record a formal note of gratitude and thanks to all the resource persons for the event. Honorable Justice Ambadas Joshi, Sir, Lokayukta Goa, Professor KVS Sarma, Chancellor MNLU Aurangabad, Dr. Purvi Pokhriyal, Dean School of Law, NFSU, Dr. Rashmi Oza, Principal Chembur Karnataka College of Law, Dr. K.I. Bibute, Sir, Director, Amity Law School, Mumbai, Advocate S.K. Jain, Advocate Puneet Vasin, Cyber Law and Crime expert, Dr. Sanjay Jain, Principal, ILS Law College, Pune, Rajashri Varadi, Professor and former Head, Department of Law, University of Mumbai, Ms. Purnima Gaikwad, Deputy Commissioner, Police, Pune Zone 2, Zone 3, I'm sorry, Ms. Anuradha Sahasrabudhe, Director, Childline, Advocate Uday Varun Zikar, Professor Tapan R. Mohanty, NLIU Bhopal, Dr. Atmaram Shelke, Dr. Girish Abhankar, Professor Yogesh Dharanguti. A special note of thanks to Sister Lucy from Maher for consenting to attend the function. I also extend a special note of thanks to Professor Ranjit Thomas from National Law School, Jodhpur. We thank NCW for collaborating with Symbiosis Law School, Pune. Thank you, Mr. Praveen, for being with us from yesterday and rendering the requisite guidance. I thank the management of Symbiosis, the Honorable Chancellor, Dr. S.B. Muzumdar, sir, Honorable Pro-Chancellor, Dr. Vidya Yoradekar, Madam, and Honorable VC, Dr. Rajini Gupte, for their support to all our academic and co-curricular activities. I thank Dr. Shashikala Gurpur, Dean, Faculty of Law, Symbiosis Law Symbiosis International University and Director, Symbiosis Law School, Pune, for moderating the session and steering it in a very efficient and effective manner. Madam, without your able guidance, an event of this measure and stature wouldn't have been successfully conducted. Thank you, ma'am, for your vision and support. I thank the organizing committee headed by Dr. Bindu Ronald, Dr. Atmaram Shelke, and Professor Lasya, who have very meticulously planned every detail with regard to the event. I thank the faculty for their wholehearted cooperation in executing it. I thank IT team for providing the technical support. I thank the student volunteers who have assisted us in executing the event. I also thank Sonar sir, our office superintendent, and his team for providing the logistical support. Last but not the least, I thank all the students, including the members of SA Student Advisory Board for attending the regional consultation. I'm sure each student must have had something or other to take away from this wonderful exercise. I thank you for attending the regional consultation. Thank you all.
We will now end with the national anthem. So I request all the dignitaries and participants online as well to stand for the national anthem.
पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे जन गण मन
Thank you to one and all.